Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Today is Thursday, February 5th of 2026. And thank you so much for indulging me yesterday. I couldn't even get out of bed. I could not get out of bed. And I'm here. I'm not feeling 100, but I'm here. Good enough. I'm feeling good enough. Feeling well enough to get back to this because I did try and watch some of it yesterday in my haze. And boy, the Twilight Zone emojis are going to be put to good work today. Let me just say that. Wow. You know, there's a lot of things that made me want to become a lawyer. Number one is because I love to argue. And so I was always arguing growing up. And my mother just could never win an argument with me. And she's like, you're going to be a lawyer. I just know it. And I was like, no, I want to be an actress. And she's like, okay, whatever. And I did wind up going to law school because I did want to be an actor when I was a kid. And then I realized I could still use all my skills for acting and have a jury. And they could be my audience. And nobody could reject me. And I couldn't not get the part because I could write my own script and have a locked in audience, right? And it's all the same skills. But also there are some books that I read as a kid that really made me want to become a lawyer. One of which I always have right behind me underneath, see the lady, the Scales of Justice back there behind my YouTube silver plaque. I pulled it out for you because here it is. Harper Lee's To Kill a Mockingbird. This is one of the books that I read as a kid that made me want to become a lawyer. And let me tell you, are we watching a modern day To Kill a Mockingbird? Anyone? Bueller? Anyone? Yesterday, I watched at least 2 or 3 witnesses come on the stand to talk about a guy that was suspicious because he was black. And he was walking down the street at 8 o'clock in the morning, and he seemed very awake. Was I in and out of a haze, or was that the testimony that we watched? Or that some of you may have watched yesterday? Maybe you waited for me. I'm not sure. Oh, your daughter's name is Harper Scout. I love that for you. I love that. Harper was one of my choices too, and Scout was too. And then I decided on some other names. And look, my grandson's name is Atticus, right? Is it just me, or do I feel like we're watching a modern day To Kill a Mockingbird? What is going on? First, we got to pull our affirmation for a badass. But then what I want to do, it was said with zero shame, but I think some of the people now are trying to walk it back. Hold on. Thank you. Thanks, Carrie said I read all the paper. The way they got his DNA was egregious. Yeah. Did you send me that email? Somebody sent me that email. And I have to just verify it. And I think it was you saying that they stalked him to pull him over for anything. And that that's how they wound up getting his DNA. However, he was convicted. He pled guilty to something involving a stabbing. Here's the thing, and I don't think the jury's going to hear about it because I fell into the rabbit hole, as I do. Call me Alice. We have an emoji for me. He's got a record. Edrick Faust has a record. I don't know that the jury's going to hear about it, but he did plead guilty to I think there was an incident involving a knife right around the same time as this in 2001, right? You guys know more than me, some of you do. And so it makes me think, oh, did they need a patsy? So they had to find a guy who committed an offense with a knife around the same time. Because remember, this guy, Edrick Faust, was never even in the court file until 2023 or 2024. Is he a convenient patsy? I mean, the way that these people were calling the police just because they saw a black man walking down the street in an orange, maybe it was a hoodie, maybe it was a shirt, maybe it was red, maybe it was orange, to the point where they made police sketches back in 2001. And then he was never, ever mentioned again until 2023. What are we doing? Was it just me? Because that's what I felt like. Yeah, no, just because someone has a record doesn't mean that they're guilty of this particular crime. Here's another thing I noticed when I looked in the court docket. There are a lot of traffic offenses and things like that. They want to bring in some offenses of his from more than 10 years ago. Guess who the judge has been on many of Edrick Faust's prior cases? Yeah, it's a lot, but he's been in front of her before. And does it make more sense to you now that she's got a little bit of a chip on her shoulder about this defendant? Yeah, I'll pull it up for you later. The thing I want to do first is I want to go back to Ashley's testimony, which is the last testimony from yesterday. Ashley was one of the roommates, and I want us to start because she's coming back today. So I thought what we could do is, since we're going to recap day 3 probably over the weekend, because it needs recapping, is recapping or kneecapping? I said recapping. Okay. Let's go back. I'm gonna put it on 1.5 speed because I realized that, and this is no shade to my friends in the South at all. I speak very fast. I am a New Yorker. I'm like, I got places to go, things to do. I'm a fast talker. If you know Seinfeld, you know I'm a fast talker. Their cadence is a little bit slower in the South, so we can put it on 1.5 speed and get through it while we listen to Ashley. And listen, I feel bad for Ashley. She's in a tough position. This is her roommate. This was her bestie, according to her, her best friend. And I'm sure she wants to do everything she can to help the family find closure and get a conviction. But justice for Tara, and I say this, and I feel like I say this in every case like a broken record, justice for Tara is not incarcerating the wrong person. Justice for Tara is about finding the person who murdered her and incarcerating them. And my heart went out. I'm the Lorelei of New York. I'll allow it, Zibby. I will totally allow it. I love Gilmore Girls. If that's what you're referring to. My heart, Ahmad Cruz is my young spirit animal. He is so passionate. He's such an empath, and you can feel that. And the way that he yesterday said things like, it was my dream to become a lawyer. It was my dream to become a lawyer. I couldn't wait to become a lawyer and come into court every day and fight for my clients. And now, after this trial, he said something like, he almost said, it almost felt like he was going to say, I don't even want to come back anymore. I just want to quit. And it broke my heart, because that is the way every young lawyer feels. You know, you feel like you're putting on this gladiator costume and you're going to go out there and you're going to save the world, right? And you're going to help the innocent prove their innocence. And I feel like he really, really, really believes that his client is innocent, and he's doing everything in his power. And he is being hamstrung. He is. Now, listen, he's a little bit young. All right, John. Bye-bye. Bye-bye. I mean, it's amazing to me how the trolls will wait 48 hours to just come in and be a jerk. It's amazing. Yeah, he joined 7 days ago. Brittany, say goodbye. Say goodbye. Just here to torture me. It's what they do. Because John O'Keefe was not hit by a car in a car. Justice for Tara. And I feel like he's young, right? And a lot of times you have to get thrown into the fire because it is difficult. It looks easy. If you guys watch a lot of trials, it looks easy to impeach a witness. It looks easy to, try and get in a prior inconsistent statement. It's not. There's procedural things that need to be done before it's allowed. But I also feel like the prosecution opened the door with this witness, Ashley. They opened the door when they started asking her about things. He said, I'm handcuffed. He did. He also said hamstrung the day before, I think, right? I feel like he is. He's gaining his bearings. He's awesome. He has the potential for greatness. And it's not easy, right? But also, there are judges who will show you a little bit of grace and they will try and help you. And then there are DAs like this guy, Yaman Shilly, I think that's his name, Yaman Shilly, who will do everything they can to make you look like a fool on national television. I'm the kind of person who likes to root for the underdog, and I think I think maybe the jury might feel that way too, and might feel like not only is this defendant being railroaded, but his lawyer's being railroaded too, and they may not like it. And I would love to know, I look so tired. Let me just say that telling someone that they look tired is not a compliment. That is probably the biggest insult that you could say. I know, I am tired. I've been sick for days. And that distracts me. And I forgot what I was going to say. Anyway, let's do our affirmation for a badass. Please don't tell me I look tired. Please don't tell any woman that they look tired. It's not a compliment. Obviously, I'm tired. I haven't slept. I couldn't breathe for 3 days. All right, here we go. Here's our affirmation for a badass. And oh yes, this Elaine said this something is the JC of the courtroom. This prosecutor is the JC of the court. Yeah, Elaine, I think you're right. Oh, I got something, but it's downstairs. I'm going to show it to you later. Okay, here you go. Here it is. Here's your affirmation for a badass today. Thank you, James. Thank you for your compliment. See, that's much nicer. I am effing powerful. There it is. I'm effing powerful. You are effing powerful. If this is your affirmation that you need to hear today, sometimes we need to hear it. And I love that you missed me. Thank you so much for missing me. And once you get out there and you have to survive in the world of the other chats that are not your favorite law tubers, you can tell a lot about a channel by the way their chat operates and what's allowed to be said in their chat. And we don't allow it here because my mods rule with an iron fist. And there's a reason for that, because people feel safe here. I know I sound better, but I feel good. I feel good. Thank you, Mitchell. Thank you, Mo. I appreciate it. So I think that let's do that. How many of you, well, it doesn't matter. I'm going to do it anyway. I'm going to do it my way, executive decision. We're not going to recap entire day 3 today. We're going to go back. We're going to watch Ashley, the testimony of the roommate. We're going to see some difficulties that Mr. Cruz had getting in some of the testimony and whether I think it was legit. And I'm sure you have a lot of questions. And this is from day 3. So let me put the banner up. There are extensive show notes below this video. If you're not familiar with the case at all, they are below. This is a 25-year-old murder case. 25-year-old murder case. Tara Baker was a 23-year-old first-year law student at the University of Georgia when she was brutally murdered. Brutally murdered. She was stabbed, strangled with a printer cord, a cord from a printer back in 2001. And then the house was set on fire with an Afghan that was put on top of an electric stove. There was a neighbor who testified yesterday that he smelled smoke sometime around 8:45 in the morning, but the call to the fire department did not come into the fire department until I think it was 11:22 a.m. And it was said in opening that because there was smoke in the lungs of poor Tara Baker, she was alive when the house was set on fire. It is tragic. It is horrific. The defense is pointing to her ex-boyfriend or her boyfriend at the time. It's not even sure. We're not sure if they're broken up because that's not what Ashley says. His name is Chris Melton. He's going to come in to testify. He's the third-party culprit here, and that we're going to hear Mr. Cruz say, absolutely, that is who they're pointing the finger at. So here we go. This is again from yesterday. If it seems a little fast, it's because it is. It's on 1.5 speed, but the good thing is that we get captions on replay. And this is channel 11. I went back to Law and Crime. I was in the middle of watching it and I went back to it and they took their entire video down from yesterday. And I think the reason is because I think it was the first witness of the day, the woman who came in with an oxygen tank. I think they totally doxed her social security number and date of birth. And I couldn't believe it when I heard it. I was like, what are you doing? And then I think that's why they took it down. I'm not quite sure, but I hope that's why, because yeah, I think so too, right? All right, here we go. We're at 1.5 speed. This is Ashley, Tara's roommate from yesterday. Let me know that you can hear it okay.
And if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And I just need to make sure that you're speaking loudly enough into that microphone so that we can hear you, okay?
Okay, is that better?
Yes. Ma'am, could you state and spell your name for the record, please?
Yes, it's Ashley Hall, ASHLEY HALL.
And where do you live, ma'am?
Pendicula.
I'm going to ask you about your relationship with the deceased in this case, Tara Baker. How did you meet Tara?
We were in the same sorority at Georgia College in Milledgeville, and then we ended up living together in the sorority house for a couple years. We both came to Georgia and ended up living together here as well.
Can you describe, in general terms, your friendship with Tara?
We were extremely close. Pretty much once we met, that was became a little bit inseparable. And then when we both came here I was doing my graduate studies and she was in law school. We were living together. Of course, we just didn't have as much time together, but we were still very close.
What kind of friend was she?
Wonderful friend, sweet person, always nice to everybody, always up for anything. Very Southern Belle, very someone that was very into her family. Like I felt like her siblings were my siblings. A lot of time I knew everything about them, all about her mother, how wonderful she was. She knew my family pretty much about the same. She's very black and white. She knew right and wrong. There's no gray with Tara. Like this is what you're supposed to do. This is how you treat people. Fantastic person overall. And I know people say that about a lot of people, but she really was just pure of heart, just a great person.
She's a talker. Ashley's a talker. Sometimes you let them keep talking and they give you so much more information. Black and white. Everything was black and white. There was no gray with Tara. She was a Southern Belle. Yeah, we're going to watch that too. Yes, we are. We're going to watch this and then we're going to go to day 4.
Take you back to August of 2000.
Okay.
And did you and Tara and Valerie Lowe all move in together?
Correct.
And how did the three of you come to decide to live as roommates?
Well, I met Valerie through the equestrian team at UGA. We both rode on the team. And then Tara came in '99 to work for the law firm. And unfortunately, I'd already signed a lease, so we couldn't live together that year. So we made sure we were together the next year. And she got along with Valerie fine. And we were just very similar personality types, how we were raised, just both. Yeah, it turned out to be a great roommate situation. So
Where did y'all move into in August of 2000?
Fawn Drive.
In that time, starting in August of 2000, did all of you have boyfriends?
We did, yes. I was dating my now husband, Chris Hall. Valerie was with Jeff Hall, and then Tara was Chris Melton. We thought it was funny because we had 2 Chris's and 2 Halls in that whole.
2 Chris's and 2 Halls. 2 Chris's and 2 Halls. Thank you, Gen X 1968, for gifting 5.
Let's
Let's talk a little bit about Tara and Chris.
Okay.
You recall how they met?
At Georgia College, mutual friends. He actually was a cheerleader at Georgia College, and my brother was a cheerleader. And it's kind of just small school. You meet through that way. So,
over the course of your friendship with Tara at Georgia College, up through and including moving into 160 Fawn Drive with her, did you have an opportunity to see her relationship with Chris?
yes, we attended sorority functions all together. We went camping together. We went on trips together. Just hung out together. So definitely immersed in their relationship.
In that fall semester, so starting in August of 2000, where was Chris living at that time?
He was living Jamestown Apartments, I believe it was, with Chase Guerin.
Is that here in Athens?
That's in Athens, yes, I'm sorry.
Do you remember where in Athens that is?
The Jamestown, right off of Millage, I believe.
Can you describe for the jury kind of what at least inside y'all's house at 160 Fawn Drive, what that fall semester was like?
Oh, well, I was starting my graduate studies. Tara was starting her law studies. Valerie was finishing her undergrad, and she was starting her grad studies the next semester, but it was busy. I mean, we were kind of passing each other, or we're just studying at all times. And then we had our boyfriends on weekends. We either would do something with the boyfriends, or we'd do stuff together too. But it was just that time of your life where you weren't getting any sleep and you were studying and, just living your life. So.
Do you recall during that fall semester occasions where Tara would spend the night over at Chris's apartment? Do you also remember occasions when Chris would spend the night at 160 Fawn Drive?
Not as much. It was mainly over there. So.
Moving forward a little bit to the start of the spring semester, did you notice any change in Tara as it related to her relationship with her studies?
She was really buckled down. She was stressed with school. This UGA law school, it was a tough department. I think Chris ended up moving back with his parents more, so they just couldn't see each other as much. And so mainly just really buckling down with school.
You mentioned Chris had moved back in with his parents. Do you know why?
He was helping his father. He was a plumber, and he just started working more full time. So was starting his career and trying to go off on his own a little bit. He just was busy, and it just made more sense for him to work from there versus driving an hour to his work sites.
Where did Chris live?
Loganville.
Wait, I mapped it. Loganville to Athens is like 45 minutes to an hour away. So, they're a little bit long distance. Yellow Ledbetter, she's definitely on team talking too much. You know what Kathy would say from Gossip Rumor and Innuendo? She failed shut up classes.
Do you recall a time when Chris gave Tara a Christmas present that year?
Okay.
Do you remember that?
No.
You're right. That is so weird. I just noticed that the captions have completely different things on them. Okay, let's take them down. It's like, what's going to happen after this? That's so weird.
He gave her maybe a piece of furniture or something, or.
And without going into anything that Tara may have told you, did you get an impression as to her reaction to that gift? Does that question make sense?
Oh, anything he would give her, she was over the moon about. She just liked anyone to think of her. So usually if you just give her, you could have given her, I would draw a little picture sometimes when I was bored at work, and she would hang them on her wall. That's just, she just liked anyone to think of her. So anything he gave her would have been wonderful to her. So.
Turning to Thursday, January the 18th.
I have a feeling he wanted something more out of that, about a gift that he gave her for Christmas. What was the gift? She doesn't know. She didn't really take the bait on that. I feel like he wanted to make a point that that wasn't made. This is prosecutor.
Were you at the house at 160 Fawn Drive that afternoon?
Yes.
Were you heading out of town that weekend?
I was. My class for Friday was canceled, so my boyfriend was going to Georgia State and ended up going to see him.
Do you recall being at home with Tara that?
Yes, we had a long conversation because with her birthday coming up, I actually had a horse show that weekend, so I couldn't go to her party. And so we were talking about what we were going to do to celebrate later for her birthday. And then we're just catching up on everything for the week, since it was rare for us just to have time to sit and talk.
So you mentioned the birthday. Do you remember what she was going to do?
I think go to a couple different places downtown Athens with her law friends and some people she used to work with.
Did she seem excited?
Oh, she was thrilled. Yeah, I hated I was missing it. That was going to be, she was very excited.
Do you recall Tara talking to anyone on the phone that afternoon?
I think she and Chris talked on the phone, but they talked about every day.
If you know, was Chris planning on coming in town that weekend?
I don't remember if he could make the party, but I know he was coming in town and they were doing something for the birthday.
Objection, hearsay.
All right, any response to the objection?
I didn't ask to elicit any statements by anyone. I just asked if you did.
It's implicit hearsay.
I'm going to sustain the objection.
Of course she is.
Did Tara appear excited about the weekend's plans?
Yes, she was extremely excited about the weekend plans. And she was excited about seeing Chris.
Let's talk a little bit about Tara's morning routine. What do you recall about that?
She was pretty much a creature of habit. Shower in the morning, she'll go eat breakfast. She'd always have 2 bags of cheese grits.
Grits.
Because I like cheese grits too, and that was a bonding moment. Eat her grits and then go finish getting ready. She had really thick hair, so it took her forever to blow dry her hair. So usually she'll sit on the floor and flip her head over and blow dry her hair.
You went through that all really quick.
Sorry,
really fast.
I'm sorry. Yeah.
And so I'm going to ask you to kind of break that down
Okay.
one at a time. How would Tara start her day?
Shower.
And what would she then do next?
She would go make her breakfast.
And where would she go to make the breakfast?
Well, she'll go to the kitchen to make the breakfast, and then she'll probably sit on the sofa and eat it.
And at that time, after eating her breakfast, is that when she would go back?
Go back in her room and finish getting ready. Yes.
You indicated that part of that included blow drying her.
Yes. She had a lot of really thick hair, and so she would have to usually sit on the floor because she would get tired of standing up. And we've lived together since my freshman year, so it was kind of a joke. Her sitting down on the floor, flipping her head over, doing her hair all the time. So.
What time would she start her day?
Depending on the class, if she had an early class, she'd like a 9:30, probably 6:30, 7:30. She liked to get everything ready and then study for whatever classes she had that day.
So that would kind of start that routine?
Yes.
Depending on what time the first class was?
Yes.
I mean, it's just so crazy. She had so much hair, right? So much hair she had, and the hair that was in her hand, that was Caucasian hair, is all of a sudden missing from the envelope, as are the other 2 Caucasian hairs in the envelopes.
In kind of the last months of her life, had you noticed anything significant about Tara's relationship with Chris?
Well, I mean, I think she was frustrated they couldn't see each other as much. Of course, with her schedule and his schedule now working full time, like every girl, she wanted her boyfriend to give her a little bit more attention. But I mean, I think I had the exact same complaint about my boyfriend at the time. So it was normal conversations you have with your friend about their relationship. Nothing off or nothing that would have caused me to be alarmed in any way.
You feel like your relationship with Tara that you just described over the course of this afternoon, you would have recognized if there were...
Oh, yes. Yeah. Like I said, Tara's very black and white. Like, we're not ones to share, like, maybe the little minute intimate, but we definitely knew what was going on in each other's lives. I mean, and if something was happening with Chris, since she knew I knew him and our relationship was what it was, she would have told me.
Ashley, or Ms. Hall, I'm sorry.
Yes, sir.
I believe I have a motion, Your Honor.
All right. I'm going to send the jury out. If you'll have a moment in the jury room and don't discuss the case. Thank you.
Just making sure. Yeah.
I had to step away for a second, so let me just take that back a moment.
This afternoon, you would have recognized if there were...
Oh, yes. Nothing off or nothing that would have caused me to be alarmed in any way.
You feel like your relationship with Tara that you just described over the course of this afternoon, you would have recognized if there were...
Oh, yes. Yeah. Like I said, Tara's very black and white. Like, we're not ones to share, like, maybe the little minute intimate, but we definitely knew what was going on in each other's lives. I mean, and if something was happening with Chris, since she knew I knew him and our relationship was what it was, she would have told me.
Yeah, or maybe she wouldn't have told you because you are friends with Chris. And here's what she just said. She would not tell me the minute details of her life, right? But she would tell me in general if something was wrong. Okay, this is where I'm having a problem with this judge. I'm going to take that back again. I'm going to let you hear what she said again because she's opening the door. In my opinion, this witness has now opened the door about things that Tara told her about her relationship with Chris. And it doesn't necessarily go to their sex life, right? It goes to their relationship. And so if you're going to open the door into their relationship with this witness, then he should be allowed to continue the questioning, right? Okay, let's hear that again from the top.
Ready. She had really thick hair, so it took her forever to blow dry.
Yeah,
Sorry.
so
I'm sorry.
thick.
Yeah.
How would Tara start her day
So
after eating? That included blow dry.
she had an early class shoot last.
In kind of the last months of her life, had you noticed anything significant about Tara's relationship with Chris?
Right.
What? I mean,
Did you notice anything significant about her relationship with Chris? You can't use it as a shield and a sword. You can't use this witness to say, well, I'm going to ask her all about the relationship with Chris. And then she's going to say, well, you know, she would have told me everything, but not everything. She would have told me some things, but maybe not everything. Right? I agree. This is exactly what I was going to say, Brittany. In my opinion, if Tara was seeing anybody else, this girl would not know about it. She was too close to Chris. Right. So I'm going to slow it to regular speed now, because that was only at 1 1/4, because 1 1/2 was a little bit fast. Let's hear what she says. And in my opinion, he kicked the door in. Here you go.
I think she was frustrated they couldn't see each other as much. Of course, with her schedule and his schedule now working full time, like every girl, she wanted her boyfriend to give her a little bit more attention. But I mean, I think I had the exact same complaint about my boyfriend at the time. So it was normal conversations you have with your friend about their relationship. Nothing off or nothing that would have caused me to be alarmed in any way.
You feel like your relationship with Tara that you just described over the course of this afternoon, you would have recognized if there were...
Oh, yes. Yeah. Like I said, Tara's very black and white. Like, we're not ones to share, like, maybe the little minute intimate, but we definitely knew what was going on.
We're not ones to share the little minute intimate details, right?
Other's lives. I mean, that was, and if something was happening with Chris, since she knew I knew him and our relationship was what it was, she would have told me.
She would have told me. Maybe, maybe not. That's your opinion. I think this opens the door for Mr. Cruz to be able to get into this. It's not the way the judge is going to feel, but let's keep watching.
Ashley, or Ms. Hall, I'm sorry.
Yes, sir.
She's looking over at the defense table as if Mr. Cruz is standing up because he's got an objection. He probably does.
I believe I have a motion, Your Honor.
All right. I'm going to send the jury out. If you'll have a moment in the jury room and don't discuss the case. Thank you.
We can skip a little bit.
Yes, ma'am, and I'd just like to fit the bases on the record. As the Honorable Court is aware, Mr. Faust has a restriction on his line of questioning that he could ask witnesses in regards to statements that Ms. Baker may have made to said witnesses. During the state's examination of Mrs. P.V. Hall,
Great question. And the answer is no. I have never seen a witness be allowed to sit through motion arguments like this. I don't know if they do it differently in Georgia. The problem here is that the witness is sitting there listening to the argument. And so now, therefore, she's smart enough to know how to change her testimony to fit with whatever the judge is going to say she's allowed to say and not allowed to say. This is wild to me. I don't know if it's a Georgia thing, but the witness should be, either they should be at sidebar or the witness should be taken out of the room. I don't know. It's bizarre to me.
there's been intimations of, well, and I'll say what the exact statement was, that if something was going on, she would have told me. Well, we have evidence to the contrary, but as of right now, we can't confront that statement because of the Honorable Court's ruling. So before I move further with our motion, I would ask, would the Honorable Court reconsider its ruling in regards to our residual hearsay motion with the statements that we have that Ms. Baker shared through Ms. Ashley Peavy?
All right, thank you.
You guys are telling me that in YSL and other cases in Georgia, they do not do that. Ashley, to my knowledge, is still sitting on the witness stand, and they are very proper in Georgia. They don't call her Ashley. They're like Ms. this, Ms. that. And it's confusing because she had a different name at the time of the incident, and now she has a different name. And so I wish that I just call her Ashley on my scroll. Ashley.
Mr. Bolden, Mr. Yeoman, would you care to respond to the motion?
is asking the court to reconsider its ruling on our 607 before we move forward with any other motion. Our residual hearsay motion. 807, excuse me.
Your Honor, to the extent that the state has asked Ms. Hall to testify about anything that Tara may have said, I understood the court's admonition the first time and have intentionally stayed away from that. I don't think that I have failed to, or I've elicited any testimony that would, violate the rule that requires notification. So I don't know exactly what Mr. Cruz is asking.
All right, thank you. So first of all, your request for a reconsideration of a prior ruling is not properly brought in this manner. That's not an objection. And I think you're misinterpreting my prior order. And so I think it would be imperative, Mr. Cruz, to go back and review what my orders were about. If you want to file a motion to reconsider, you certainly may do that, and I will consider whether it is timely and whether I should take it up. But I think your interpretation of the court's order is not accurate.
It is accurate, Your Honor. The order that you
I'm
got.
not going to argue with you, Mr. Cruz. I have made my ruling.
Well, sure. Well,
Do you have any other objection before I bring the jury back?
I
What
moved
is your
for a
objection?
mistrial. And the grounds we're moving for a mistrial on, Ms. P.V. Hall was able to testify that Tara would tell me if there was anything going on with her and Chris Melton. We've submitted to the court and filed a residual hearsay notice.
Okay, I don't think that this is a proper grounds for a mistrial, but he's going to keep doing it. And he's going to do it at least 3 times today. Yeah, this was yesterday. So at least 3 times he's going to move for a mistrial. And what he's doing is preserving the record. He's preserving the record. Also, a motion to reconsider her prior ruling is probably not the proper objection to be making here. But again, she's patronizing him. And that's just what I find so grating about this. And she's still sitting there. The witness is still sitting there. There was a motion to recuse her from this case, Judge Lisa Allott, and it was denied by another judge. And that was made right at the end of January. Let's hear him keep talking.
To address those statements that were made. The Honorable Court advised us that we could not mention anything that Tara Baker told Ms. P.V. Hall in opening, and we cannot ask any questions related to that. Evidence has come into this case contrary to our 807 notice, residual hearsay notice, and we asked the Honorable Court to reconsider its restriction on the defense that is not on the state and allow us to ask questions in regards to that. The door has been open, Your Honor. We're just asking for fairness at this point.
Okay, Mr. Cruz, once again, you are misinterpreting this court's order.
I am not, Your Honor.
Mr. Cruz, I'm not going to argue with you.
Yes, ma'am.
I'm just going to tell you what the court's position is. You are misinterpreting this court's order. It would be helpful for you to go back and look at the order and to review the law.
It's not written.
Mr. Cruz, I'm talking now.
Yes, ma'am.
It would be very helpful for you to go back and look at the court's order and to review the law that the court used in coming to that decision. This is not grounds for a mistrial. I'm going to deny your motion for a mistrial. If you want to file a motion to reconsider and it is filed properly, I will consider whether it is appropriate for the court to hear it at this point. We will, of course, do it outside the presence of the jury if the court decides to hear it. But until that motion is filed, I'm not going to consider a motion for reconsideration in this forum. But I do think it is imperative for you, Mr. Cruz, based on your arguments, to go back and look at the court's order and the law and to interpret it properly. And that is going to be my final answer. Would you please bring the jury back? Thank you.
It's like that game show.
Can we ask her about it? That's what the court hasn't ruled on, Your Honor.
Mr. Cruz, it would be imperative for you to begin your cross-examination. If there's an objection, I'll rule on it.
Yes, ma'am.
Can you say hamstrung? Yeah, she just wants to say it's wrong, so it's in the record. Yeah, he's wrong. He's wrong. She always talks down to him. It's like, we're here now. It's time for my cross-examination and soon. And I want to know what the guardrails are because it's unclear. Because the state's allowed to get into it, but I'm not. So fast forward. And the witness has been there the whole time.
Ms. Hall, Talk a little bit about 160 itself, the house. Did y'all use the back door very often?
No, I think when we first moved, we might have looked out there and that was about it. I mean, there's no reason to go in the backyard.
The window by the kitchen table, was that ever open?
No, but I remember that it wasn't on the track correctly, so we can never really lock it. So I think we moved a chair back there, so thinking if someone walked in, we would hear it. But I think we did report that it was off track.
Did the three of you share keys with your boyfriend?
No.
Wait a second. They did report that the window was off track. Hold on a second.
You all may be seated.
Ms. Hall,
I was looking for the papers.
talk a little bit about
I think when we first moved, we might have looked out there and that was about it. I mean, there's no reason to go in the backyard.
the window by the kitchen table, was that ever open?
No, but I remember that it wasn't on the track correctly, so we can never really lock it. So I think we moved a chair back there, so thinking if someone walked in, we would hear it. But I think we did report that it was off track.
We reported that the window was off track. So the window was already broken. So the window never opened?
Did the three of you share keys with your boyfriend?
No.
Oh, none of them had keys? She's saying none of the keys. And then she looks down right away. I don't know. Do you believe her? How else would somebody have deadbolted that door? The front door, the back door, and the bedroom door. How else would somebody have done that? Whoever deadbolted that door after they set that house on fire did not want her to be able to get out, or did not want anybody to be able to get in.
Why not?
Like I said, we were very black and white on that. It was our house, and no boy should be there if we're not there with them. We were in law school, or grad school and law school, and just were busy, and we don't need just a random person being there. And we were very respectful of each other's place.
Great question. Was Tara's key missing?
How did you learn of Tara's death?
When we left, my boyfriend's in Atlanta, we first went to Winder, and then I went home, but my cell phone, like back there, we did not charge them, and mine was dead because we just didn't use cell phones like that back then. And by the time I got home, my parents met me at the door and said there was a fire. My immediate thought was Tara left a candle burning. She loved candles, and but then we had to load up in the car and go to Athens, and I think just, you didn't believe it because, and at the time we didn't know exactly what happened. We just knew there was a fire. So, of course, got to Athens and find out what happened, and I don't know. Some of it's kind of blocked out. I feel like your body shuts down when you get some type of that kind of trauma.
Totally understandable. Totally understandable. Heartbreaking.
No, you're fine. No, I'm here to answer whatever you need.
I'm not.
Both sides.
I'm not accusing her of lying or anything else. It's been 25 years since this happened. I'm sure that she has blocked a lot of it out. Totally normal. Totally normal. Looks to me like she either just looked over at the jury or the family. I'm not sure of the setup of this courtroom because they're not really showing the gallery at all. But here, watch her eyes. There you go. Oh, is Julie
Thank
Grant
you
going
so
off on this
much.
attorney?
I don't have any further questions
Okay.
for you.
Thank you.
Cross-examination, Mr. Cruz.
Ms. Hall, I think the most important thing, and I think everybody in this courtroom would agree, I am tremendously sorry for your loss.
Thank you.
I'm going to ask you some questions. Some of the questions may be a bit difficult, some of the questions may be a bit uncomfortable, okay? But I want to let you know I am tremendously sorry for your loss. I would like to start with talking about Miss Baker's life and how you knew Miss Baker, okay?
Okay.
I think we'd agree that Miss Baker was in law school and she wanted to become a judge.
Eventually, yes. She wanted to do real estate law.
Is it fair to say that Miss Baker was known to have a keen sense of justice?
Yes,
Okay, she would listen, hear things out before she would make a decision on something.
I agree. Yes.
And would you agree, as you sit here today, you just simply want answers on what happened to Miss Baker?
Well, and we want someone prosecuted in
Correct.
crimes. Yes,
But the right person. Is that
the right person, definitely.
And there it is. And we want someone prosecuted for this case. To Kill a Mockingbird. We want someone prosecuted. Hear that again? I don't blame her. I'm sure they want someone prosecuted, but how about the right person?
You just simply want answers on what happened to Miss Baker?
Well, and we want someone prosecuted in
Correct.
crimes. Yes,
But the right person. Is that
the right person, definitely.
Yes, ma'am. So you knew Miss Baker in undergrad, is that correct?
That's correct.
And you didn't just know her undergrad, you two went to college together.
We did.
And you two were roommates in college as well, is that right?
Yes, correct.
And not only in undergrad, which was in Milledgeville, but you also were roommates here at 160 Fawn Drive.
Correct.
You would have no reason to disagree that if Miss Baker was here, she would say you were her best friend.
I would hope so. Yes.
Ms. Hall, about a year and a half ago, do you recall being visited by law enforcement to discuss Miss Baker?
I do. Yes.
And
And then she looks over at the prosecutor. So she was interviewed again a year and a half ago, right around the time that Mr. Faust was finally, that anyone was finally arrested for the murder of Tara Baker. And this is where we're going to get into the prior inconsistent statement.
as a part of that discussion, they asked you about Miss Baker's relationship with Chris Melton. Is that
Yes.
correct? And you didn't know Chris Melton just through Miss Baker. You knew Chris Melton because he went to undergrad with you
I
two as
did.
well.
Yes, I knew him before they ever dated.
Mm-hmm. And I believe Miss Baker and Chris met at Georgia College.
Yes.
Is it fair to describe Miss Baker as, and if I say anything wrong, correct me, okay?
Oh, yeah.
Goal-driven and ambitious.
Very much.
And is it fair to say that you told law enforcement that Chris was very aloof and the fun guy to date in college, but not long-term?
If that's what it says, then that's what I said. But yes, they had a lot of fun together, and I felt like they just didn't have a lot of time for each other at that time. So it was a possibility that like relationships do, sometimes they end, but that's not to me. That's up to her.
She's totally backpedaling. She's totally backpedaling on what she told investigators a year and a half ago. He was the fun guy to date in college, and that's like, yeah, but I didn't mean that. And so she's going to get to explain everything. He's got the statement. He knows what she said, and he wants to call her out on it. And she's going to backpedal her little Southern Belle ways. And I'm not disparaging her whatsoever, but you're going to see a little bit of inequity here in the way that he's allowed to handle this witness. Listen to that again.
It says, and that's what I said. But yes, he was.
And is it fair to say that you told law enforcement that Chris was very aloof and the fun guy to date in college, but not long-term?
If that's what it says, and that's what I said. But yes, they had a lot of fun together, and I felt like they just didn't have a lot of time for each other at that time. So it was a possibility that, like relationships do, sometimes they end, but that's not to me. That's up to her. So I have no idea if they would have broken up or stayed together, and we never will. So
Yeah, you never will. And maybe she didn't tell you if she was breaking up with him or they were fighting or something happened or if he was shoved her, pushed her, or if it wasn't all, you know, sunshine and rainbows. Because he was your friend first.
That's fair. And you may have answered this. I just want to make sure it's clear for the court reporter. You described Chris as very aloof and the fun guy to date in college, but not long term.
well, that was my opinion. That might not have been her opinion.
Yes, ma'am.
Backpedal.
And Tara and Chris were a match you never thought would happen.
Well, because she was very serious and he was fun, and what they got together, and it worked. So that's all that mattered. There's a lot of people, I'm sure, that, you know, in your past that they didn't look like they would work, and they were fantastic together.
Wow, really backpedaling because the family's there. And now she's like, oh, well, I got to explain that one away.
And when you and Ms. Baker were staying at the Deer Park apartment, she was dating Chris. Is that right?
Correct.
Okay. And Chris would come over to the apartment a lot.
You come some, but they mainly went over to his.
Sure. And I want to make sure that I use the right term. Do you recall telling law enforcement that Chris came over to the apartment a lot?
I don't recall, but if I said it, then that's what I said, yes.
So for now, she's trying to say, oh, she mostly went over to his house. And now she's like, he came over a lot. Because that's what she said to the investigators. You see? You see what's going on here?
No,
I
that's
just want to make sure I'm clear from the record. Do you not recall?
Yes, okay, I recall I said that. I said it a lot. Like I said, I talked to many reporters and many people, so.
So I don't remember who I told what. Don't hold it against me. I've spoken to a lot of people.
Chris would sleep over as well. Is that correct?
Some, yes.
Based on your personal knowledge, you don't know whether Chris had been provided a key to Deer Park or not. Is that correct? Excuse me, the Deer Park house or not?
Personally, no, but she would have, one, told us if she gave him a key, and two, none of us would have ever given someone else a key that was not on the lease.
Girl, that was not on the lease. Girl. You have no idea whether he had a key or not. Come on. Isn't that again?
But we would.
Provided a key to Deer Park or not. Is that correct? Based on your personal knowledge, you don't know whether Chris had been provided a key to Deer Park or not. Is that correct? Excuse me, the Deer Park house or not?
Personally, no, but she would have, one, told us if she gave him a key, and two, none of us would have ever given someone else a key that was not on the lease.
Sure.
I would have moved to strike the non-responsive portion. The answer was no. Move to strike the non-responsive portion. The answer was no. See how she kept going on to try and explain herself?
And thank you for that. And just to make sure it's clear for the record, to your personal knowledge, you don't know.
Of course, no one knows.
Yes, ma'am.
So.
Now she's getting snippy.
As Tara's best friend and as her roommate, would it be fair to say that you had an opportunity to observe her relationship with Chris Melton?
Yes.
Is it fair to, well, let me rephrase that. When law enforcement met with you, you told law enforcement, I think once she started law school, I think they started dividing a little. Do you recall making that statement?
I'm sure I made the statement. The only thing I would mean by that statement is that he was starting his full-time job, plumbing, and she was trying to study. So they just didn't have the time together. And as I said before, that was just frustrating whenever you don't have the time with the person that you're with.
Yes, ma'am. And you also told law enforcement, and I quote, I mean, there were cracks already that, you know, it was just he was wanting more time and she's like, hey, I'm in law school. Do you recall making that statement to law enforcement?
I'm sure I did you said I did, but she was in law school. She was busy.
Yes, ma'am.
That's a fact.
Would you agree that you told law enforcement when asked about Ms. Baker's relationship with Chris Melton before her death, you stated, I think just the normal, you could almost see it was the normal, you could almost see the ending of a relationship, if that makes sense.
Well, that was my opinion, but
You
doesn't
could almost see the ending of a relationship, if that makes sense. Remember, this statement was given, what did he say, a year and a half ago? This was not even a statement given in 2001. I feel like this is the statement that is from a year and a half ago, right? Tell me if I missed something in my brain fog from being sick. And now a year and a half later, you're going to change your statement going back to what happened 25 years ago?
not mean that's what was happening.
Sure, but that was based on your.
No, it's just, as I said before, they just couldn't spend time together. And so it just looked like they're both busy. It did not mean one thing or the other. She was frustrated at the time. Again, does not mean that their relationship was ending. He was one of the nicest people ever. It was always sweet to her. Never.
He was one of the nicest people ever. He was always sweet to her. Okay. In defense of Chris,
Showed any anger toward her.
as far as you know.
And you told law enforcement about the frustration around them not seeing each other. Is that correct?
Yes, that's correct.
And is it true that you told law enforcement when you were asked, like they're starting to grow apart or he's getting on her nerves? Do you recall being asked that question?
I don't recall it, but if I said it, that's.
Would
getting on her
hearing,
nerves.
But also you have to remember, we were asked so many questions by so many times that it was getting on my nerves at that point. So sometimes I might have been a little abrupt.
yes, ma'am. I know you mentioned that you don't recall it. Would hearing your interview refresh your recollection in regards to that particular question and what your answer may have been?
If it makes, is there a reason for me to hear it?
Ma'am?
Is there a reason for me to hear it?
Sure, we could talk about it outside the presence of the jury, but at this time, the Honorable Court has only given me permission to ask questions.
Okay.
So would hearing your interview refresh your recollection into the question that was asked and your answer to that?
What exactly was the question? And maybe I can just answer it for you, how you need it answered.
Yes, ma'am. You were asked by Agent Bigham, like they're starting to grow apart or he's getting on her nerves. And your response was, I think it was just getting frustrated because, and I think they both were because she had to study so much. Do you recall making that statement?
Well, sure, I've made it many times, but yes, she did have to study a lot. And when he had time, a lot of times she didn't. And when she had time, he had to work. It was what happens when people start their real lives. You have priorities and you just don't have the time to spend together. But that doesn't mean that he hurt her or did anything to her.
Yes, ma'am. Is that a yes or a no to my
Do I
question?
remember making that? Yes. Okay. I remember that statement.
Thank you. Do you remember telling Elizabeth Bingham,
Eyes.
and I think
Yeah.
that was, once she started dating Chris Milton, and I think that they were kind of on the outs before everything happened.
Well, they just didn't have, not on the outs, they just didn't have the time together.
Do you recall making that statement?
I'm sure I made the statement. I'm just saying that they did not.
She made the statement many times in more than one way that they looked like they were heading for a breakup, that she was annoyed with him.
Spend as much time together as they had previously.
Yes, ma'am. But you do recall making.
Yes, I recall making that statement.
Yeah, may we approach?
Okay.
FF it a little bit.
Please don't discuss the case one other time. We are almost done for today, but if you'll go into the jury room, please don't discuss the case. Thank you.
So the jury goes out, but again, the witness is still standing there.
Cruz. And I have your. All right, go ahead, Mr. Cruz. And I have your motions that we were talking about. In general, I have all three of them that are pending. So I'm pulling up the one related to this witness. Go ahead.
I'm going to speed it up a little bit so we can get to today's testimony.
As the number court is aware, on January 20th, 2026, Mr. Faust filed a notice of intention to introduce residual hearsay testimony pursuant to OCGA section 24-8-807 in regards to Ms. Ashley Peavy. In court's indulgence, Your Honor, my computer just froze on me. I have a hard copy, actually.
Oh man, he just can't catch a break.
From, and we ask that the Honorable Court admit 3 statements from Ms. Tara Baker that were made to Ms. Ashley Peavy. The first statement that we ask for admission of is Ms. Peavy stated in her interview with law enforcement that Ms. Baker confided in her that Chris Melton was not considerate and that she was doing a lot and Chris was not reciprocating. She didn't feel appreciated. The second statement from Mrs. Peavy Hall, please forgive me. Ms. Baker expressed frustration to Mrs. Peavy Hall, advising that Chris Melton wanted more time with her, but Ms. Baker was unable to give it. The third statement that we asked that the Honorable Court admit through Mrs. Ashley Peavy Hall is that Ms. Baker, the third statement, we asked the court not to consider that statement. We're asking about the first two. And the reason we bring this motion up, Your Honor, is because during direct examination, the state elicited testimony from Mrs. Peavy Hall where she stated that if there was something, and I'm paraphrasing, but if there was an issue in the relationship, Tara would have said something to her about it.
Okay, what just happened? Why did they just take their feet down? Okay, what just happened? Hold, please. I wonder if the same thing happened. I wonder if they had to take away. Yeah, now that video has been made private. Somebody said Law and Crime put theirs back up from yesterday. So let me see if I can find it. But
Hired me on the Atlanta.
problem is we're going to have to find the exact spot. Well, suffice to say that Edrick, Mr. Cruz had a lot of problems yesterday trying to get this residual hearsay in. And once I can find the papers on it, we will take a look at that. But he had a great speech about how he used to want to become a lawyer and be a lawyer. And this case has made him not want to become a lawyer anymore. All right, let me get back to, we'll start today's testimony now. Let me just see something.
Stayed there.
Maybe they realized yesterday that they, the doxing thing happened and so they took it down. Hold on. Oh, please. If Law and Crime put up day 3 yesterday, but I don't see it. Somebody said that you did they put it back up day 3? All right, hold please. Maybe they just clipped that part out.
No other questions in regards to number 1, Your Honor.
All right. Mr. Yalman-Chile, do you want to ask any?
Hold please.
No other questions in regards.
The third notice statement, and if we look
or he's getting on her nerves.
He's getting on her nerves. Okay, then he comes to do his.
What we know.
Tell me if this is where we were. Hold on. And if the volume's okay.
The evidence would show we're saying in essence that this has now become competent and relevant evidence that we could use to impeach the prior statement given on direct of Mrs. Peavy Hall.
Speaker to respond.
yes, Your Honor, and I'll just cite, there's basically in all of the notes on decisions here. There's a very good first sentence to all of them. The residual exception to hearsay is to be used very rarely and only in exceptional circumstances. That holding is in Brooks v. State, 365 Georgia App 711. And frankly, Judge, I haven't had a chance to read all of these cases. These are just the notes on decisions. Thrift v. State, 310 Georgia 499. Miller v. State, 303 Georgia 1. Those are in order. I'm sorry, I should have done this to begin with. 2022 Court of Appeals case, a 2020 Georgia Supreme Court case, and a 2018 Georgia Supreme Court case. These are certainly not exceptional circumstances, Your Honor. What they are is a couple of statements cherry-picked about minor regular relationship complaints that parties would have in an effort by Mr. Cruz to cast a certain light on the relationship between Ms. Baker and Mr. Mellon. This witness, and I would just state, the court heard the objection from defense counsel to statements similar to the statements he's attempting to admit, and it sustained that objection and directed the state to move away. Defense counsel is not seeking to admit the third notice statement. If we look at the first two notice statements, I don't believe there's a way to interpret those as being necessary in creating some kind of exceptional circumstance. The witness has acknowledged that there were challenges in the relationship that were created by a lack of time, and has not denied. She may not be familiar with each statement that Mr. Cruz has read to her that are purportedly quotes from the interview that she had with the GBI in 2024, but she has acknowledged that they had her perception of things may have been that they were drifting away, but she didn't have the ability to get inside of them.
Dude, 2024 is only like a year and a half ago. Okay. It's not like these statements were made in 2001. And guess what else? You should have prepped her with these statements. And if you didn't prep her with these statements, it's your problem, not his.
Baker's head, and her overall view of their relationship was nothing that caused her concern. I failed to see, residual hearsay is an extraordinary exception. If we think about all of the exceptions to the hearsay rules, there are well over a dozen. And so when you're going into this catch-all category, especially in a circumstance where you are picking random statements that Ms. P.V. Hall has referenced in talking about talking to law enforcement, and the only one that's close in time to the crime, the defense is not seeking to admit anymore. I'm not sure that there's been a date provided as far as when these statements were allegedly made by Ms. Baker to Ms. P.V. Hall. So that in and of itself, I think it's a failure to show how they would be extraordinary. This would qualify as an extraordinary circumstance. We don't even know the temporal relationship to these statements. You go inside any serious long-term relationship or any marriage, and if we're going to pick out times where one party or the other made some kind of statement about being frustrated by the conduct of the other party, that certainly wouldn't be an extraordinary circumstance. And that's exactly what Mr. Cruz is describing here, Your Honor.
Right. But if he's the third party culprit in her brutal murder and burning of her body, don't they then become relevant, Mr. District Attorney? Is he up for re-election? Somebody I thought said. I'm sorry, what? Yeah, all relationships have problems. Yeah. But when this guy is a third party culprit here, then it becomes relevant. And I think that part of the problem is that Mr. Cruz did not lay a proper foundation. When did she make these statements to you? But I thought she said it was within close in time to her murder, within a couple of weeks, right? Or did I just make that up out of my head?
I don't think the court should let it in under 807. The only other cases that I've seen, Judge, and I can look back and find them again, but when we looked at it when the notice was filed, most of the statements that I saw had things to do with statements directly related to the crime, either made by the decedent or made by some witness who was unavailable, not through any kind of wrongdoing of the party who is trying to admit that residual exception. And so I'm unaware of any case where a criminal defendant who is on trial for the murder of the declarant has been allowed under the residual hearsay exception to admit statements from them. I don't think Mr. Cruz is citing any case. There may be one out there. I'm not saying that. And that's not even really the determinative factor for the court. But I've not seen any cases where it was admitted in any circumstance that would be anywhere close to this.
All right.
May I respond, Your Honor?
Okay.
In regards to the exceptional circumstance, Ms. Baker is not here to speak for herself.
Right.
As the state has clearly said multiple times, my client is the individual charged with Ms. Baker's death. So I have the burden of not only getting justice for my client, but also Ms. Baker. We're presenting the evidence that the state had and did not use. The exceptional circumstance is the state had all this evidence of Chris Melton's guilt for 24 years and ignored him. Even today, when I've given them.
Praise be. I got to put him on regular speed because you need to hear this in all its glory. This should be a movie. I'm sure Hollywood is writing the script as we speak. Listen to this. They had all this information on Chris Melton for 24 years and they did nothing.
Death. So I have
Anywhere close to this.
All right.
May I respond, Your Honor?
Okay.
In regards to the exceptional circumstance, Ms. Baker is not here to speak for herself. As the state has clearly said multiple times, my client is the individual charged with Ms. Baker's death. So I have the burden of not only getting justice for my client, but also Ms. Baker. We're presenting the evidence that the state had and did not use. The exceptional circumstance is the state had all this evidence of Chris Melton's guilt for 24 years and ignored him. Even today, when I've given them, I've given you your own evidence, they still continue with the prosecution of Mr. Faust. Our position, on the court knows this, is that Chris Melton did this. We're presenting the evidence to establish that Chris Melton committed this crime. And a part of that evidence is Ms. Baker herself saying, hey, these are the issues, or these are my feelings about my relationship with Chris Melton.
Okay. Thank you, Mr. Cruz. All right. So I'm going to move backwards from 3, 2, and 1. First of all, number 3 has been withdrawn by defense counsel, and I've noted that in the motion, and I will order it withdrawn, and that will not be allowed. Number 2 is has already been testified to by this witness. And so I'm going to deny your motion on number 2. This witness did articulate what you are seeking basically to introduce in number 2 of this motion. And because of that, your motion does not meet the standard for the court to grant you the ability to have any of those statements introduced under 807. With regard to number 1, I think what is important for me to tell you is that the state's comments that your request, Ms. Tara Baker confided in Ms. Ashley Peavy that Chris Melton was not considerate and that she was doing a lot and Chris was not reciprocating, she didn't feel appreciated, is very vague and general in nature. I will let you at this moment, in support of your motion, voir dire question this witness about that moment that you seek to introduce. It's outside the presence of the jury. The court cannot make any determination about your request because of the vagueness of that particular statement. I don't even...
The witness is sitting there the whole entire time. She's sitting there the whole entire time. Thank you, Gen X 1968, for gifting 5 memberships. You're amazing. Happy birthday to you, Carrie, coming up. She said, my wish is for this world to straighten up. Don't we all?
Know what the statement is that you're seeking to introduce. The way that you have written it in the motion, and you may have just done it to put the court and the state on notice, and that's fine, is a general sense of what you're insinuating.
Sure.
But I know you're asking to introduce a specific statement.
Yes, ma'am.
I'm going to ask you to, if you choose to,
Yes, ma'am.
question this witness outside the presence of the jury about what it is you want this court to admit, the specific statement, but it also needs to have the specific supporting testimony, the foundation that Mr. Yamamoto was referring to.
Yes, ma'am.
Because it is not proper under 807 for the court to admit statements that are not particularized, that are not associated with something very specific. Just sort of a general request is not appropriate under 807. And so in the context that perhaps you were just giving the court notice of what you wanted, I'll let you voir dire or question this witness if you choose to, and then I'll let you cross-examine, sort of, or redirect, or whatever you want to call it also, and I'll make a decision.
Sure. Thank you.
That's with regard to number 1 in your motion.
He's going to, see, here's the thing too, and he's going to say this, but I picked up on this before he even had to say it, is that she wants him to tell the prosecution his theory of the case. He's got some gotcha moments and he wants to save them, and he should be allowed to save his gotcha moments, right? Not a lot of surprises in a trial. In Massachusetts, you have to hand over all your impeachment evidence, which is wild to me, before the trial. But he's probably got some gotcha moments that he wants to hang on to, right? And shouldn't he be allowed to do that? But this judge wants to make, the prosecution aware of everything that he's going to use in his defense, and I disagree with this.
Thank you, Your Honor. What was she telling you about their relationship? And she is Ms. Baker. Do you recall? Agent Bigham asked you.
No, this is outside the presence of the jury. I'll slow it down a little bit.
Was she telling you about their relationship? Mrs. Peavy Hall, Agent Bigham asked you, what was she telling you about their relationship? And she is Ms. Baker. Do you recall that question?
Okay.
Do you recall that question?
Yes.
And your response was, your response to her question of what was Ms. Baker telling you was, some of it's just guy stuff of not being considerate. You know, the girl's doing so much and feel like the guy's not reciprocating. Is that correct?
Yes.
Okay, and that's what Ms. Baker told you. Is that correct?
Yes, correct.
No other questions in regards to number one, Your Honor.
All right, Mr. Yalmanchili, do you want to ask any other questions?
I don't have any questions.
All right, thank you.
Judge.
All right, Mr. Cruz, you haven't laid the foundation. I mean, I don't know when these statements happened. I don't know what circumstances the conversation you're asking to introduce happened between the victim in this case and this witness. It's a general conversation. You haven't laid the foundation.
So let him clean it up. You know, Your Honor, you're allowed to step in. You're allowed to say to the witness, okay, so when did she make these statements to you? And when were these statements made, and et cetera? She could do that, but she's not going to, because she wants the conviction too. I'm convinced now. I'm convinced.
Foundation, I'm going to deny your motion.
Yes, ma'am.
You may bring the jury out.
I'm just going to deny your motion. He needed to find out when those statements were made to her.
Your opinion of Ms. Baker's
When
relationship
Tara
with
told her that stuff. How close in time to the murder?
Chris Melton was that Chris Melton was not treating Tara. Your opinion of Ms. Baker's relationship with Chris Melton was that Chris Melton was not treating Tara well leading up to the time of her death. Is that correct?
My opinion was she was frustrated, but that does not mean that he wasn't treating her well.
Do you recall telling law enforcement he liked to flirt with other girls and everything else too?
Well, not everything else too. That probably was a little bit extra, but he was very
That part was a little bit extra. He liked to flirt with other girls and everything else too. That was a little extra. Is she still friends with Chris? She's still friends with Chris's family. Have they been in touch since they were both going to be called to testify at this trial? I'd love to know that. When's the last time you spoke with Chris Melton? That would be my next question. Listen to this again.
mean that he wasn't treating her well.
Do you recall telling law enforcement he liked to flirt with other girls and everything else too?
Well, not everything else too. That probably was a little bit extra, but he was very friendly, but so was Tara. They were both very happy, friendly people and talked to everybody.
My specific question is,
Is it possible that Tara could have met Edrick Faust in a bar and spoken to him? Is that possible?
tell law enforcement that he liked to flirt with other girls and everything else too?
Something
Yes
funny?
to your question.
Something funny, Ashley? Oh, the jury's back now. I got to change the banner.
And sometimes you would hear Ms. Baker express frustration about her relationship with Chris Melton. Is that correct?
Sorry, I'm going to object to hearsay, Your Honor.
All right, here to respond to the hearsay objection.
I do. I'm not asking for a statement. I'm just asking for the witness's perception based on information given to her.
All right, I'll allow it. Go ahead.
Okay,
Is that
just to
correct?
clarify what hearsay is for those of you who may not know, who may not be avid trial watchers. Hearsay is an out-of-court statement offered to prove its truth. Okay, so a hearsay would be, this person told me this, and I'm offering it to say that what this person said was actually true. There are exceptions to the hearsay rule, and she's allowing this in.
It's correct. We usually talked about being frustrated with our boyfriends. Yes.
He's not asking for a particular statement. She told me this particular thing, but in general, did she express her frustrations to you?
Okay. And not only would you hear Ms. Baker talk about it, you told law enforcement that you witnessed it for yourself. Is that fair?
I'm sure I did.
He's trying to backdoor it in, and he's doing a good job.
Now, we've agreed, or I believe we've agreed, on a couple of things regarding your knowledge of Ms. Baker's and Chris Melton's relationship. But based on your friendship with Ms. Baker and you being Ms. Baker's best friend, I think we all would agree, I think both sides are on the same page that you were the person that she considered her best friend. Is it fair to say that Ms. Baker was not the type of person to speak ill of Chris to others to avoid making him look bad?
To a point, yes, probably. But she would still, if something really bothered her, she would have said something.
And just to make sure I'm clear for the record, in regards to my question, and if you can, just yes or no, but you can always explain. Is it fair to say that you describe Ms. Baker as the type of person that would not speak ill of Chris to others to avoid making him look bad?
Yes. She would also do it for me too, probably. But
Ugh, she's got to keep adding and adding and adding because she keeps laughing because she's caught. Because when she told law enforcement a year and a half ago, she doesn't want the family to know she said that.
Now, again, I want to go back to Ms. Baker as the person, because I think that's the most important thing, tied with the most important thing in this trial. You would agree that Ms. Baker was not a pushover.
no, she was not.
She was very assertive,
She was quite assertive.
but she would speak her mind. If something was wrong,
Yeah, well, but yes, she was not pushy. She was not loud.
and even as best friends, you two would get into disagreements.
Of course.
So it is fair to say that she's assertive, not timid. Is that correct?
She had things she was timid in.
Okay. But just speaking her mind.
She would have to be very, either something upset her to where she had to speak her mind, but she wouldn't just say something to somebody to say it. Like she was not one to insult somebody, even if though she had a different opinion.
That's fair. Do you recall law enforcement asking you about racial biases of Ms. Baker?
Yes,
Okay. And is it fair to say that you advised law enforcement that she did not have any racial biases?
I did.
But you did say if you did her wrong, she might not ever forgive you.
I did. Yes.
Were you aware of the incident the week before her death between her and Chris Melton?
This was 25 years ago. You have to do a little bit more than that. So
Sure. As you sit here today, are you aware of a disagreement Ms. Baker and Ms. Melton got into, Mr. Melton, the week before her death?
I know she was frustrated with him, but we did not discuss exact details.
Okay, just to make sure it's clear.
Do you think she knows what that argument was about 1 week? 1 week before her murder? Look at her face. My freeze game is so on point right now. He got this witness to say Tara Baker had no racial biases, but if somebody did her wrong, she would not forget about it. I want to know what that argument was about a year before. Hang on. I mean, it was a week before, right? Hold on. 100% she knows. She doesn't want to say it.
I did.
About racial biases of Ms. Baker.
Yes.
Okay. And is it fair to say that you advised law enforcement that she did not have any racial biases?
I did.
But you did say if you did her wrong, she might not ever forgive you.
I did. Yes.
Were you aware of the incident the week before her death between her and Chris Melton?
This was 25 years ago. You have to do a little
Incident.
bit more than that. So
Sure. As you sit here today, are you aware of a disagreement Ms. Baker and Ms. Melton got into, Mr. Melton, the week before her death?
I know she was frustrated.
The week before her death. First he said incident, then he said argument. 1 week before her death. Do you guys think this is relevant? Do you guys think that the jury should be able to hear about that? I do.
Frustrated with him, but we did not discuss
frustrated.
exact details.
Okay, just to make sure it's clear for the record. Are you aware?
I am not aware of the exact confrontation that they had.
Yes, ma'am.
Oh, now it's a confrontation. First he said incident, then he said argument. Now she's calling it a confrontation. Those are her words. I would have expounded on that. Confrontation, you say? Confrontation? You said they had a confrontation? Tell me what you know about that confrontation. Without telling me what anybody said, tell me what you know about that confrontation. What do you know about that confrontation?
Now, with these lines of questioning, I'm going to ask you some very personal questions, but I am not going to mention the topics. I'm not going to dig too deep, okay? So I'm going to speak in general terms. Is that fair?
Yes, sir.
Okay. During your interview with police, and again, I won't mention the topics, but do you recall being asked some questions about your knowledge of Ms. Baker's innermost private life?
Yes.
Would you agree that you told law enforcement, or let me change that. Would you agree with the statement, people do things without telling people, it doesn't matter how close you are?
I agree with that. That's
Okay, got that? People do things without telling other people.
Would you agree with the statement, people do things without telling people, it doesn't matter how close you are?
Doesn't matter how close you are. People do things without telling other people. You know where he's going with this, right?
I agree with that. That's
You would also agree with the statement that there are certain things, if they occurred, Ms. Baker would not advertise to anybody.
Can we approach?
You may.
Right. Okay. He hasn't said it outright. But what I'm thinking, where I think he's going with this is if she had a consensual relationship with my client, the black man, Edrick Faust, she might not have told you that, right? Because you might not have approved of that, right? But he hasn't said that yet. He's simply asking questions. He didn't even get there. And this district attorney is cutting him off and going up there. And what happens next, it could have been predicted, in my opinion. But if you haven't seen this, get ready. Buckle up.
Your Honor, I would ask if there's objection, the state just makes the objection, Your Honor.
Well, y'all been coming to the bench this entire time. So why don't you?
He's like, if you want to make this objection, make it an open court for the world to see in front of all the cameras. Don't be running up to the bench to ask mommy to help you out. And he's right.
I'll come up here and I'll make a determination of whether we do it here or send the jury out.
And the witness is still sitting there.
Yes, sir. Hold on.
If anybody knows who Mr. Cruz's co-counsel is, the man to the left of the screen, please let me know, because he does stand up.
And I am going to take up another thing outside your presence. I'm not going to make you go back in and come back out again. I'm going to send you home for the evening. It's 5:05. I am going to ask you, of course, to recognize the rules we've talked about ever since you've been coming to this court.
She does
Don't
say, like,
discuss the case with anyone. Don't do any
don't use
independent
social media.
research. Don't look at the news for anything that may be on there about this case. Does anybody have any questions for the court before I release you?
Yeah, why are you such
Okay. I appreciate your patience today. It's been a long day. The elevator, and just very much.
We have snacks for you. We have snacks. You want snacks? We've got snacks. Okay, now the jury's out. And then soon this will be the end of day 3, and then we'll move on to today.
And we'll do that since the jury is gone. Make a statement before we get into your motion, and we'll do that since the jury is gone. All right, we're gone? Okay. Should have first. I want to sort of go back for a moment with regard to the motion of residual hearsay that the defense filed and that we've kind of heard argument on today, even though it was pending.
Right, because she never decided the motion.
With regard to this witness is denied. Number 3 that the defense asked for was withdrawn. I've already made my comment about number 2, the second prong of the motion. But with regard to number 1, the first prong of the motion, I did deny, but I want to elaborate for the parties why I denied the motion. The law requires, and I'm making a finding the defense did not provide this, the law requires, of course, that there be a sufficient foundation laid to provide that exceptional guarantee of what the law mandates, exceptional guarantee of trustworthiness. There was no statement under a belief of impending death or any statement against interest, which the statute, of course, refers to. That really isn't what the statement was about, but that wasn't present here. I did make it clear to defense counsel that the court needed a foundation about timing, about context, and things of that nature in order to assess the appropriateness of the motion. That was not provided. And so those are the reasons that this court did not grant your motion that you filed with regard to this witness to introduce residual hearsay. I'm making a further finding that it did not violate 403. There was no showing that the testimony was relevant, as the witness in this particular motion did not deny the statement she made to law enforcement. And even if it was relevant, there was not a sufficient showing that the probative value was substantially outweighed by the danger of unfair prejudice. And that is my finding on that motion. All right, let's talk about your objection to Mr. Cruz's question. Go ahead, and then Mr. Cruz, you may respond.
Well, Your Honor, it is an objection to any questions, which was the line of questioning that Mr. Cruz seemed to be headed down, that could touch on acts or inferences to be made to the jury by his questions that would violate the court's previous order regarding 412. Mr. Cruz is asking questions about the most intimate details of Ms. Baker's life. He is asking Ms. T.B. Hall questions.
I didn't hear him ask about the most intimate details of her life. Did you? Because I must have missed that part when he started asking about, did she ever tell you what positions she liked? And I didn't hear any questions about intimate details. Did you? Are we being gaslit?
About there may have been things that Ms. Baker has done that she wouldn't tell anyone about. And the state's fear is that Mr. Cruz is going to continue down a line of questioning that would result in trying to, which is barred by 412, it's cross-examination, but direct examination, cross-examination, or any evidence of any kind is barred that may touch in any way on any type of past sexual conduct.
This is his fear, okay, Mr. District Attorney? Your fear is not a proper objection here. You need to wait until such a question is answered and then make your proper objection. But your fear that defense counsel may go down a road that you might not like, or that may be in violation of 412, which is Georgia's rape shield statute, is not a time. This is not a timely objection. 412 is the rape shield statute in Georgia. You can Google it. We went over it the other day. Just Google Rule 412 Georgia, and you can get all the information about it. But we can't stop right now to talk about it. There are certain situations in which you cannot mention because she was a victim of grape and SA before as part of her murder. There are things that you cannot talk about with regard to the victim's sex life. However, I did not hear those questions being asked. He's afraid that he may ask that. Okay. And yes, he's hiding behind the grape shield. Yes. And the thing is, this is not your typical grape case. This is a brutal murder with a third-party culprit who actually was having a sexual relationship with the victim. May she rest in peace, Tara Baker. And this guy, Chris Melton, the boyfriend at the time, who this witness is saying they were in a great relationship. She would have told me if something was wrong. Maybe she was getting tired of him. You know, her testimony is all over the place. But we learned from openings that Chris Melton originally told police that he had not had sexy time relations with Tara since the weekend before. She was murdered on a Friday morning. She was murdered on a Friday morning. He said, I didn't have sex with her since the weekend before, which is interesting because his hair and his DNA is found around her privates. Okay. And as this witness just told you, she showered every single morning. Every single morning she showered. She had 2 bags of cheesy grits and she sat on the floor to blow dry her hair. In 2024, when Chris Melton is again questioned by Bigham, who's the new lead investigator from the Georgia Bureau of Investigation, when they want to close this cold case real bad because they just enacted an act in Georgia called the Coleman-Baker Act, in which they allocated something like $5 million in an effort to start closing cold cases. Baker, the Baker part of that act, was named for Tara Baker, coincidentally, or maybe not so much. In 2023, they enacted that act. This may be the first cold case they allegedly closed because of that act. So ask yourself, do they want a conviction or do they want to show that their $5 million went to good use? That is for not me to decide. Follow the money. Chris Melton was told by Elizabeth Bigham in 2024 when he was interviewed. Listen, dude, here's the thing. They found your DNA and whatever around her private parts. And I remember that you said you didn't have sexy time with her since like the weekend before, but come on, maybe you want to, tell me. It's okay. You could tell me. And then all of a sudden in 2024, Chris Melton's like, oh yeah, well actually, yeah, I forgot. But yeah, we did have a booty call the night before, but I left at midnight. I swear, trust me, bro, I left at midnight. So much is wrong with this case. So much. Thank you for coming to my TED Talk. They were cheesy grits. And let's keep going. This is Yalamanchili. I think that's how you spend. So if anybody wants to type anybody wants to type his name into the chat, I will put it up again. I think it's like Kalki Yalamanchili. No, I'm not kidding. I wish I was kidding. And then apparently there's some like in the opening, if you guys are new, in the opening, the prosecution put up a whole PowerPoint slide of Chris Melton's alibi. And I think there's allegedly video of him at a bank or something. Somebody put it in there. I don't remember when it was, but I think that the defense is still waiting for the calci yalamanchili. Oh, thank you, Emily C. And I think the defense was still waiting on the tape from the ATM. I don't even, were there even ATMs in 2001? I don't remember back that far. It's 25 years ago. We need to follow the money emoji. We do. Chris put himself there at that time. Yes, he did. Yes, he did, but not until 2024. See? Right. Here we go.
Of the victim, and I believe that that is what this line of questioning is. So it is a motion limiting, asking Mr. Cruz not to continue down that line of questioning, which is barred by 412.
I think Mr. Cruz.
It's an improper objection, the timing.
Say, Your Honor, we have a right to cross-examination. The state clearly just. Sure.
You hear him?
I told me I need to use this when I speak, but
Praise be.
I truly
Praise
don't
be.
know what to say.
Like,
The state,
it's like Law and Crime gave him a lavalier mic. Look, he's got a mic in his hand. Yay, praise be. Hold on. I don't want to put the sleep timer on. I want to turn the speed down because I love his passion so much.
just stated that I guess they believe, not that I've done anything, but they believe my questioning is leading to 412, which led them to request a bench conference that I wasn't, that I wanted to continue my cross-examination. They could have made their objection on the record. This isn't an objection. This is the state saying, hey, judge, please curtail his cross-examination. We just don't like where it's going. The court has made it very clear what I can't. I'll say this. The court has given me 2 examples of what is off limits with 4012. And I understand the statute as well. This is, again, in essence, the state just saying, judge, we don't like this line of questioning. We don't like where it's going. It violates 412, so put a restriction on them. And he even just asked for it. He said, judge, this is a motion of limine asking you to put a restriction on Mr. Faust regarding his line of questioning. Your Honor, I am exhausted. I used to love coming to court.
Oh, this is his speech, and I love this so much. Oh, look at, well, first of all, thank you, Susan CR, for gifting 5 memberships. You're amazing. This chat is amazing. You're the most amazing people on the internet. You really are. And you know that the internet can be an ugly, dark, and dangerous place. And you guys are the shining light in the internet. And look at Mr. Faust behind him, just raising his fists up. I'll take it back a smidgen because this is like a Hollywood speech.
Regarding his line of questioning. Your Honor, I am exhausted. I used to love coming to court every single day. This was my childhood dream. I am starting to just, me and Mr. Faust, it's a war of attrition. We're just dragging through this case. I would ask, Your Honor, that you rely on the law, the 412 statute. I'll prepare a brief if you want me to. Our office will put it together regarding 412 and what the cases say about Rule 412. I would ask that you deny the state's motion. And if we put anything in place, that the state, if they have a valid objection, make an objection. If I violate the court's order, the court can hold me in contempt if I violate the court's order. I understand what the court's order is. The only thing we're trying to do, Your Honor, I'm trying to get justice for my client. I'm trying to get the truth for the family. We're just trying to litigate a case. I would just ask that the Honorable Court allows us to litigate this case pursuant to the rules of evidence and not the preferences of Mr. Yalamanchili and the state.
Thank you, Mr. Bruce. So I want to ask you if I can get an understanding of your line of questioning that you're
Wait, did he steal that speech from Brian Steele? Hold on, Angel, really? He said the same thing. I used to dream of being a lawyer and now I don't want to come to court every day. Oh, well, I liked it anyway.
Asking to be admissible. Where were you going with those questions?
Like, why does she
Your
have
Honor,
to tell
these are-
him? Why does he have to tell her where he's going with those questions? It's his case. Let him present his case. Let him have the element of surprise. And if the question is improper, object then. He doesn't have to tell her where he's going. This is so improper. And here we are in Georgia. Lisa Lott, she's a lot. It is, again, like the Twilight Zone.
Exact quotations of statements that she's
All in
made
front of the witness.
by the made to law enforcement. If the honorable court wants to know exactly where I'm going with that, I could do it outside the presence of the I would ask to do it outside the presence of the witness.
Yeah, because
All
the
right, fair
witness is
enough.
still sitting on the witness stand. Could you imagine? Oh my God.
Could I have you, well, actually, I don't think we need this witness now at all, unless there is something else we need to discuss with this witness.
That's correct, Judge.
All right. I'm going to ask that you return tomorrow per your subpoena, and you're free to go for now. Thank you.
So, Tara, the purpose of this.
Go ahead, sir.
Yes, ma'am. The sole purpose of this line of questioning, Your Honor, is summed up in one sentence that we were going to use in closing. That Tara did not share intimate details of her private life.
Right.
So what the state just did, stopping the cross-examination, was to prevent us from saying one sentence in closing. And that sole sentence, Tara does not share intimate details of her private life. I would ask that a restriction is put on the state. They are more focused on convicting Mr. Faust than finding out the truth and letting the evidence stay where it needs to stay. The evidence speaks for it.
Praise be. They are more interested in convicting Mr. Faust than they are in finding out the truth. And these are the cases that I choose to cover. These are the ones that I choose to cover because these are the cases that outrage me. They outrage me. We know, I mean, I think that Ahmad Cruz watches LawTube because he in his opening or somewhere during the questioning said the word unalived. And I was like, oh, he's a fan of the YouTubes, right? Listen to that again, because we say that all the time. There's nothing worse than a prosecutor who is more interested in getting a conviction than finding the truth.
State just did, stopping the cross-examination, was to prevent us from saying one sentence in closing. And that sole sentence, Tara does not share intimate details of her private life. I would ask that a restriction is put on the state. They are more focused on convicting Mr. Faust than finding out the truth and letting the evidence stay where it needs to stay. The evidence speaks for itself. Mr. Yalama-Chile doesn't have to speak for the evidence. I don't have to speak for the evidence. The witnesses can come in and present the evidence. I have a double burden on me now, right? I have to make sure this family finds out what happened, what evidence we have, but I also got to defend Mr. Faust, knowing that anytime he gets any traction, the state jumps up. Judge, stop him from doing this. Judge, hold him in contempt. Judge, we object to this. Your Honor, I just ask that we have opportunity to present this case. I respect the court, but it is hard to drag on every day knowing Mr. Yalama-Chile at any given time, just any given time, is going to jump up and make some type of objection, run up to the judge and say, Judge, he's doing this, stop him. We just want to present our case.
All right. So first of all, I think that both counsel have jumped up and, in your words, made objections throughout the case from beginning to end, and that is fine. That is what lawyers do. I don't think one side is doing it more than the other. And so I think that the record needs to be accurately reflected. So let me say that first. The second thing I do want to ask you, Mr. Cruz, is, are you asking permission? I mean, I realize that you didn't intend to ask permission, but I'm asking now, sort of in the context of what we're talking about. Are you asking permission to ask that witness, is it true that Ms. Baker did not share all the intimate details of her life with you? Is that what you're asking?
What I'm asking is the honorable court to protect Mr. Faust's right to cross-examination.
Mr. Cruz, I certainly will do that, but we are really getting into the weeds with regard to this motion. It's very necessary. So that's my question, is that are you asking to be able to ask that question?
Let me ask this question. Is the honorable court saying that I need permission to ask that question?
Well, not necessarily, Mr. Cruz, but I'm trying to get at the heart of this matter. So this is kind of where we are.
Sure.
And we have been talking about Rule 412 for days. We talked about it a lot before this trial started, and we talked about it a lot this week. And I guess I'm just going to repeat what I said the other day, but I'm just going to repeat it. When the state filed their motion and the court heard arguments from both sides about 412, the defense noticed in court orally to the state that the only person that they would seek to introduce evidence with regard to 412 was Chris Milton.
That motion is in writing, Your Honor. We filed a written motion in regards to that. And we had a hearing and the honorable court granted it.
Okay. The motion was initially by Mr. Yalama-Chile. I'm talking about the verbal notice that you gave to the state during our hearing that that's what you would do. Okay. I mean, that's That's what happened. And we discussed this in court, and you made it very clear that that was the only person you were giving the state notice for. And based on the defense's not giving notice to the state about any other persons, for us to be able to talk about whether that would be appropriate, that's kind of where we are. And so every other discussion about any other exception to 412 was prohibited. That's the prohibition, right? And I've said many times that if you, for whatever reason, felt that you needed to change your response, you could file a motion, and I would determine whether it was timely and we would hear it. And so that's where we are. The Chris Melton questions are not off the table. You gave notice to the state that you would seek to introduce evidence about the relationship of Tara Baker and Chris Melton. I mean, I think that's that's not open for a debate. And so I think and Mr. Yalman, I don't want to put words in your mouth either, but my sense of your objection is that you are, once again, concerned that the defense is trying to elicit testimony, either directly or by insinuation, that other persons' behavior or relationship with Ms. Baker could be introduced in violation of 412. Is that a fair statement, or is it something different?
Yes, Judge.
Why doesn't the judge make the argument for the district attorney? Why doesn't she? Thank you, expert architect, for your thoughts. Says, I completely understand Cruz's chip on his shoulder. This is Marjorie Taylor Greene's district. Cruz has a huge uphill battle. Love to know the makeup of the jury. All I know about the jury is there's 8 men and 4 women. I don't know anything about racial makeup. Thank you for your 10.
That's correct. The way the line of questioning was progressing, it started with a question about Ms. Baker not having a racial bias against any person. It then immediately went into the realm of intimate details about her life.
It didn't.
That she wouldn't share with anyone. And so in conjunction of those things, it seemed very clearly to me that there was at least a risk that Mr. Cruz was going down a line of questioning. Now, I think we excused the witness so that Mr. Cruz could proffer to the court what his actual questions would be, which he did not do. He just referenced that the questions were in support of something he was going to argue in closing, which I'm not asking him to give us his closing argument. It's just the direction in that these questions are going. If they're relevant for some other purpose, or I misinterpreted the direction they're going in, then I apologize, Judge, but the state is acting out of abundance of caution. Violations of 412 are serious things, and you can't necessarily unring that bell. It happened twice in opening statements. So when we see a direction that Mr. Cruz seems to be heading in, I'd like the court to take some action, either to again instruct Mr. Cruz that is not relevant or admissible. I guess relevant wouldn't be the right terminology. It's not admissible.
If you're not watching, Cruz is trying so hard not to blow his top. He's walking around. He's got his suit jacket open. He's got his hands on his hips. He sat down on the defense table. He is like, what is happening here? Are we back in 1930? What are we doing? Peace Geek, I think this is answering your question. Says, I'm confused about the 412 statute. Why is it that talking about the victim's past relationship with Melton is okay, but a possible relationship with Faust is not? That is because the state did make a motion to get into things about statements about Melton, and they brought up in their own opening that even though there was a hair found near her, buttocks, that absolutely Chris Melton and she did not have that type of sexy time, backdoor wise. They brought it up in their own opening, the prosecution did, because they made a motion, because they wanted to get into that stuff. And it's gross, and we don't need to know that it's too much information. The problem when I go to the docket right now is that I can find a lot of other Edrick Faust cases, but I can't find this one, and I don't know why. Yesterday, I was able to find it, and now I just can't seem to find it because I would like to see the papers on this 412 motion, and so that's the reason. He still could make the motion, but again, it's going to be that he's giving them his strategy, which is clearly what Mr. Yalamanchili wants him to do.
Or proper to inquire into due to his failure to notice the state. As he said before, there's no evidence to that fact. So, Your Honor, that's the basis of the state's motion in limine. And so I don't know what additional questions Mr. Cruz was about to ask, but it seemed like we were getting to the point where he was trying to skirt that line again.
Okay, and I'm going to ask you a question, Mr. Cruz, and I'll certainly let you respond. The state didn't object to the relevance of the question about whether Ms. Baker had a feeling about race relations or anything of that nature, but I understand based on the context that you're arguing that you're referring to the relevance of those questions. So I guess, Mr. Cruz, that's where the court needs to hear, I guess in terms of a proffer would probably be best. What is the reason you're asking those questions?
Sure. and I don't mind giving it to the court. I would just ask moving forward that the honorable court puts restriction on the state, because I think this is the second or third time I've had to proffer our strategy to the state. I've not once asked this court to intervene to tell me where the state was going with their examination. I do believe it violates Mr. Faust's
Let me just
rights.
answer that real quick.
Well, Your Honor, it violates Mr. Faust's rights to a fair trial.
Okay, hold on, Mr. Cruz. I'm going to let you respond, but I want to respond to something because you've used this word many times. You keep saying that the court has put restrictions on the defense and not on the state. Mr. Cruz, the court doesn't do that. The court listens to motions and makes rulings according to law, and those rulings are the restrictions themselves. And so it is a tremendous mischaracterization of what the court has ruled on and the reasons why to simply say the court is putting restrictions on the defendant. That is not appropriate. And I know that you know that. The court has heard motions. It has made rulings, which you may very well disagree with, and I certainly understand that. But the court doesn't put restrictions sort of unilaterally on any party. It listens to motions. It looks at the law and makes rulings to the best of its ability based on those motions and the law. And so the restrictions you're referring to are based on those decisions. So I want it to be clear that this court is not putting restrictions on one party over the other, but it is simply the result of rulings that were made according to law. Now,
Judge, may I?
You may.
Denied motions that they've consented to because, in my opinion, they benefited Mr. Faust. We had a motion to suppress that you denied that the state consented to.
Mr. Cruz, I want to stop you there because you know very well that is completely disingenuous.
That is
Mr.
not
Cruz, I'm talking right now.
Yes, ma'am.
You know very well that what you are referring to is actually completely inaccurate. There was, and we are not going to relitigate motions, but I certainly want to make sure you understand that I know that is not that is a tremendous mischaracterization of what happened. We had a hearing on a motion to suppress that you filed, and the state consented with the defense about one of the allegations. And this court said, that's fine. Provide the court with a stipulation and I'll sign it. I don't have any problem with both parties consenting about part of your motion. That stipulation has not been entered, and I believe that was because the defense has not provided the stipulation to the state. You can respond about whose fault that is, but I don't have the stipulation. But I also denied the rest of the motion to suppress based on the evidence and based on the law. But the one moment you're referring to, Mr. Cruz, and you know this, where the state and the defense consented about your allegation in the motion to suppress, and I supported that. You know that to be the truth.
I do not.
It is not appropriate for you to continue making a statement that is false.
That's the truth, Your Honor. The same day we received the order denying it, we didn't have opportunity to put a stipulation in because after our motions hearing, either that day or the next day, the honorable court issued an order denying all our grounds for the motions.
Mr. Cruz, that's not accurate. I would have accepted any stipulation because I ordered you to provide it to the court. And if both parties still want to give it to the court, it'll be part of the record. It is on the record. It is on the record that will be transcribed. And so that stipulation has been entered and approved by the court, even though it's not in writing. But it has been authorized. Let's move on. And if you would proffer for the court what it is you are seeking to admit, I can make a decision as to whether it is relevant and whether it is admissible. I just don't know what you're trying to do.
The state had opportunity to present the testimony of Miss Lauren Sherling. Ms. Sherling came in and testified, and the state elicited this testimony that there were no issues in the relationship with Chris and Tara. Based on, I think the state explicitly asked this question, based on what Tara told you, what was her, I'm paraphrasing, but pretty much what was the nature of her relationship with Chris Melton and, what was the nature of the relationship between Chris Melton? Please forgive me, Your Honor.
All right, wait a second. Who's Lauren Sherling? Was this one of the people that they've voir dired before the trial started? Because unless I was sleeping most of the day yesterday when I was sick, but Lauren Sherling has not testified yet in the trial. Yeah. Thank you. Remind me.
Chris Melton and Tara Baker. And her testimony was that it was good. The line of questioning that we are going down to separate Mrs. Ashley P.V. Hall, who is actually her best friend, not Miss Laura Sherling. Mr. Sherling, I think, knew her for 6 months, is that Ms. Baker, one, and we elicited this when she was testifying, one, she wouldn't talk bad about Chris to other people because she didn't want to make Chris Melton look bad. So Ms. Sherling, who was a 6-month friend, I tell you, I hate to even have to share this because this is what we talk about in closing, but I'm following honorable court's order. Ms. Sherling, who was a 6-month friend versus someone who went to undergraduate with this young lady and who says, hey, these aren't things she would tell people, is exactly what we're using to build our defense in Mr. Faust. It is extremely important if the state wants to bring a witness in here and have them testify to something, that we're able to rebut that. Our position is this, Your Honor. We have the same evidence. I have introduced nothing new. So when the state calls me disingenuous, and I took that I couldn't believe it. When the state calls me disingenuous.
Wait, was Lauren the friend who she was supposed to call her when she got home? Thought I would remember her name. Okay. Yeah, maybe. I was really sick that day. Maybe that was the one that she went to the library with the night before, and then she was supposed to meet her for drinks. Because I know they also did some voir dire of some witnesses before the trial started that I did not watch because I wanted to come in as a juror. A juror.
But they have all this evidence that they're excluding. They don't want the family to see. They don't want the jury to see. And we have to present it. And then when we are presented, they come up to the judge and say, Judge, he should preview where he's going. I believe it's 412, but I don't know if it's 412. That is an issue, Judge. It is hamstringing Mr. Faust's defense.
Okay.
The only thing we ask is the court says, hey, state, do your job. If you want to prosecute.
I'm sorry, no. Her name is Catherine Lonstein. That is not the girl. That is a different, this is a different girl that we haven't heard from yet, I believe.
Mr. Faust, present the evidence. Don't come at the attorney. I've had personal attack after personal attack from Mr. Yalomachili, and I have never gone out of my way to say anything ill about Mr. Yalomachili. Even when I see him in the hallway, I speak to him, I'm polite, but I know when we come in court, at some point, Mr. Yalomachili is going to get up and accuse me of something or either ask for me to be held in contempt. Your Honor, we're just asking to present the case. That is the basis of our questions. We just want a sole sentence and sole argument that says that Tara Baker does not share the intimate details of her private life. So when the state does their closing and they say, well, you heard from Ms. Sherling that the relationship was great, we would have put testimony into the record that, hold on, don't listen to that. This is her best friend, and her best friend is saying Tara Baker was a private person. That's where we're going with our line of questioning, Your Honor. But I would ask in the future that the Honorable Court, if they have a lawful objection, even if they want to make an unlawful objection, they just do it in their place. If it's an issue that the Honorable Court feels, if I'm doing something wrong, Your Honor, you are the power in this courtroom. You are the ultimate power in this courtroom. If I'm doing something wrong, Mr. Yalomachili isn't the one that has to get up and say it. You could tell me. You can say, Mr. Cruz, that is inappropriate. Mr. Cruz, you can't have that line of questioning. When the court gets involved for Mr. Yalomachili, it's when he has a lawful, or if he wants to, an unlawful objection. But an objection. That's all I'm asking, Your Honor.
Praise be.
But that is the proper in regards to
Under her eye, everyone. Did the chat just freeze for everyone else or just me? Under her eye.
the reason for that line of questioning.
Okay, okay, thank you. I'm still, I still don't have my question answered. So I'm going to ask you some
Please
questions.
forgive me.
All right. Well, I mean, there's a lot going on. And so, but I need to be able to address
Sure.
state's motion. All right. First of all, with regard to the objections from both parties, it is easier, of course, to handle objections right from your place. But both parties have asked to come up to the bench a lot. I'm okay with that, given the kinds of objections you all are making. I know that there are certainly things you don't want the jury to hear, and I am not.
Maybe the witness.
There are some rulings I want to make that I do not want the jury to hear all of the things that I say, because I think that would not be helpful to either party. And so if you want to continue asking to approach the bench, I'll entertain it. If you don't want to do that, that's fine. I mean, I'm going to leave that up to the attorneys.
It did freeze for a minute, right? It wasn't just me.
What I don't understand,
Right after
Mr.
this
Cruz,
is over, we're
this.
going to court.
The issue with Mr. Melton is different than I think Mr. Yalomachili's motion. Mr. Yalomachili's motion alerted the court again to a line of questioning that would seek to admit testimony about other people. Quite frankly, that's it, other people. And that is my question for you, Mr. Cruz, is the line of questioning that you said about whatever the statement was, and I didn't write it down, about race relations and about
Race relations.
that's what I need to know. Is, and I think, you know, that is what we're talking about.
That is fair.
When we're talking about
That is-
412.
That is fair.
Go ahead.
So a part of my examination of Miss Ashley P.V. Hall, something that I found that it was very important to do was to show how great of a person Ms. Baker was. I've read this entire discovery file. Me personally, and I'm not a witness in this case, she was, from what people said, she was a really kind and amazing person. She was assertive. She was straightforward. She didn't have any biases. I am just, and I said it to the witness, I said it to the honorable court, let's talk about Ms. Baker's life. I said it in opening. That's all I'm doing, Your Honor. But they've taken me talking about Ms. Baker to say, well, Judge, he's going down this line. Anything I've said.
Well, I need you to answer my question.
Sure.
Cruz.
It's about who Ms. Baker is as a person. The state has not tried to present Ms. Baker as a person during this entire trial. They focused on trying to make him into a person guilty of her murder. My job is.
Praise be. It's about the victim. Praise be. I've never heard a defense attorney say this before, really. Have you? Have you ever heard this before? His passion for the victim? He wants the jury to know about her. What has the prosecution said to get anybody on the jury to know about Tara Baker? No, they don't care. They just want the conviction. Listen.
Question.
Sure.
Cruz.
It's about who Ms. Baker is as a person. The state has not tried to present Ms. Baker as a person during this entire trial. They focused on trying to make him into a person guilty of her murder. My job is twofold, as I mentioned, Your Honor. I want the family to know the truth of what happened to their daughter, and I also have to defend this gentleman here. And if the jury believes he's not guilty, let him go home.
Okay, Mr. Cruz, I understand all that. I do. You've said that many times. I understand that it's your position, but you haven't answered my question. And this is what I need to know. Very specifically, Mr. Yalamanchili's motion, his objection, which he has made many times since we started, were objections to either statements about other people or statements that appear to lead to that line of questioning. That's my question for you, Mr. Cruz, is
That's very vague because they've taken a question about Ms. Baker and turned it to a 412 argument, Your Honor. So maybe I'm not understanding the Honorable Court's question. I thought the Honorable Court was asking me to explain the purpose of the question about her racial.
I am.
Correct.
I'm not getting the answer. That's why I'm keeping
The answer to that question is through Ms. Ashley P.V. Hall, her best friend, one of our goals in this examination is to show the jury who Ms. Baker was. We talked about her being a law student. We talked about her being ambitious. We're giving them a profile. The state hasn't given anybody a profile about Ms. Baker. I have to, but I'm doing it. This is a 24-year-old, 25-year-old cold case. I don't think Mr. Faust is just a victim. I don't think Ms. Baker is just a victim. I truly feel the family is a victim too. So what I'm doing is at least, okay, jury, this is what you need to know about Ms. Baker. We're going to have a time where they get to know about Mr. Faust, and then we're going to get into the prosecution. We're getting into every aspect of this case. So in regards to your particular question of why we asked about race is to give the jury a piece of a profile to Ms. Baker. We asked about her education. We asked about her ambition. We asked if she was goal-driven. We asked about her personality. Was she assertive? We even asked about their relationship. Did you two?
I think the family is a victim too. Karen, you're right. Cruz is not trying to be disparaging about Tara. He's trying to get to the truth about what happened to her.
But I don't understand, and maybe it's just me, how we get from he's talking about Ms. Baker to he's talking about her character under under Rule 412. I'm flabbergasted. My mind is blown. I don't even know how we get to this point based on the questions that I'm asking.
Mr. Cruz, let me ask you this. Why is your question about how Ms. Baker felt about race relations relevant?
Because Ms. Ashley Peavy told the detective that everything that she told the detective about Ms. Baker, we're introducing. That honorable court.
What are you asserting she told the detective about that?
That she wasn't, she had no racial biases. Okay. Is that, and maybe I'm wrong, Your Honor, is that sexual? Am I being inappropriate by my line of questioning? And I think that's what Mr. Yalamanchili is bringing up to the court.
Well, okay. Now I understand what you're saying. I'm going to let the state respond, and then I'm going to respond. Mr.
How dare you
Yalamanchili,
insinuate that she might have had a relationship with a black man? How dare you insinuate that? And that's not even what he's doing. How dare you insinuate that this white girl would have had a relationship with a black man and her bestie would not have known about it? You should be outraged by this. You should be.
Have gone through this moment, and there's been a specific comment about a statement that was made in an interview.
Right. Well, it's not a question about race relations and the fact that Ms. Baker was not racist. I mean, that's not the issue. The issue is immediately thereafter.
Mr. Cruz, I'll let you respond. You got to let Mr. Yalamanchili speak too.
He just
can't have two people talking.
It's immediately thereafter.
He just like sat down in his chair. He's like, I'm done. I don't know if this is where he talks about communist Russia or if that was before this, but Mastermind 13 says, I think I'm a little in love with this defense attorney.
Was not racist. I mean, that's not the issue. The issue is immediately thereafter.
Mr. Cruz, I'll let you respond. You got to let Mr. Yalamanchili speak too. You can't have two people talking.
Immediately thereafter, Mr. Cruz went down a line of questioning with no segue, no change in topic or anything like that, saying, would Ms. Baker share the most intimate details?
He doesn't need to segue. He doesn't need to change topic. He doesn't need to tell you what he's doing. He can talk about one thing in one question and something else in his next question. He doesn't need to run his line of questioning by you, Mr. District Attorney Yalamanchili. And I motion to call him Yamalama Ding Dong. Okay? I'm going to call him Yamalama Ding Dong. He doesn't need to run it by you. He's allowed to go from subject to subject, from topic to topic. He can do whatever the hell he wants. It's his cross-examination, not yours. And just because you don't like it, or you think he might be going to a place that you don't like, does not give you, I can't anymore. I can't. Do you want him to give you a script of what he's going to say?
Of her life. And then aren't there things that Ms. Baker would never tell anyone, even if she did them? Was essentially the question.
Okay.
paraphrasing just a little bit.
That is a
And
paraphrase.
Mr. Cruz is headed down that line of questioning, which seems to go down lines of questioning that try to toe the line around Rape Shield and create the impression that Ms. Baker may have engaged in some other types of relationships that Mr. Cruz would like to put in the jury's mind without following the appropriate procedures. And I mean, as the court says, asking the parties to follow what the law requires is not handcuffing anyone. It's just applying the law to these proceedings. I would also note that from a relevance perspective, because someone told the police something doesn't make it relevant or admissible in court. So I would respond in that way to that.
Okay. You wanted to say something, Mr. Cruz?
If I may, just to, I guess, kind of summarize things. I hear where Mr. Yalamanchili is coming from. I believe that first, he has not made an objection to anything that Mr. Cruz has.
And this is the second, this is co-counsel. This is not Mr. Cruz. This is his co-counsel who is now like, okay, I'm getting up. He reminds me of the guy from the Mod Squad, right? Gen Xers, you'll know what I'm talking about. And he's like, okay, I could see Ahmad is a little upset right now. I'm going to get up and try and diffuse the situation here. Here you go.
If I may, just to, I guess, kind of summarize things. I hear where Mr. Yalamanchili is coming from. I believe that first, he has not made an objection to anything that Mr. Cruz has actually said. I want to note that at first. Secondly, I will like to note that it seems, so any comments or questions that have been asked about her intimate life at this point, her intimate life can entail a number of things. It could potentially include sexual things, but it could also include things that are not particularly sexual. At this point, I do not believe that Mr. Cruz has asked any questions that have actually been objectionable. So any objection at this point, I do think would not be right. If Mr. Cruz does get to a question that is objectionable, I think that then Mr. Yalamanchili's objection would be appropriate. But at this point, I do not believe that Mr. Cruz has made an objectionable statement or asked an objectionable question. So I would respectfully ask the court to deny his request. And Mr. Cruz, I think through this conversation, is reminded of the court's admonitions around 412. And I'm sure he will be mindful of that as he proceeds moving forward. But at this point, I do not believe that he has asked anything objectionable. And if he does, then the state can make the appropriate objection.
Thank you. Is it Hall or Hill?
Hill.
Thank you, Mr. Hill.
Mr. Hill.
All right, Mr. Cruz, anything else you'd like to tell
Mr.
the court?
Hill.
I just don't know what to say, Your Honor. Our cross-examination was stopped just for Mr. Yalamanchili based on his belief that this was a 412 issue. Another thing I would say, Your Honor, is Mr. Faust doesn't feel protected in this courtroom. I don't feel protected in this courtroom. And I feel that the Honorable Court has been leaning extremely favorable to the state. I've been nothing but respectful to the Honorable Court. I've been nothing but respectful to Mr. Yalamanchili's case. Anytime I've approached the bench, it's been because there were sensitive issues that I did not want to address to the jury. I've never once approached the bench and say, Judge, I think they're about to do this. Let me stop them and let me send the jury out. The only thing I'd ask, Your Honor, is Mr. Faust is on trial. Constitutional protections apply to Mr. Faust. Mr. Faust has the right to effective assistance of counsel under the 6th Amendment. He has the right to cross-examination under the 6th Amendment. He has the right not only to effective assistance of counsel, but his choice of counsel. Your Honor, right now, we don't feel this trial is fair. I'll just say my place. I do believe the Honorable Court is going to grant his non-objection, so I'm sure I won't be able to ask these questions, and I'll make do with whatever I'm allowed to do. But Your Honor, I respect this Honorable Court. I would just ask, there's a gentleman here fighting for his life. He is fighting for his life. He has no hope. You're his only hope. We're just asking that we have opportunity to present our case. And if Mr. Yalamanchili has an objection that he needs to make, just make the objection. And if the Honorable Court...
He's fighting for his life. Is this for the media? Maybe a little bit. Is he really that passionate about it? Maybe 100%. This man is fighting for his life.
Finds that it's lawful, stop it, and I'll stop it. That's all I ask, Your Honor.
All right. Thank you, Mr. Cruz. All right. So with regard to the objection, I think what we're going to do is we're going to put the witness back on the stand. And Mr. Cruz, you may ask her the question that you proffered, which is something about, did she share everything with you about her personal life, right? The motion in limine that the state is asking the court to grant has already been granted. I have already granted that motion in limine, and I've talked about it several times. And so you just need to be aware, Mr. Cruz, that you cannot go forward after that question with any insinuations, for example, which I think is what the state is probably concerned about, insinuations about other persons. You can't do that. That would be a violation of the motion in limine that has already been ruled on in this case. It was ruled on again several days ago, but
Here's the problem, okay? Maybe Tara Baker did have a relationship with not a mod Cruz. Maybe she did have a relationship with the defendant, Edrick Faust. Maybe it was a, one and done. Maybe it was a one-night stand. Maybe it was something consensual, like a couple days before. Maybe. But the only way to get that in is by him testifying, and he's got a Fifth Amendment right not to testify, right? So he's trying to get the roommate to say that she was not biased. She might have had a relationship with a black man. It wouldn't... And he is handcuffed. Should he make the 412 motion? Yes. Please make it. Please make it.
It was also ruled on. We had
But based on the prior rulings of this judge, it would probably be denied anyway. And you're right. He didn't even say anything. And why is Mr. Yamalama Ding Dong making the arguments when he's not the attorney who's been questioning that witness? This judge, it's like a free-for-all here. It's like a free-for-all in a kangaroo court.
412 motion. So I'm not going to redo a motion in limine. It is already on the record. I will certainly hear any objections outside the presence of the jury. We've been doing that the entire time.
Yada,
I'm
yada,
not going to, order that you all argue your motions.
And then pretty that much, that's how it ended yesterday.
Aren't you when I said there's for them?
Blah, blah, blah.
Yes, sir.
I'm clear. I think you asked me if I was clear. Yes, ma'am.
Okay. Any other questions? All right. We're going to adjourn, and I will see you all tomorrow morning at 9 o'clock. Thank you.
All right. So now we're going to move to today, which is day 4. But before we do that, let's go to the chat. But I thought it was very important to watch that portion of yesterday because the first witness on the stand today is going to be the same witness, Ashley. So we will cover that now. Courtney says, I'm not saying he's wrong, but the judge sends the jury out every time he objects, a lot, rightly so. You meaning Mr. Cruz, right? Is that bad for the defense, unbiased jury or not? No, they probably don't mind going into the jury room and getting a snack, and there are certain things that the jury should not be there for. So I don't really think it's a problem. And I think the jury room is very close by because every time they call him back in, they get there very quickly. Thank you, Courtney, for your 5. I appreciate you so much. Julie said, I tried watching this yesterday, but I stopped. It just wasn't the same without your commentary, Mel. Glad you're feeling better. Oh, thank you so much. I appreciate you so much. I'm still not 100%, but we're getting there. Thanks for your 10 on top. Thanks for your super sticker. As always, R3639 says, the way that judge smacks her lips at the end of a sentence when dressing down Attorney Cruz is bringing up a rage in me that I will need to discuss with my therapist. Thank you for your 10. Don't make me laugh because I'm going to cough. New Hampshire woman says, Rage Crochet Club. Let's get busy. We have a Rage Crochet Club here. You guys are amazing. Thanks for your 5. For Stitches and Giggles says, the judge's lip smacking when she's talking to Cruz is infuriating. She doesn't do that with prosecutor Yamalama Ding Dong. Very condescending. You guys are hearing that more than I am, or maybe we have more misophones in the chat than I realize, or maybe it's because I have headphones in and I don't really hear it. But I don't hear it as much as you guys seem to hear it. Thank you, Ruth, for buying 3 matcha lattes. I appreciate you so very much. I'm going to need them today and all the days. Thank you so much, Elaine. I will check on that for you as soon as we get back into the feed. But I saw you a couple of times, so I'm not sure what that means. And I can't check on that right now. Okay. Let us go back to let us get to today's feed anyway. On law and crime. One moment. And this way we'll be able to fast forward through all the breaks and stuff like that. Okay. All right. I guess Court TV is not covering this on their YouTube, are they? Not that I want to watch. I don't want to watch them anyway. It's too busy. Their feed is too busy with all the stuff on it. All right. So we are going to go back to this morning where Ashley is still on the stand. And we may speed it up a little bit so that we can try and get through the day. Are you ready for it? Okay, moving on. And now we're on day 4, but this is from this morning. And we know that the volume is okay.
We're ready to resume the trial in the state of...
No, I don't want that.
Georgia versus Edrick Faust, SU 24CR0547. Is the state ready to proceed?
State's ready, Your Honor.
Is the defense ready?
Yes, ma'am.
All right, thank you. State may call.
What? Why is what? I don't understand what's happening here. Come on, man. Oh, go away. Okay, there we go.
Call their witness, and we have a continuing witness, I believe, from yesterday. Is that correct?
Ashley Hall.
Thank you. If you could get Ashley Hall, please.
PV Hall, how are you?
I'm doing
Yes, ma'am. Good morning, Mrs. PV Hall, how are you?
well. How are you?
I'm doing okay. Thank you so much for asking. Between us breaking yesterday and you testifying now, has any attorney spoken to you about this case, your testimony?
I talked to the DA this morning for a little bit.
Okay. Your Honor, I have a motion.
Oh, really?
All right.
Already?
Ladies and gentlemen, I'm going to have you go back into the jury room. I'll see you in a moment. Please don't discuss the.
Oh, really? The DA spoke to her this morning. Okay. All right. Neither side is supposed to speak to any witness while they are under oath
Sharon, before we
and actively on the stand.
Y'all may be seated.
This is wild already.
Yes, sir.
Sharon, before I get into the motion, may I ask Mrs. PV Hall some questions about the conversations that she had with
She's
these?
still there.
Can you tell the honorable court about your discussions with the state?
He was just reassuring me about coming in today and said I was okay from yesterday and just I keep telling the truth like I'm doing.
Okay. Did he talk to you about your testimony in any way?
He just said I did a good job. That's all.
Okay. Did he say anything about how you should answer my questions?
He did not. He just said just be truthful like I've been doing.
Okay. Did he ask you to review anything?
No.
Okay. Excellent. And if I haven't asked you a specific question, just in general, well, specifically, excuse me, who spoke to you? Let me ask that question.
Kristen.
Okay. And what did Mr. Bowden say exactly?
Objection, asked and answered.
Sustained.
Okay, sure. Based on what Mrs. PV Hall has stated, the only thing I would request at this time, Your Honor, is just to instruct the state that once a witness is under oath, neither party, myself or the state, is to speak with them in any manner until they finish their testimony or before the testimony starts.
Thank you. Any response from the state?
I'm not aware of any rule that prohibits that. So I don't know what the basis is.
Well, I agree with the state. There isn't any rule that prohibits what you have elicited from this witness. I think both parties realize they can't talk to a witness about their testimony in any specifics in that way. That has not been shown, so I'm not going to give that instruction. I think both parties are aware of the law. All right. Thank you. If you'll bring the jury back up.
This is gaslighting. She's not aware of any rule. Okay. Yeah, you're doing a great job. Just keep up the good work. Keep up the good work. Keep telling the truth. Some states asking their witness to tell the truth is witness intimidation, specifically Massachusetts.
Please, thank you.
Is my volume modulated? Because my ears are so clogged I can't tell.
Discussing,
Or is
Ms. PV Hall, I believe we left off.
is court much louder than I am? Let me go back to regular. Hold on.
Yesterday,
Is that better?
just discussing
Test.
how Ms. Baker
Test.
was with intimate details about her life. I believe we left off yesterday. I think the last question that I asked you is that when you're speaking to law enforcement, you said that there were certain things that Ms. Baker wouldn't share with anyone. Is that correct?
That would be correct with regards to her relationship. That would be something between her and her partner.
And is it fair to say that Ms. Baker was not the type of person to share really intimate?
Court's much lower. Okay, let me boost it.
And private details about her life?
When it came to her partner, yes.
Is it better?
Ms. Baker was with.
Get back.
All right, you all may be seated. Thank you. Mr. Cruz, you have the floor.
Yes, ma'am. Ms. PV Hall, I believe we left off yesterday just discussing how Ms. Baker was with intimate details about her life. I believe we left off yesterday. I think the last question that I asked you is that when you're speaking to law enforcement, you said that there were certain things that Ms. Baker wouldn't share with anyone. Is that correct?
That would be correct with regards to her relationship. That would be something between her and her partner.
And is it fair to say that Ms. Baker was not the type of person to share really intimate and private details about her life?
When it came to her partner, yes.
Now, would you agree that Ms. Baker was a down-to-earth person?
Yes.
Outgoing,
Yes.
fun, funny?
Yes.
Okay. She was in a sorority?
Yes.
And even while in law school, which you would agree is very tense, is that correct?
Yes, I agree.
She would still find time to go out, have cocktails, hang out with you?
Not very often. Like I said, we were extremely busy at that time. We might try to get to a Georgia game, but it's definitely not like what undergrad was like at all. You might see a friend real quick after class, but you don't go out like you would in college.
I believe your exact statement to law enforcement was you leave class, get a cocktail, then go home and study. Is that fair?
Not every day, but sometimes.
Ms. Baker also had a friend circle. Were you aware of a friend circle?
Yes.
Okay. And there were times when Ms. Baker would go out with a gentleman by the name of Steve, who was an attorney.
Well, she would go out with the law office, and Steve was part of that.
Okay. And Ms. Lauren Sherling as well.
Yes.
Had Ms. Baker spoken with you about Steve the lawyer?
She did.
Mr. Cruz, why is that relevant?
Just discussing her friend group, Your Honor.
All right, I'm going to overrule the motion and allow you to continue, Mr. Cruz.
Yes, ma'am. And I believe you stated this on direct, but I just want to make sure I'm clear. So just to make sure I'm 100% clear, the day before Ms. Baker's passing, which would have been the 18th, you were leaving home for the night. Is that correct?
Yes, that is correct.
And you informed Ms. Baker that you would not be home that night. Is that right?
I did.
And you stated that she began cutting up, saying she was going to be alone for the night. Do you recall making that statement?
Yes, we were sitting there just talking and cutting up about the week and what was coming up that weekend. So, yes.
Is it fair to say?
Wait, she began cutting up? I don't know. I don't know what that means. Is that a Southern term? She began cutting up about what she was going to do over the week. Hold on, I got to hear that again.
That you would not be home that night. It's 100% clear. The day before Ms. Baker's passing, which would have been the 18th, you were leaving home for the night. Is that
Yes,
correct?
that is correct.
And you informed Ms. Baker that you would not be home that night. Is that right?
I did.
And you stated that she began cutting up, saying she was going to be alone for the night. Do you recall making that
joking.
statement?
Yes, we were
Joking.
sitting there just talking and cutting up about
Okay, cutting up means joking. All right, thank you. Joking, chatting. Okay, cool. She was happy she had the house to herself. In other words, got it.
the week and what was coming up that weekend. So, yes.
Is it fair to say that Ms. Baker being home alone that night was a big deal to her?
I wouldn't say that was a big deal to her. I think she was just cutting up just since we were all leaving. She was just excited. She had things to do. She was going to the law library to see her friends or to
Excited.
study. We've all been alone in that house at some point. It was not unusual.
Is it true that you heard Ms. Baker ask Chris to come over that night after finding out that she was going to be home alone?
She asked, but she knew with his job that it was probably not likely. And so she was not surprised when he could not do it.
Thank you.
Oh, she asked Chris to come over that night. Remember, he changed his story in 2024, like I told you. Oh, my freeze game is on point. Listen to that again. Y'all was cutting up, Bo.
And cutting up about the week and what was coming up that weekend. So, yes.
Is it fair to say that Ms. Baker being home alone that night was a big deal to her?
I wouldn't say that was a big deal to her. I think she was just cutting up just since we were all leaving. She was just excited. She had things to do. She was going to law.
Who did she tell that she was going to be alone? Because if you got two roommates and they both have boyfriends, you have a boyfriend, the house is always full of people. You never get any alone time with your boyfriend. Now we're getting somewhere.
Library to see her friends or to study. We've all been alone in that house at some point. It was not unusual.
Is it true that you heard Ms. Baker ask Chris to come over that night after finding out that she was going to be home alone?
She heard Tara ask Chris to come over that night. She heard it.
She asked, but she knew with his job that it was probably not likely. And so she was not surprised when he could not do it.
Okay. Thank you. After Ms. Baker's passing, you returned to the Deer Park home to gather your belongings.
I did.
And when you returned home, none of your jewelry was missing.
Nothing was missing in mine. No,
Your jars had not been rummaged through?
nothing. Only the stuff you can tell from the firefighters.
Yes, ma'am. And is it fair to say that you had numerous items of value in your bedroom?
Yes.
Ms. Phoebe, do you remember the layout of your Deer Park home?
I did.
Okay, you had your own bedroom and you had your own bathroom. Is that right?
That's correct.
And you and Tara, it's probably clear, so forgive me, I just want to make it clear for the record, but you and Tara did not share the same bathroom.
We did not share the same bathroom.
And you had your own toilet, shower, and bathtub.
Correct. But her bathroom did have the door open to the main room.
Say that again?
Her bathroom had the door open to the main room.
So she could actually
Go
walk
through.
through her room and then go in her bathroom.
Yes.
On January 25th, 2001, Mr. Melton came to your home. Do you remember that?
Again, this was 25 years ago. I'm sure it happened.
Okay, January 25th would have been almost a week after the murders. Chris went to her home a week after the murders.
And would you agree Ms. Baker was killed on January 19th, 2001?
I would agree to that, yes.
So you would not disagree that Mr. Melton was at your home within a week of Ms.
No,
Baker?
I would not disagree to that, no.
Do you remember on the day that he arrived to your home, he called a woman by the name of Miss Leah Tucker?
I do not.
Was seeing a summary of your statement to law enforcement refresh your recollection?
That's fine.
Court's indulgence.
Oh yeah, let's see her statement from 2001. We heard in openings that he was going out double dating with other people within a week of Tara's murder. Hello, we have a Cardi B emoji for that.
So I'm showing you what is going to be marked as Defense Exhibit 22. And I'm showing you this for the purposes of refreshing your recollection. If you would, please look at page 2, paragraph 2, sentence 2 and 3.
Okay.
Your Honor, I just would ask Mr. Cruz to show me the exhibit before he shows it to the witness.
All right, that's appropriate.
Yeah, Mr. Bolton really doesn't want this out. But that is proper. He's got to show him the exhibit before he shows it to her. FF.
And again, Mrs. P.B. Hall, page 2, paragraph 2, sentence 2 through 3. You can just read it silently, okay?
Okay.
Yeah, we want to know if she saw his hands all cut up.
Okay.
Okay. Do you recall making that statement to law enforcement?
I do.
And that phone call to Ms. Leah Tucker occurred after 8:15 p.m. at night. Is that correct?
I did not see that on there, but
That is going to be paragraph 1 and 2.
okay.
Full paragraph 1,
Mhm.
paragraph 2, sentence 2 through 3.
Yeah, I read that, but yes. So some around, I think on there it says sometime around 8 to 8:15. But yes, Leah Tucker was a cheerleader with him at Georgia College, and they were just really close friends at the time. She was seeing someone as well.
Yes, ma'am. And Mr. Melton set up a dinner with her for 5:30 on Friday, January 26, 2001. Is that correct?
I do object again to relevance.
Ms. Cruz, care to respond to the objection?
Yes, ma'am. It goes to the evidence that we presented in our opening about Chris Melton's actions after Ms. Baker's death.
Okay, I'm going to overrule the objection. You may continue.
That's right, it does.
Repeat your question, please.
Yes, ma'am. Please forgive me. Mr. Melton set up a dinner with Ms. Leah Tucker for 5:30 p.m. on Friday, January 26.
Okay.
Is that correct?
That's what it says in the statement. Yes, correct.
And we would agree this is at a week after Ms. Baker's death. Is that correct?
That's correct. But again, at this time, we were all reaching out to all of our friends and the people that cared about us at this time.
Girl.
Yes, ma'am.
Girl,
And a follow-
girl,
Here as well.
girl, why are you protecting Chris Milton? Why are you protecting him? This dude is going out trying to get some 1 week after your best friend is murdered, and you told the police this, and now 25 years later, you're trying to say that it was totally normal that we were all reaching out to our friends? He was a cheerleader, she was a cheerleader, no big whoop. Now it's no big whoop. Wow.
I'm sorry.
She knew Tara as well.
Yes, ma'am. The next day on January 26th, Chris called a young lady by the name of Holly Hufford from your home. Is that correct?
That's correct.
And Chris set up a 1:30 p.m. lunch with Ms. Holly Hufford for January 26, 2021. Excuse me, 2001.
Okay.
Is that correct?
That sounds correct.
Well, not if it sounds correct. Is it correct? Do you recall making a statement based on the summary of your?
From what you have in front of me, yes.
Now,
I mean, from what home? Because I'm going to assume a week after they could not move back into that house. We saw the pictures of it. That house was burned to a crisp, pretty much, right? The living room was charred. There was no way that she had to move out and move somewhere else. And now Chris, her best friend's boyfriend, who was just murdered a week before, is at her new place, wherever she is. And making dates.
Ms. Peavy, Chris actually went to lunch with Ms. Hufford, right?
Yes.
And you know that because you joined Chris at the lunch with Ms. Hufford. Is that correct?
I don't remember that, but I'm sure I did.
If you'll look at page 3 of that document, we're going to start at paragraph 2, the first sentence. And after you read the first sentence, look up and I'll direct you to the next portion of that.
All right. Say that one more time.
Yes, ma'am. Page 3,
Yes.
paragraph 2,
Mm-hmm.
the first sentence. Well, don't read it out loud. Just to refresh your recollection, you can read it to yourself. And after you read that sentence, look up and I'll direct you to the next sentence.
Okay.
All right. If you'll go to page 4 and read the 3rd through the 4th paragraph in full.
He must have done a lesson last night on refreshing recollection. I love it. Because now he's not getting any objections. Right. He didn't have any male friends to help him grieve.
All right. Is it correct that you joined Chris at lunch with Ms. Hufford?
Yes, it says that my husband, Chris Hall, and I joined him.
Yes, ma'am.
Oh, okay.
And during the lunch, you told law enforcement that
All
Chris was
right. You're married to this guy, other guy now, the other Chris, 2 Chris's and 2 Halls. You're married to this guy, Chris, now. Is he still good friends with Chris Melton? Asking for a friend.
flirting with Ms. Hufford. Is that correct?
Wait, what?
Lunch with Ms. Hufford?
Yes, it says that my husband, Chris Hall, and I joined him.
Yes, ma'am. And during the lunch, you told law enforcement that Chris was flirting with Ms. Hufford. Is that correct?
Chris was very flirty to anyone he spoke to. That was just his personality type.
So is that a yes or a no?
I guess that was a yes, but he didn't mean it in any way that you would call being flirty. That was his personality.
Well, not what I mean. Were your words that?
Yes, those were my words.
And during lunch, Chris was also gently rubbing Hufford's lower back.
He might have been. Again, this is
Wow.
25 years ago.
Sure. Would reading a summary of your statement refresh your recollection?
Probably would.
Yeah.
You go to page 5. And starting at the last paragraph to the top of page 6. So start at page 5, last paragraph. Read that paragraph to the top of page 6.
Was he rubbing the girl's back to comfort her? Did she also know Tara? The good glow says she wants to protect Chris more than she wants justice for Tara.
No, at the time, you have to remember I was very protective of Tara. She was my best friend. And
now I'm
even
not.
when I met Tara, Tara met my now husband, she didn't even like him. We're very protective of each other. So Chris, even just talking to another girl.
Hold on. Now comes the time. Comes a time when the blind man takes your hand, says, "Don't you see?" It's a Grateful Dead song. Now I'm going to normal speed because now we're going to see her shaken. Shooketh. She shooketh. Okay?
Those were my words.
And during lunch, Chris was also gently rubbing Hufford's lower back.
He might have been. Again, this is 25 years ago.
Sure. Would reading a summary of your statement refresh your recollection?
Probably would.
If you go to page 5. And starting at the last paragraph to the top of page 6. So start at page 5, last paragraph. Read that paragraph to the top of page 6.
She's got pearls on. She might want to clutch them now.
No, at the time, you have to remember I was very protective of Tara. She was my best friend. And even when I met Tara, Tara met my now husband, she didn't even like him. We're very protective of each other. So Chris, even just talking to another girl in my emotional state was the reason I was upset about him talking to any girl.
But 25 years later now, you're going to brush it off like it was no big whoop. Her face says everything. Her voice is cracking. And I hope the jury sees this like we do.
Yes, ma'am. My question is, during the lunch, was Chris gently rubbing?
Yes, he was gently rubbing her back.
She won't even let him finish the
And
question.
when you and your husband,
He was my boyfriend at the time, yes.
yes, ma'am. When you and Mr. Hall left, Chris continued to hang out with Ms. Hufford. Is that correct?
Yes.
May I approach you to retrieve that exhibit?
Yes.
Is that okay? And I still have free reign, Your Honor.
You?
Thank you. Those are my questions. Thank you so much for your patience.
Well
You're
done. Well done.
Any redirect, Mr. Bolden?
Very, very briefly.
Go ahead.
Ms. Hall, there are a couple things I neglected to ask you yesterday.
Okay.
Are you aware generally with how the fire started?
Okay,
at
no.
160
Okay,
Fawn
no.
Drive?
That's not. I'm sorry. Am I living in the Twilight Zone? Redirect should be based on what was elicited through cross. You don't get to go back to things you forgot to ask during direct. Am I losing my mind? Is Georgia another one of the land of the lost type states? Hold on here. This should be outside the scope, okay? He's going back to the fire.
With how the fire, are you aware generally with how the fire started at 160 Fawn Drive?
Yes, I am. They actually had me walk the scene that next day, or the day. And with walking, I noticed by the oven there were some fibers. It looked to be from, we realized it was from, I had a cream chenille blanket that was on the back of the chair that was next to Tara's door. And they had used that to start the fire on the oven.
Hey,
And we still saw.
I also neglected yesterday afternoon to ask you about the clock in Tara's room. Were you familiar with that clock?
Yes, it's a new clock, but it looked like an antique. It was a little, I guess, like a wooden stand clock with just a little clock face.
maybe he wants it in for
And
some reason.
To the best of your knowledge or recollection, was that clock functional?
Yes, it was brand new. Even she likes things that looked old, but this was a brand new object.
Yeah. She's walking the crime scene the next day, Scott.
Then my last question, Ms. Hall, is do you remember in the days following the fire and Tara's death, providing samples of your hair to law enforcement?
Yes, I mean, we would do anything they asked us just to make sure they could proceed and find out who did this to our friend.
Right, but you went
Thank you,
on
ma'am.
double
That's all I
dates
have.
with her boyfriend.
Any
Did you
recross,
just-
Mr. Cruz?
Did you discuss this in your morning chat this morning? Helen wants to know. In your morning chat this morning, did you discuss this? There was an expert yesterday, a fire expert, who came in and testified. He did some experiments on a stove about a year ago with some different blanket materials and some, and when asked if he knew what fabric the blanket was involved in the fire, he said, "I have no idea." Did you guys see that yesterday? That was wild. I have no idea. She told us it's chenille, but the person who did the experiments for the state had no idea what the fabric was.
No, ma'am.
May this witness be excused?
I'd ask that she be excused.
All right. And is she under subpoena from you, Mr. Cruz?
I believe so. So I would ask that she remains on call.
All right. But you're okay with her leaving today? No objection to that.
Correct. Once we have 24-hour notice.
All right. Thank you. You are free to go. If you are under
Good.
subpoena with the defense, then you are still under subpoena. But you may leave now. Thank you.
Should
You may
not
call your
watch
next
the
witness.
trial.
Oh God.
Oh God, hot mic. Oh God.
Oh, Valerie Lowe.
Okay, this is Valerie,
You please get Valerie Lowe.
the other roommate. Waiting to hear from
Morning.
Val.
Can I have you raise your right hand, please? Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And if you could just be sure to speak into that microphone so that we can hear you. If I can't hear you, I'm afraid the jurors might not be able to.
Okay.
Ma'am, if you could start out by stating and spelling your name for the record.
Valerie Lang Lowe, VALERY LANGLOWE.
And ma'am, what do you do for a living?
I'm a district administrator in a school district.
I want to take you back to August of 2000. What were you doing at that time?
Motion to speed them up. Granted. Hold on. At least through some of the original background type things.
I was student teaching at Oconee County High School.
Were you in college?
I was.
Where were you in college?
University of Georgia.
Beginning that August of 2000, did you move into a new residence?
We did, yes.
And what was that residence?
We lived in Deer Park on Fawn Drive.
Who were your roommates there?
Tara Baker and Ashley Peavy.
How did you come to know Tara?
I had met Tara probably sometime the year before. Ashley and I lived together the year before, and so I met Tara through Ashley.
And can you describe, I guess, what it was like to get to know Tara as a roommate, as opposed to a friend or an acquaintance?
We all got along very well, and I mean, we were all very busy, either in grad school or finishing up college at the time, and we were just all busy. So we all got along fine, and everybody kind of did their own schedules.
Okay. And if I didn't clarify this earlier, in that fall semester 2000, did you graduate that December?
I did graduate in December.
And then did you start a graduate program in January?
I did. I had started my master's degree.
If you could please, ma'am, describe what you observed about Tara as it relates to the fall semester.
My schedule was different in the fall because I got up early to go for student teaching. So I was gone a lot. I know she had started law school, and so her schedule, she was busy. So we really, we were home in the evenings together, but we again, everybody had their schedule, and we were extremely busy, all of us, that particular semester especially.
During the fall, would Tara occasionally spend the night at her boyfriend's house?
Yes.
And by boyfriend, do you mean Chris Melton?
Yes.
Would there be times when Chris would spend the night over at Fawn Drive?
I don't recall.
As you transition from the fall semester into the spring, or I say spring, but January.
Hold on.
I don't recall.
Usually spend the night at her boyfriend's house?
Yes.
And by boyfriend, do you mean Chris Melton?
Yes.
Would there be times when Chris would spend the night over at Fawn Drive?
I don't recall.
She doesn't recall if Chris ever spent the night at Fawn Drive. Sounds to me like they were going out for a long time. Nobody's really asked the question how long Tara and Chris had been going out for, but since they were at undergrad together and now she's in law school, so she doesn't recall if he ever stayed over. Okay.
As you transition from the fall semester into the spring, or I say spring, but January semester, did you notice a kind of a change in Tara's approach to law school?
She had made comments that,
And I'm sorry, I don't mean to interrupt. I don't want you to testify to anything that she may have said, but just did you get an overall impression as to her approach to law school?
yes, she'd started another semester. I was starting grad school. So I think a lot of our patterns had changed just because it was a new semester.
Okay. And what change was that, if you can recall?
Probably at home more. I know I was at home more.
What about Tara?
Same. Mm-hmm.
So on Thursday the 18th, do you recall what your schedule was like that day?
I had class when I started my grad program. A lot of my classes were in the evenings, so I would have been home, and I think I left sometime before maybe 4 o'clock or around 4 o'clock. I can't remember the exact time, and I had class that evening till probably 7:15 or 7:30, I believe.
And what did you do after class?
I was going home for the weekend, so I immediately started heading in that direction when I left.
So you didn't go back to Fawn Drive?
I did not.
Did you see Tara that day at all?
I don't remember. I don't. I think that she probably got home the time I was leaving. I don't remember.
Ma'am, what, if anything, do you remember about the weather that evening as you were leaving town?
It was very rainy. I do remember that. Just driving in the rain and it being dark, but I just remember that it was raining.
I want to talk about kind of the relationship between the three of you in that house. How did the three of you get along as roommates?
We got along great. Ashley and I had lived together the year before, and it was no different when Tara moved in. I mean, we all got along great. There was no girl drama or anything like that sometimes can come along with roommates.
Were you careful to look out for one another?
Yeah, we were all safety conscious about things being locked and that kind of thing. I've always been that way.
Did all of you have boyfriends at the time?
Yes.
Did anybody give an apartment key or a house key to their boyfriend?
I have no knowledge of that.
Why would that have been?
I don't think that they would have ever been at the house. There would be a time.
I have no knowledge of that, she said. And then he said, why would that have been? Why would that have been that you had no knowledge of that? She has no knowledge of whether anybody was given a key. She didn't say no, nobody had a key, right?
Any response to the objection?
I'll rephrase the question.
All right, I'll sustain it. Let you rephrase if you choose to.
Based on the relationship that the three of you had, you, Ashley, and Tara, would you have given a key to your boyfriend at the time?
It's hypothetical.
There would have been no reason for him to have been at the house if I would not have been there.
Based on your
No, the proper question would be, did you give him a key? Not would you have. It's not hypothetical. We're not here for a hypothetical situation. Okay. Tara Baker was brutally murdered, strangled, SA'd, and beaten before her house was set on fire. Your house was set on fire. Would you have given someone a key? Is not a proper question. This is insane.
your impression of the relationship again that you should. Would you have given a key to your boyfriend at the time?
No.
Why not?
There would have been no reason for him to have been at the house if I would not have been there.
Based on your impression of the relationship again that you shared with Ashley and Tara, was that consistent throughout the house?
I would assume yes.
I would assume.
Ma'am, I've been told that, well, let me rephrase. Were you the one that would keep the house clean?
Yes.
Can you describe that a little bit?
I was just the clean one of the group. There's always one, I guess, when you live with roommates. And so I was the one who would clean and tidy up the house. And just that was something that I enjoyed and still enjoy doing.
She's a cleaner, like Nicole Coco.
Do you remember, or if you recall, in the days after Tara's death, do you recall hearing about certain parts of the house being wiped down or anything like that?
I do remember hearing that.
What if anything, do you recall about that?
I think at the time it was more about, fingerprints, or they were, doing whatever you do after something like this happened, and the house was clean and things were, wiped.
Do you recall what areas of the house they were referring to?
I remember they asked, certain patterns of cleaning, if, I would have cleaned this or cleaned that, that kind of thing. But it was, maybe doorknobs or around the doors or windows, that kind of thing.
And is that something that you would have cleaned?
Not typically. I mean, I kept things dusted and vacuumed and just your normal thing, but I didn't like deep clean the house all the time.
Dr. Lowe, we'll talk a little bit about your observations of Tara's relationship with Mr. Melton. Is that something that she would have confided to you about?
No, we didn't have that kind of relationship. That I was private, and I would have never. I mean, we didn't talk about that kind of thing.
Did you ever personally observe any arguments between Tara and Chris?
I did not.
Did you ever hear Tara arguing on the phone with him?
I did not.
But you were so busy, you were never home.
Bear with me just a second.
So she didn't wipe down the peephole and the windowsills and the doorknobs, right? Now, in this chat, we are respectful to the witnesses as far as their, we don't body shame them. We don't guess about their sexual orientation or their gender identity or anything like that. So please be better than that. Thank you.
Thank you, ma'am.
Thank you.
Cross-examination.
That's not a lot. He didn't really get a lot out of her.
Dr. Lowe, first and foremost, I want to let you know I am sorry for your loss, tremendously sorry for your loss. I thank you for your courage in coming to testify in court to help the jury find the truth in this case. My first question for you, are you nervous?
I think anybody would in this situation.
I tell you don't be. I have some very softball questions for you if that's okay. Okay. There was a statement that you made to law enforcement that I wanted to ask you about. Do you recall stating it was almost like somebody knew that we weren't going to be home?
If you'll show me the transcript, I can.
I don't have a transcript, but I can play the recording for you. Is that fair?
Excellent.
Your
I
Honor,
want to hear the
would
recording.
the recording refresh your recollection?
Sure.
Your Honor, I like to play the recording outside the presence of the jury.
All right. Ladies and gentlemen, I'm going to have you go into the jury room. Please don't discuss
Play it in front of the jury. We want to hear. We all want to hear the recording.
the case. We'll be with you shortly.
We have room to move here. I guess, I don't know why the jury can't hear it because the whole thing isn't in evidence. Maybe he wants to refresh her recollection outside the presence of the jury. Maybe the judge has already ruled that the jury can't hear it. We didn't cover this extensive pretrial on this case the way we did on Karen Reed, so there's a lot we don't know.
Yes, ma'am. And if I may, Your Honor, a lot of my questions come from this recording, so I'd just like to play that pertinent part so we won't have to send the jury in and out.
And put on normal speed.
Okay. 1524 for you. And just to save the jury time and respect honorable court's time until minute mark.
No, the only thing that and this is probably in some of the notes from way back when, I think like New Year's, like I always came home for breaks and stuff, like I'm a little homebody, but we went to, Ashley and Chris and Jeff and I went to Hilton Head for New Year's, I think. So we came through Athens maybe to pick them up or something. And Tara was there and we were like, what are you, why are you here by yourself kind of thing? It's a holiday,
This is of 2001, right? Or like 2001 and 2001.
Yeah.
Okay.
And she's like, oh, I'm going to go. Or maybe it was, I don't even remember. It may have been right before Christmas. At some point during the holiday, we went to Hilton Head just for the weekend. And she was there and we were like, Tara, why?
Yeah, this would be the 2023 to 2024 statement because it was a female lead investigator. And so I think she just referred to some prior statements she had given. So this would have been the most recent statement, 2023 to 2024.
It was New Year's because we wouldn't have been gone for Christmas. And we were like worried about her being there. Like, you need to go home and be with your family, like during break or whatever. Like, we just were shocked that she was there. And, you know, we went on our trip or whatever and came back to school, you know, in January or whenever classes started back. But when class started back, we hadn't been there like, 2 weeks? Because I had just graduated in December and I was starting my master's in January at UGA. We had not been back, whatever week or week and a half, whatever all that was when all this happened. She hadn't been going to Chris's house at night. So when I say she went there that often, it was weird that she was at home.
Oh, okay. So I didn't catch that earlier. Like, she was at Chris's house like almost nightly?
It was a lot.
Okay.
It was a lot for that, but like I said, I can only speak to like first semester.
Yeah.
I don't know, you know, what her life was like before. But when we came back from break, and Ashley will tell you the same thing, there was a significant change in that. But again, like, that's her business. We didn't want to ask any questions. And I think maybe Ashley or I maybe did say, you know, are y'all okay? And, you know, so maybe they were having a tiff or whatever. But Tara was really private about her life and, you know, details and that kind of thing. But there was definitely a change when we came back in January. She was not spending, like, she wasn't spending the time she had been spending at Chris's.
Okay.
Which is, you know, why everybody was like wondering if something was going on.
Everybody was wondering
But
if something was going on.
We, like I said, we didn't pry, we didn't ask, we didn't, I mean, that was her business. We just said her, you know, basically just checking on her. And Ashley, she may have exposed Ashley like, yeah, we had a tiff or a fight or whatever.
Yeah.
But
it was like a noticeable shift.
Definitely.
Is that fair to say? I don't want to put words in your mouth.
No, it was definitely a shift. And like I said, you can go back to the notes of when all that, and I'm sure that
I'll have to go.
we said the same thing because it was just, like I said, I can't remember a lot of things, but I remember the details of a lot of this that were just very vivid to me that like something wasn't right.
Something wasn't right. Something wasn't right. Poet Nick Justice Podcast says, I just came across this channel. Glad I did. I appreciate you documenting utter nonsense and injustice taking place in the courtroom. In this courtroom, no other YouTube attorneys are, and I can see why. Thanks for keeping it a buck. Listen, if I wanted 1 million viewers today and I wanted 1 million new subs today, I'd be covering Savannah Guthrie's mom. This is way more important to me. Not that Savannah Guthrie's mom is not important. Okay. This is what I choose to talk about. Thank you so much for noticing and for your 10, and I appreciate you so. Remember, this is not an interview from 2001. This is an interview from 2023.
And she was a very private person.
She was, you know, she wasn't one to overshare like what's happening in life. And maybe to Ashley, maybe she confided in her more because, I mean, you know, they were friends for a long time.
Mm-hmm. Okay. Were you aware of any of her sexual life with?
I'm gonna fast forward a piece to get to the next portion.
So the sexual life stuff is out based on Georgia's rape shield law.
That I'm gonna ask you questions about, okay?
Go back to your lavalier mic, sir. He can't play it in front of the jury because it's not in evidence. He's doing it to refresh her recollection. See if we can just fast forward a little bit.
More so probably day to day, like, you know, doing stuff together, hanging out because Tara, more so probably day to day, like, you know, doing stuff together, hanging out because Tara was always doing the law school thing and studying.
Okay.
And, you know, and I think going back to the whole Chris and January thing, I don't know. I remember one of the things she said was like, oh no, you know, I'm just trying to buckle down and like I'm basically she needed, that was a distraction for her and she was like buckling down on her studies was kind of the way she blew off like when we checked on her to make sure she was okay. Just because her behavior had changed. And
maybe she was seeing someone else. Maybe Chris was didn't want her to be with someone else. Maybe he found out she was with someone else. I don't know, but it's a lot of reasonable doubt, don't you think? And she feels bad. Look at her face. My freeze game is on point again.
Not her personality or anything like that. It's just like, no, I'm just.
Like a routine.
I'm just, yes. And I mean, you know, if you live with somebody and something's completely.
The last portion that'll be a part of the examination is Lowe. Dr. Lowe.
Kind of does, right? Thank you, Tay. Thanks, Tay, for your super sticker.
Thing, and she was like, I don't see anything that's missing, like, from your stuff. Everything looks just like you left it. It was like in perfect shape, like nothing's gone. I mean, I even had, like, you know, those big jars you throw in money and change, and I even had like that in my, like, if somebody wanted, if they were coming there to rob us, they would have. I mean, I had expensive jewelry, I had, you know, purses, I had, like, I mean, they could have taken a ton of stuff, but nothing.
Do you recognize your voice? Yes.
I remember Faust is being charged with burglary. Also, nothing was missing except Tara's laptop. And all of these girls are saying, I had lots of expensive jewelry. I had lots of valuable stuff. Nothing was taken.
Yes, those are my statements.
Thank you. Thank you.
Your Honor,
Yes.
trying to make good use of everybody's time.
Yes.
I think this is probably a good time to address Mr. Cruz's residual hearsay motion.
All right.
I would say that the state does not oppose him asking.
Let me get the residual hearsay motion though that you're talking about, because there were 3 that were filed. So,
Thank you, Strange Credulity.
all right. So, Mr. Bolden, you're talking about the pending motion that the defense filed on January 20th with regard to Dr. Valerie Lowe Lang. Is that right? Is that what you're referring to?
Yes, Your Honor.
Okay. And your position is?
We don't oppose that motion.
All right. Any response?
No response.
All right. Then I will grant it.
Good.
Motion was filed. The state does not oppose it.
Wow.
All right. Anything else before we bring the jury back?
No, ma'am.
All right. Could you bring the jury back, please?
Thanks, Tay, for your 5. Says, born and raised in Athens, my only hope for this case is that the jury truly reflects the diverse spectrum of people who reside in Clarke County. Thank you. Rocker says, is it possible her friends were in on it? Great stream. I don't think so. I think, look, I think that they are very loyal to their friend, even in
written at the top of it, my order.
her death
but you can show
25
that to
years
the state, too,
later.
until you can get
And
it.
also, I feel like they want to see justice for Tara, and the family is probably very excited that there finally may be justice for Tara. But I feel like maybe they got the wrong guy. So I think that the friends are conflicted. I don't think they had anything to do with anything, and I don't. Thank you for your 5 though, and also Sweetie Pie 68. Thanks for your super sticker. And Karen Lachlan, thank you for your super sticker. You guys are amazing, and I love you all of my heart. And let's keep going.
We'll make a copy if you.
I don't know, the volume just got super low all of a sudden. What happened? Valerie is a doctor now. I think the defense attorney, if you've already watched this today, I think he's going to make some big points. I haven't watched it because I'm with you.
Mr. Cruz.
Yes, ma'am. Dr. Lowe, you would agree with the statement that the day that Ms. Baker was killed, it was almost like someone knew that you and Ashley weren't going to be home. Is that correct?
Those are my statements.
I can't hear you.
Those are my statements, yes.
Yes, ma'am. Can you pull the mic up? Thank you. And the reason you said that is because it was rare for both you and Ashley not to be home. Is that correct?
That's correct.
Somebody had to know. She's allowing residual.
I like to discuss your.
She's allowing, there was a couple of hearsay motions. She's going to allow this witness to talk about the things that Tara told her. Even though Tara's deceased, the state has withdrawn its opposition to the motion. That's what we're going to hear next. Okay? Okay, cool.
Observations of Chris and Tara's relationship. Is that okay?
Yes.
During the first semester of law school, during the first semester of school, Ms. Baker, Mrs. P.V. Hall, and yourself, you all stayed together at 160 Fawn Drive. We would agree on that.
Yes.
Okay.
Oh, she's probably PhD.
You would agree that during the first semester.
Okay, she's a district administrator in a school, so she's probably PhD, right? Like sometimes the principal of a school is called Dr. So-and-so. Got it. She's not a medical doctor. Thanks, little cupcake.
Of school, Ms. Baker would always be at Chris Milton's house. Is that fair?
I can't say always. Often. A lot.
Do you recall telling Investigator Black, first semester of school, she would always be at Chris Milton's house all the time, like every night. It seemed like she was never at home. And then when we got back for second semester, Tara wasn't doing that anymore.
That's concurrent with what we just heard, yes.
Well, no, that wasn't on what we just heard.
Right.
That's just separate. Okay.
Yes.
But you agree with that statement?
Yes.
And you would have no reason to disagree that the first semester of school entailed August of 2000 and December of 2000.
Correct.
All right. Let's talk about second semester. Okay, second semester for the purposes of our conversation would have been January 2001 until May 2001. Was that fair to say?
Yes.
Now, on New Year's Day of 2001, do you recall stopping back by your house at 160 Fawn Drive?
I don't remember exactly. It's been 25 years ago which day we stopped by, but we did stop through Athens.
Based on the recording that you heard, do you recall stating on New Year's Day 2001 you were on the way to Hilton Head Beach? It was you, Mrs. Ashley P.V. Hall, Chris Hall, and your significant other. Do you recall making that statement?
Yes.
And when you stopped in at your home on New Year's Day, you found that Miss Baker was home alone.
Yes.
And you were shocked to find Miss Baker home alone on New Year's Day. Is that correct?
Yeah, I mean, typically college students would go home during the holidays, but I, hadn't lived with Tara, so I didn't know her patterns of when she went home and when she wouldn't have gone home.
Okay, and based on our discussion regarding how she was with Chris from August to December, is it fair to say that you probably expected her to be with Chris?
I don't know where I would have expected her to be. It was the holidays. So.
But you and Miss Ashley P.V. Hall, you two were with your significant others, is that right?
Yes.
Now, from January 1st to January 19th, that's going to be the focus of this portion of our conversation, okay? You would agree Miss Baker had stopped going to Chris Melton's home, is that right?
She hadn't stopped going there. She just wasn't going as often, I would say. I don't remember fully, how many days a week or anything like that.
Do you recall making a statement, when class started back, we hadn't been there in like 2 weeks. We had not been back week or week and a half, whatever all that was when all this happened. She hadn't been going to Chris' house at night. Do you recall making that statement?
Do you have the transcript or is that what you just played?
Do you recall making that statement?
I'd like to see it.
You would like to hear it?
Yes.
And I would move to introduce minute mark 1632 through 1651 of Defense Exhibit 22, which is Ms. Course indulgence. Ms. Lang, do you recall speaking with law enforcement agent Elizabeth Bigham?
Yes.
Okay. And do you see Ms. Bigham in the courtroom?
Yes.
Okay. And you've heard
Bigham's in the courtroom. Okay, now we're getting somewhere. We might need to make, Jimmy Anti-Deb has Thickums merch. We might need some Bigham merch. It's Bigham, I believe. Oh boy.
You've heard portions of your recording with Ms. Bigham, is that correct?
Yes.
And is it fair to say that it was you on that audio?
Yes.
Okay. Had it been altered from what you heard, had it been altered in any way?
I'm not aware that it had.
Okay, thank you. Your Honor, I would move to introduce portion or minute mark 1632 through 1651 of Defense Exhibit 22 into evidence.
Any objection?
I don't know that he's laid the grounds for it being an inconsistent statement. So I guess I would object on this ground.
All right, I'm going to sustain the objection. I think that's correct, but I'm going to let you refresh your recollection, and I'm going to ask the jury to go into the jury room one more time. Please don't discuss the case, and we can do that.
They really.
Well, Your Honor, I have a case for you.
I'll let you.
But
outside the presence of the
yes, ma'am.
Again, he's being handcuffed. They really don't want the jury to hear her statement to Bigham. And why is Bigham in the courtroom? Why does she get, if she's on the witness list, which I'm going to assume that she is, why is she in the courtroom as the lead investigator? Here's our defendant, Edrick Faust, today in a very nice button-down shirt of the
Y'all may be seated.
Light. It's not really pink. I would say it's sort of like a heathered red.
So, Mr. Cruz, you can tell me whatever you want to, and that's fine. But it sounded like she was offering to have her memory refreshed, which you had already done, and you can do that again if you choose to. But if you want to make a different argument, go ahead.
I'll follow the Honorable Court's order. I'll just put the case law on the record if the Honorable Court will allow me.
Oops.
Page 5 v. State. I provide the court with Hayes v. State, which is 320 Georgia 505. Page 518. That is 910 Southeast 2nd, 198. This is a 2024 case. It states, if a witness testifies that he cannot recall making a prior statement, this is the same as a denial, and extrinsic evidence of the prior statement may be presented in evidence. In support of that proposition, I also cite Scuniers, which is S as in smile, C as in car, O as in orange, N as in nice, Y as in yellow, E as in eggnog, I as in rhinoceros, and S as in sailor, v. State, 318, Georgia, 855, 901 Southeast 2nd, 170. That's a 2024 case. Also, Murdoch v. State, which is 299, Georgia, 177. Page 179, which is a 2016 case, cites or states, if the witness testifies that he cannot remember the underlying facts, this is an implied denial of any prior statement on those facts. So I just want to put that on the record, Your Honor.
All right, thank you. I think at this point, Mr. Cruz, I'll let you refresh your recollection. The understanding of the court from this witness is not necessarily that there's no memory of any statement being made, but the specific question that you asked. You can go ahead and refresh your recollection. If that doesn't satisfy you in your questioning, we'll go ahead and talk about sort of the next steps, and you can renew your motion.
Yes.
All right, go ahead.
Thank you, Your Honor. And let the record reflect that I am playing minute mark 1632 through 1651 of Defense Exhibit 22, which is identified as Ms. Valerie Lowe's interview with Agent Elizabeth Bigham.
Oh, thank you, Cindy. Elizabeth Bigham. I don't think the jury is sequestered in a hotel. Where did you hear that? I'm not aware of that, Sweetie Pie. Is that accurate? I don't know.
We hadn't been there like, what, 2 weeks? Because I had just graduated in December and I was starting my master's in January at UGA. We had not been back and half, whatever all that was when all this happened. She hadn't been going to Chris's house at night. So when I say she went there that often, it was weird.
Does that refresh your recollection?
Yes.
Any other questions of this witness?
Yeah, she literally just heard it.
All right, any other motions we need to take up before the jury comes back in?
Not from the defense, Your Honor.
All right, thank you. All right, you may call the jury back in.
He's prepared today.
Any
They're
from the
not
state?
sequestered. Yeah, no, they're not.
All right.
I wouldn't think that. They rarely sequester juries anymore. Rarely. It's very expensive to pay for hotels for jurors like that. And people don't want to serve if they have to be sequestered. What I said was, why is Elizabeth Bigham, the lead investigator, not sequestered? Meaning, why is she allowed to sit in the courtroom? That's what maybe you misunderstood what I was saying. Yeah, I think tomorrow's not going to be a full day of court because a juror has to go somewhere, or more than one does.
My question,
I don't know how many days a week.
Ms. Baker. Thank you, Your Honor. Now, during the month of January 2001, Ms. Baker had stopped going to Chris' home. Is that correct?
Yes, I don't know how many days a week or anything like that, but she was not going as often.
My question specifically is, during the month of 2001, Ms. Baker had stopped going to Chris' home. Is that a yes or a no?
Yes.
You also noticed that she was no longer spending much time with Chris. Is that correct?
That is correct.
You would agree that there was a noticeable shift in the relationship between Chris and Ms. Baker before her death?
I don't know anything about their relationship necessarily, but her patterns had changed.
Okay. Ms. Lowe, you recall speaking with Agent Bigham in regards to the shift in Ms. Baker's relationship. Do you remember that conversation?
I do.
Okay, so this isn't the first time you've been asked that question about the shift in Ms. Baker's and Chris Melton's relationship. Is that correct?
That is correct.
And your statement to Elizabeth.
All right, I just want a Living Story World pointing out that based on another case in Georgia last year, the lead detective is part of the district attorney's team and will always be in the courtroom. Isn't that great? All right, thank you for clearing that up for me.
Elizabeth Bigham, when she asked you, but it was like a noticeable shift, you said definitely, it was definitely a shift. Is that correct?
That's correct.
Okay. Let me ask you this. Would you agree that some of your answers have changed here today versus when you spoke with Agent Bigham?
No, they have not.
No?
I mean, it's been 25 years. So I've been asked lots of questions over the years.
That's fair. And you would agree that you spoke to Ms. Bigham last year?
That's
right. Correct?
I believe it was, I don't remember when the arrest was, maybe 2023.
Sorry, I am incorrect. Do you recall speaking to Ms. Bigham on May 3rd, 2024?
Yes, I do remember speaking with her.
And some of the questions that I am asking you, you've learned are the same questions that Ms. Bigham has asked you, correct?
Yes.
And would you agree that some of the answers that I've gotten originally have been different from the answers you've given Ms. Bigham?
I don't recall that, but I mean, I listened to the statement that you played.
Okay. Is there any reason that
Thank you,
do
Sheree.
you feel the need to protect Chris Melton?
No, I don't.
Okay. And you are going to be truthful and honest with the jury?
Yes.
Okay.
Thank you, Tina. And thank you.
After noticing the shift in Ms. Baker's relationship, do you recall asking her if everything was okay?
Yes.
Oh.
And based on Ms. Baker's response, it is fair to say that you're...
Ooh, she was concerned enough to ask Tara, are you okay? I've noticed this. Are you okay?
Your takeaway was that Chris was no longer a focus for Ms. Baker.
Her focus was on school.
Chris didn't like that.
Is it fair to say that her relationship with Chris was a distraction for her?
Yes. Her focus was on school.
Now, we've agreed that on January 1st, or New Year's Day, Ms. Baker was home alone. Is that correct?
Yes.
Okay. And January 19, 2001, she was killed. Is that correct?
Yes.
And I like to put this in context for the jury, okay? We agree that 3 people stayed at 160 Fawn Drive. We've already discussed that. We agree on that, correct?
Yes.
If you can come to your screen safely, just watch the body language, the licking of the lips. She turns to look at the jury or someone. We don't know what is over there to her left. Watch.
2001, she was killed. Is that correct?
Yes.
And I like to put this in context for the jury, okay?
See it?
We agree that 3 people stayed at 160 Fawn Drive. We've already discussed that. We agree on that, correct?
Yes.
Okay. And although Ms. Single may or may not have been single, I want us to assume that she's with Chris Melton, okay?
Can you repeat that?
Sure. We're going to assume for this conversation that Ms. Baker is still with Chris Melton on January 19th, okay?
Yes.
You were dating Jeffrey Hall.
Yes.
Okay, so we have 3 roommates. We have
2
Jeffrey
Halls and 2
Hall.
Chris's.
Ashley Peavy was dating Chris Hall. Okay, so we have Chris Hall. So we have Miss Baker, we have you, we have Mrs. Peavy Hall. I want to make sure I get her name right. We have Chris Hall, we have Jeffrey Hall, and we have Chris Melton. So at any given time, there could be 6 people in the house. Is that right?
Correct.
Okay. And even with the single car in the driveway, there could still be at least 2 people in the house. Is that right?
Correct. If someone had somebody there.
Okay. Well, boyfriend, girlfriend, couple. Is that fair? Okay. Based on the number of people that could be in the house at any given time, is it fair to say that it seemed as if the person that killed Miss Baker was certain that she would be home alone?
Sustained.
It's okay. The jury heard it. It's okay.
Your statement to law enforcement was that it was like someone knew that she was going to be home alone. Is that
I'm going to overrule that objection.
Thank you.
Can you repeat that?
Absolutely. Your statement to law enforcement was that it was like someone knew she would be home alone. Is that correct?
I did make that statement, yes.
Right.
Now let's talk about the items that you had in your room.
Therefore, a stranger, such as Edrick Faust, would not have broken into that home in the morning hours of January 19th, 2001.
Okay. You had a jar full of change and money in your room. Is that right?
Correct.
That was not taken.
No, sir.
Okay. You had a lot of purses in your room, correct?
Correct.
Those were not taken. Is
No,
that
sir.
right? And you also had expensive jewelry in your room. Is that correct?
That's correct.
And that also was not taken,
No, sir.
right?
No, sir.
I'm sorry, I didn't mean to cut you off.
Go ahead.
No. I think you were answering that.
I said no, sir. I said no, sir.
Purses, like expensive purses?
And all of this
Leave
was
it
in the
down?
open in your room, correct?
Yes, sir.
But none of your, and all of this was in the open in your room, correct?
Yes, sir.
But none of your property was missing from the home and everything looked exactly how you left it.
I did not go to the house, but yes, everything was still there.
Yes, sir. Based on none of your valuables in your room being stolen, is it fair to say that it seems that the person that killed Miss Baker came there specifically for her?
Yeah.
Sustained.
I mean, it's
But
not a
nothing was
proper
taken from anyone. No.
No, sir. Or not from my room. I can only speak to myself.
Yes, ma'am, that's fair. I have no other questions for you. Thank you so much, Dr. Lowe.
Any redirect, Mr. Bolden?
Dr. Lowe, you mentioned that In the fall semester, Tara had been spending a good bit of time over Chris's. Were you aware of where that apartment was?
Yes, sir. I believe I remember.
Where was it?
I believe it was off Millage.
Is that here in Athens?
Yes.
In January, do you have any knowledge as to where Chris was living at that time?
I think he was living in the same place, but I don't fully remember, but I think he was.
Do you have any knowledge of him spending more time at his parents' house?
I remember times that there were, if he had work, in that area, yes.
And then lastly, Dr. Lowe, for some reason can't remember to ask this question. In the days subsequent to Tara's murder, do you remember being asked to submit samples of your hair in connection with the investigation in the case?
Yes, sir.
And did you provide those?
Yes, sir.
That's all I have, ma'am.
Any recross, Mr. Cruz?
No, ma'am.
May this witness be excused?
I would ask that she be excused.
Any objection, Mr. Cruz?
If she's under subpoena from my office, I just ask that she stays on call next.
Is she under subpoena from your office?
Abigail would know. Wilson would know. He'll be here Friday. But I believe she is. I believe all of Ms. Baker's roommates and family members are under subpoena from my office. I just don't want to say it certainly without.
All right. You are free to go for today if you are under subpoena. It's unclear to the court whether you are. You are? Okay, thank you. You are still under that subpoena, but you are free to go.
Thank you.
Thank you. You may call your next witness.
Did we ask the witness if she has been? I mean, she would.
She just stated she was.
Okay, I didn't
She
hear
did
that.
just,
I'm sorry.
Boy, man, open mouth, insert foot. Assistant District Attorney Chris with a K, Bolton. You really, really, really want to make it hard for the defense attorney. Yes, he is accused of burglary as well. He is. They've made a big deal about the screen being off the back window. And then, you know what had happened was they just lost that evidence. That is just part of the lost evidence in this case from 25 years. There were no hairs in the envelope the other day. The window is missing. Let's see who's up next.
You are free to go, ma'am. You may call your next witness.
Reynolds McLean.
Could you get Reynolds McLean?
Thank you, Dr. Valerie. We appreciate your honesty.
I'd save us a little bit of time. Sir, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay. You can put your hand down, sir. If you could state and spell your name for the court reporter, please.
Reynolds McLean, REYNOLDS
And Mr. McLean, I want to take you back to January of 2001. What were you doing at that time, sir?
I was here in college, University of Georgia.
Okay. And where were you living that year, that school year, August 2000 through 2001?
Yes, I lived in 147 Fawn Drive in neighborhood Deer Park.
And who were your roommates?
Jay Anderson, Matt Owens, John Roberts, and Richard Kevin Ford.
Kind of a full house, I guess. Okay. So I'm going to show you, and hopefully you can see this on the screen down to your right, sir. This has been previously admitted as State's Exhibit 37.
This has been
do you recommend
previously referred to by me as pluribus, as the neighborhood in pluribus. I have learned that red clay is often used in yards in Georgia, or that is a part of the natural landscape, and that is why it looks red. This is like a drone shot of the neighborhood, I guess, from 2001. This is not Chris. This is a neighbor, someone who lived around the corner. Let's see if he saw a suspicious black man, and in their words, suspicious, by the way, walking in the neighborhood that morning. I'm assuming that's what he's here for, but nobody followed up on those leads until, 2024 when Faust was arrested. So here we go.
Is that to be kind of an aerial shot of Deer Park as it existed in 2001?
Yes, I do.
And so the screen, you can actually touch it and circle the residence where you were living at the time if you recognize it. Okay. And we're going to leave that circle there for just a minute. And so on January the 19th of 2001, were you aware of a fire and a murder that had also taken place in Deer Park?
Yes. It was a class. I came back around 11 or 12 o'clock that day, and fire trucks and all kind of craziness.
So again, I'm just going to ask you to circle on that map. What house was that?
It's the one with the tarp on it. There you go.
Gotcha. So was that basically directly across the street?
Yes, sir.
Okay. Do you recall anything out of the ordinary occurring in the early morning hours of January 19th, 2001?
Yes. That morning, I remember waking up. It was oddly hot in my room that morning in the house. I lived on the second story. Went over to the window to get some fresh air, and I saw someone walking down the road.
I'm going to stop you right there. Do you remember about what time this was?
Around 8 o'clock in the morning.
So 8 o'clock in the morning, you look out the window, you see somebody. Describe exactly what you saw.
I remember seeing somebody walking. If you're looking out my window down at the house across the street, they're walking left or right to left, so sort of east.
And let's just clarify. So would that have been, again, you can kind of use your finger to draw a line in the direction that you saw the person walking. So that would that have been away from Cooper Road towards the back of the neighborhood?
That's correct.
All right, I'm gonna stop. Let you pick back up on this individual that you saw.
So yeah, they were just walking down the road. They were on the closer side of the road, the opposite side of the road, closer to the house across the street side of the road. I remember them walking at a normal pace. The person had on an orange shirt of some sort. It's the memory that stands out.
Male, female?
Yeah, male, young male.
White, African American?
African American.
You remember anything else about that person's description?
No, I think they had on some sort of brownish khaki colored type of pants. Yeah, they looked to the left and the right. They were walking, and that was it.
Other witnesses said jeans, right? Other witnesses said jeans. This one say he's got khakis on. Orange shirt is there. Walking while black. He's not running away. Do you think if he just brutally murdered the girl across the street after essaying her and breaking into her home and setting it on fire that he might have run away? Eyewitness testimony is the least reliable form of testimony. Laura says there was such a huge difference between the wife of the tow truck driver's description and the woman backing out of her driveway. One said he was obese. The other said he was average weight. I'm also going to point out to you from court records that Edrick Faust is 5'9". I believe that someone yesterday said that he was like between 5'6", 5'4", and 5'6" or something. Okay.
And I just want to, I'm going to try and, Your Honor, if you could maybe clear the screen. I'm going to zoom in, Mr. McLean.
Oh, not carrying anything, right? Where's the laptop?
So I think we've already established that the house with the tarp on it is 160 Fawn Drive. I think that. So again, maybe just with a little dot or something. Where was this individual when you first saw them?
Right about here.
Okay. I'm sorry. Am I seeing? Okay. I see it now.
A little tiny purple dot. Yeah.
And after you first saw that individual, what did you do next?
I saw them walking for a second. It stood out because it was just early in the morning. They clearly weren't trying to exercise or anything like that. They weren't wearing exercise clothes. It just stood out to me. So then I went in my bedroom.
I'm sorry, but I'm really having a hard time with what is so suspicious about walking while black. What is so suspicious about a black man walking down the street at 8 a.m. not exercising? Are we in the 1950s? You remember Robert Tellis? Remember Robert Tellis, the Boss Baby trial that we covered in Nevada? He was walking down the street in his disguise with his orange like beekeeper outfit on and like the big mask in front of his face and gloves and it was 120 degrees in the shade. That's a little bit suspicious. But everybody, all of these witnesses are like, yeah, it was really suspicious because it was, 8 a.m. in 2001. And there's a black man in an orange shirt. And he even said to him yesterday, he's like, well, isn't it odd that in Bulldog country, somebody would be wearing an orange shirt? My head is popping off. It is rolled down the street. He wasn't exercising 8 a.m. And I think another witness said, and he looked awfully awake for that time of morning. I'm sorry, what? What? Am I just like a Northeastern person who has grown up in a diverse area? I just don't understand. You better be exercising if you're out at 8 a.m. Here we go. Listen.
Saw them walking for a second. It stood out because it was just early in the morning. They clearly weren't trying to exercise or anything like that. They weren't wearing exercise clothes. It just stood out to me. So then I went in my bedroom 2-3 steps away. I had, it was in college. So I had milk cartons as I was using to hold my clothes. And I grabbed some boxers and a t-shirt, took 2 steps back, looked back out the window to sort of see what was going on. And then the individual's gone. And so I looked down, I was on the,
I think he meant to say milk crates, not milk cartons. We all had milk crates. We put our TV on them and such. And many of us kept our clothes in the milk crates. They were easy to move around in college. They were big plastic things that you kept your stuff in. And everyone had a plaid couch in college too, or some other sofa with like a sofa cover on it.
Facing the house that I lived in, sort of the opposite direction. I was on the right side of the house. I was on the, if you're facing the house that I lived in, sort of the opposite direction, I was on the right side of the house. And so, I looked out my window and looked down to the left as far as I could, down to the right as far as I could, just looked down the road, couldn't see anybody. And so then they were gone.
When you say you look to the left and the right, you mean up and down Fawn Drive?
Yes.
Okay. And to be
More people saw a black man in an orange shirt walking down the street at 8 o'clock in the morning on January 19th of 2001, then woke up at 34 Fairview with how many fire trucks and screaming going on outside their window and lights and maybe not sirens, but police activity outside on their lawn. But how many witnesses have seen a black man walk down a street in an orange shirt 25 years ago? All of them?
be clear, you didn't see that individual the second time?
No, they were gone.
Based on your observations, what, if any, explanation did you have as to where that person may have gone?
I think the only explanation is, if they were walking, it had to have gone between the houses. I mean, take a left or a right off of Fawn Drive, going between the houses.
What was he, pool hopping? It's January.
Sir, those are all the questions that I had for you. Mr. Cruz may have some questions. Thank you.
Cross-examination.
Oh, I'm sure he will.
Good morning, Mr. McLean.
Good morning.
My name's Amaya Cruz. I have the privilege and honor of representing Mr. Faust. I just have a couple of questions for you. Is it okay if I ask them?
Yeah, absolutely.
All right, thank you. I believe we established that you lived across the street from Ms. Baker at the time of the fire at her home. Is that correct?
Yes, sir.
Okay. And you also spoke with law enforcement on January 19, 2001 as well, correct?
Yes, sir.
Okay. So this is the same date that you saw the individual walking?
Yes.
So that would have been fresh in your memory at the time that you spoke to law enforcement?
I believe so.
And I believe I heard you correctly. You said it was around 8 a.m. when you saw this individual?
I believe so, yes.
And he was walking east on Fawn Drive?
That's correct.
And I think you're saying he was going down this way? Or going towards the back of the neighborhood?
Yes, that's a good description. If east is the back of the neighborhood, that's the...
Dude, you don't know east from west? Okay. All right, smarty pants. Hold on. I don't mean to disparage the witness at all. 25 years, walking all black. I'm still stuck on that part. What was your major?
And he was walking east on Fawn Drive?
That's correct.
And I think you're saying he was going down this way? Or going towards the back of the neighborhood?
Yes, that's a good description. If east is the back of the neighborhood, that's the direction he was going.
Yes, sir. And you described the black male as wearing a bright orange short sleeve t-shirt, khaki type pants, maybe dark brown, unknown shoes, and no hat. Is that accurate?
That's what I remember, yes.
Okay.
You said,
Did anybody else say he was wearing an orange short sleeve t-shirt? I thought other people said hoodie. Other people said, I think he's the first one to say it's a short sleeve t-shirt.
this individual appeared to be between the ages of 17 through 23, correct?
Correct.
This individual had short hair. Is that correct?
If that's what I said at the time, but yes, that would be correct.
I ask you this. Do you remember what you said at the time? You don't have to take my word for it. Do you remember?
I don't remember hair. But there are other things that I remember, but if at the time I said that was the type of hair they had, then I was truthful with that statement.
Sure. Court's indulgence, Your Honor.
One guy said a white shirt. Yeah, they got him off the stand awfully quick, didn't they?
Was seeing a summary of your statement refresh your recollection?
I'm sorry, could you repeat that?
Yes, sir. Please forgive me. Would seeing a summary of your statement regarding the description of the individual you saw refresh your memory?
Yes.
If you look at page 4 of 7, paragraph 2, sentence number 4. Okay.
I haven't seen what Mr. Cruz just handed the witness.
Yeah, Tennessee is orange, right? Would that be the rival? The tow truck woman said she did not see his arms, correct?
May I, Your Honor?
You may.
Okay.
Read that sentence, and once you've had opportunity to read it and your recollections refresh, just look up.
Clemson is also orange.
McLean described the black male wearing a bright...
You don't have to read it aloud.
Oh, okay, I'm sorry.
I'll ask you some questions.
Okay, yeah. Yes. Yes, sir.
Would you agree that you described the black male who appeared to be between the ages of 17 through 23?
Yes.
Okay. Short hair?
Yes.
Okay. And a medium dark complexion?
Yes.
Now, we would agree that the individual was not wearing a hat. Is that correct?
Yes.
So it's fair to say that his face was fully visible?
Yes.
And you stated that he was walking at a normal pace?
Yes.
And when you saw him, he was walking in the roadway. Is that right?
That's correct.
And the roadway was open and visible?
That's correct.
You would agree that he was also wearing a bright red or orange shirt, which made him easily observable. Is that correct?
Yes.
And there was nothing that you can recall about his appearance that would prevent recognition?
No.
And there's a Walmart on the opposite side of.
They didn't do a lineup because Edrick Faust was never a suspect in 2001. He was never even mentioned in the police file until 2023. Are you picking up what we're laying down here? There was never any suspect. Edrick Faust was never a suspect. Were there any other black suspects back in the day? I don't know. But no, there was never a lineup.
Deer Park, do you remember that?
Yes.
Okay. Was it common for people to walk through Deer Park to cut through to go to that Walmart in your memory?
I don't feel like I could answer that statement. I never walked to the Walmart.
That is fair. Thank you so much for your time. Those are my questions.
Okay.
Any redirect?
Very, very briefly, Your Honor. Mr. Cruz just asked you a question about this individual wearing a red or orange shirt. What is your recollection as to the color of the shirt?
It was orange.
Mr. Cruz, anything else, sir?
No, ma'am. Thank you.
May this witness be excused.
Ask that he be excused, Your Honor.
All right, you are free to go, sir. Any objection, Mr. Cruz, sir?
No, ma'am.
All right, you are free to go.
Can we have 10 minutes, Your Honor?
We may have a 10-minute recess. Yes. We'll be back on the record at 10 to 11. I'll let you all have a rest.
Oops, we have some time to move. We got some room to move because we're behind on today because we started off today with yesterday. Portion of yesterday, anyway.
Our next witness is in a wheelchair.
Okay.
We're going to get her. She's confident she can get up in that witness stand, but I would ask that we do that before the jury comes out. I think it would just be better.
Well, sure, I don't have any problem with that, but I do want to make sure that this is a person that can't. Are you suggesting that this person can get out of the wheelchair and climb up the steps?
Tell me she can.
Well, I don't know that that's necessarily necessary. I mean, she can certainly testify in front of the witness stand and things of that nature. I mean, I really don't want anyone to risk getting hurt.
100% agreed, Your Honor. Again, I also asked her if she would be willing to testify from before or not.
Okay.
She said she could do it.
I'll let you handle that, but I have no problem with her being next to the bench with a microphone.
Thank you, Your Honor.
All right, go ahead, sir. If you'll make that call, that'd be great. Thank you.
Okay, can scooch a little bit more. What had happened? Where'd the volume go? Did they shut off the
What it is
volume
that
at
Ms.
one
P.D. Hall
point?
said to you about the subpoena.
Entitled to
Sounds like there's no volume for this.
members of the victim who are entitled to protection under Marcy's law that we would accept service on their behalf. We never said that about Ms. P.B. Hall or Dr. Lowe.
Okay, and Mr. Yalman-Chile, can you tell the court what it is that Ms. P.B. Hall said to you about the subpoena?
This is secondhand, Your Honor. I'll just preface it by saying that. But after she left the courtroom or on her way out of the courtroom talking with some of the members of our victim witness assistance team, that she had not received a subpoena from the defense, and therefore she was wondering if she was able to come into the courtroom to view the proceedings.
All right, thank you. Mr. Cruz, anything else, sir?
Send down the court tracking information on the court will just to protect the record.
All right, thank you. Mr. Yalman-Chile, I'm going to ask you to ask your victim witness advocates to get the information from Ms. P.B. Hall as exactly what she understands about this whole subpoena issue. If she relays to your staff and then relays to you, which will relate to the court, that she has not received a subpoena from the defense, she may be in the courtroom. So that'll be the order. All right, you may go ahead and call your next witness. Yes, sir.
All right, maybe he didn't subpoena her. Maybe he needs to call his process server right now and subpoena her as she's walking out of the courtroom because you know where she is today. So, and then she won't be able to sit in there for the rest of it. But I mean, she's right on the law that if he has not subpoenaed her, she's allowed to sit in there now. But he could subpoena her today. Send Mr. Hill out. Call the process server.
You can go ahead, Mr. President. Bring your Golden, are you ready for the jury? I know you're working on my.
Right at the bench again.
And yeah, okay, there we go. Ma'am, do you swear or affirm your testimony in the matter?
Okay, this is so weird too. This is another thing I found out they do in Georgia. Look at the prosecutor is swearing in the witness. He's swearing in the witness. Thanks, Gigi, for gifting 5 memberships. You're so kind and generous to me and the channel. And to the new 5 members that were gifted, welcome. I think you're going to like it here. Something they do in Georgia. I know the lip smacking is annoying for a lot of people. I know it.
Pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Okay. And I'm going to ask you, please, to state your name and spell it for the court reporter, please.
MARLA LAWSON, MARLA LAWSON.
And Ms. Lawson, I want to talk to you a little bit about your career. Can you tell this jury what you have done for a living, ma'am?
Oh, gosh. Well, I started out in 1970s at the Atlanta police, well, at underground Atlanta, and was a street artist, and they hired me on the Atlanta Police Department as a typist. So I typed reports mostly, and then word got out around the bureau that there's a girl downstairs who can draw a face. So I mean, that's about the way it went. I
sketch artist.
Started drawing the faces of perps and everything else for the detectives, and stayed there for about, what, 20 years.
Okay. Did you then go on to draw faces for KYLEE County?
Yes, sir. I drew them for well, heck, I drew for everybody. The whole time I'm, just working. KYLEE County, Cobb County, most of the cities.
Did you spend about 16 years as, I'm sorry, I didn't mean to do that, doing forensic sketches of, did you spend about 16 years doing forensic sketches for the Georgia Bureau of Investigation?
Yes, sir.
Can you talk a little bit about your training and background as it relates to forensic sketch artistry?
Well, I don't really have any background or any training. I just kind of picked up a pencil and went to town. And after I did that, I
just picked up a pencil and went to town. I don't know what kind of training a police sketch artist is supposed to have, but I bet it's not just that. I picked up a pencil and just went to town. Thank you, Janelle, for loving me with all your heart. I love you right back. And for your super chat. And Irish Wolfhound Mama says the witness is using Jen McCabe's stylist minus the crucifix. You were talking about the prior witness. Kathleen said Cruz did not cross the witness who said a white t-shirt, which I thought was smart. Yes, agreed. And welcome Andrea Wilson, who became a new member. Okay, buckle up, buttercups. Here we go.
wound up doing it for what, almost 20 years. I don't know. I just always have fallen into the right job for whatever somebody needed.
Your Honor, can you turn the Elmo off? Thank you. While you were working as a sketch artist, did you attend courses related to that?
Yeah, I took all the courses that there were at the, trying to think where. All the courses that they, that they offered it at the.
I tell you what, Ms. Lawson, I'll move on. Did you ever win any awards for your forensic sketches?
Yes, sir. But the most public display of awards was for Eric Robert Rudolph, because when the Olympic Park bombs went off, they called me and I go over there to draw his face. And
how many times did your sketches
was relatively
actually match the perpetrator? I mean, no training or background, but I took every single course. All right, listen, there's nothing funny about the gruesome, brutal, horrifically personal, in my opinion, murder of law student Tara Baker, who has a special place in my heart as a lawyer myself, and she should be a lawyer right now, and she should have a family, and she should still be alive. But sometimes we just gotta laugh, or we're just gonna cry. Yeah, they're gonna show the sketches, I think, but I don't know because we're behind. But I do have a side-by-side of the sketch and of Faust. Remind me to show that to you later, because there were two different sketches that were shown yesterday if you guys didn't watch.
Famous, I guess you'd say.
So I understand, did you draw a forensic sketch related to the 1996 Atlanta Olympic
Yes,
bombing?
sir. And most high profile cases in between, they would call me. I mean, I was at GBI, but
You would work for other agencies?
Yes.
I got you. Okay. Over the course of your career, do you have any idea how many forensic drawings you would have completed?
good Lord. No, I would estimate 1,000.
Have you ever been asked to come into court and testify about your sketches before?
Yes, sir.
You have any idea how many times?
Probably no.
Ms. Lawson, I want to talk a little bit about the process of creating a composite drawing.
Okay.
And so kind of walk through that with me. How do you first meet with the individual that you're questioning and then go through that process if you can?
Okay. The detectives interview the witnesses and the victims and everybody, and they bring them to me. And I would show them a big, huge stack of old mugshots and photos of suspects and just old photos that I have in a big case that I dragged from pillar to post way back when. And I would tell them as they're looking at the photos, pick out anything that reminds them of the person, eyes, nose, shape of the face, teeth, hair, anything, pull it to the side and we would talk about it. And the average person would probably pull out 15 photos, and I would just draw it together into one face and hold it up, and they would help me change everything on it until we get it as far looking like the person that they remember, as they could. And I get them to rate it when we're done on a scale of 1 to 10. And as far as 10 being him and 1 not. So we just make corrections along the way. And,
How long does this process take on average?
it probably takes 45 minutes per person.
And you mentioned kind of the ranking at the end. Is there a number by which you say, okay, like we're going to stop, or can you kind of describe that for me?
Yeah, I tell them to pick out a number between 1 and 10 as far as it looking like the person that we sketched. And they usually pull out, I guess, 3 photos for that too. By this time that I've got them accustomed to digging through the photos. And we try not to quit working on the sketch until at least we get an 8 on a scale of 1 to 10.
I mean, if the person were to give you a impression or a number that was less than 8, you would keep working. Is that fair?
Yeah, because in my opinion,
I'm picturing this. Tell me if you remember this, and I don't know what it was called, but tell me if you remember what it was. It was a magnetic thing, and it had like a person's face on it. I think it was a man's face, and then you had a magnet, and then it had like some dust in there or some like little black magnet parts, and you would move the magnet to make like a beard on the person's face and put hair on the person's head. You guys know what I'm talking about? I don't remember what it was called, but I remember that thing. It was like a magnet, and you could put hair on the person's face and sideburns. Not etch a sketch. This was magnetic in nature. I forget. I don't even know if it had a name. And then I'm thinking about that other thing where you could flip through all the different eyes and you can make a person's face. Flip through all the different eyes and pick one, and flip through all the different noses and pick one. Anyway, she reminded me. It's Mr. Fuzzy. Was it Mr. Fuzzy? Wookie Willie? I don't remember what it was called. Mr. Woolly? I don't know. I'm going to find it though. Now I got to find it. Woolly? Woody? I don't know. Not Etch a Sketch. No. Okay. All right. So yeah, blast from the past. Woolly Willie. I'm going to find it. I'm going to find it, and I'm going to get one to add to my prop bin. I'm going to find one and get one. All right. We will find it. Woolly Willie. All right. We're going to find it. All right. Keep on going, Marla.
anything below an 8, it's not worth circulating. But anything above an 8 or an 8 is a pretty good recollection of their memory.
Ms. Lawson, as you sit here today, do you have any recollection about coming to Athens-Clarke County to assist in an investigation back in January of 2001?
No. Yes, I do. I don't remember drawing the 3 composites that I supposedly had to draw, but
have you had a chance to look at them though?
I haven't even seen them.
Okay. Well, I'm just going to, if I can approach you. Ms. Lawson, we've got states 99 and states 100. States 99. And what I want to point out there, ma'am, is do you recognize what's on the lapel of this individual?
Yes, sir.
What's
That's
that?
my name.
I got you. And then on states 100, I didn't see one there.
Well, you get busy and you get in a hurry, and
okay.
You might not get them signed, or you might get them signed. I mean, you know, I'm kind of haphazard.
All right, let me just
kind of haphazard.
give me just 1 second, Ms. Lawson. I'll make sure I didn't miss anything.
Hold on, we found him. We found him because we do lots of things here. We don't just learn about the law. Here we are. Here's Wooly Willie. Here he is. You are indeed right. And look what it says under there. It says magnetic personality. Wait, let me get my face out of the way. It says magnetic personality on the bottom. I got to get the comment out of the way too. We like to laugh here. We like to laugh or else we cry. There he is, Wooly Willie. He has a magnetic personality and you can make him look like lots of things, including a devil with a twirly mustache. You must pay the rent. I can't pay the rent. You must pay the rent. I can't pay the rent. Anybody remember that? Okay, now I'm really dating myself. I'm 100 years old. There you go. Wooly Willie. I'm going to get one. Thank you for playing. I love you so much. Back to Marla. Oh, they're going to give Marla a mic.
Ma'am, I don't have any further questions for you. Defense counsel may have some questions. Thank you, ma'am.
Mr. Cruz, cross-examination.
Good morning, Ms. Lawson. How are you? I'm doing okay, Ms. Lawson. I'm maintaining. I thank you for being here today. I just have a couple of questions for you, if that's okay. I'd like to show you a couple of composite sketches that you did in relation to sightings in this case. I'm going to mark those exhibits as Defense Exhibit 23 and Defense Exhibit 24.
You know what I'm talking about, Ash.
I do have an objection to these exhibits, Your Honor. It's under 401 and 403.
All right. Let me ask you this question, Mr. Golden. Do you have an objection to the admission of those exhibits? Okay. All right. I'm going to let you get started. And if you choose to try to tender them, I will hear your objection.
Yes, ma'am. Thank you. Ms. Lawson, do you recall completing sketches on Friday, January 26, 2001? Okay. I'd like to show you, and would you recognize those sketches if you saw them? Okay. I'd like to show you two sketches.
He's going to object. The prosecutor intends to object to the admission into evidence of his own sketch artist's sketches. They probably look nothing like him.
Do you and let the record reflect that I've shown Ms. Lawson Defense Exhibit 23 and Defense Exhibit 24. Do you recognize Defense Exhibit 23 and Defense Exhibit 24?
Yes, sir.
Okay, and these are sketches that you did for Athens-Clarke County on January 26, 2001? Yes, ma'am. Do they appear to be altered in any way?
They don't look like it, do they?
No, ma'am, that's my knowledge. Your Honor, I would move to admit Defense Exhibit 23 and 24, and I could respond to the state's relevance objection.
Right.
I do have an objection under both 401 and 403.
All right, do you care to elaborate?
Yes, Your Honor. Well, one, none of the witnesses that would have potentially given a description to Ms. Lawson have been in court and testified. I do think we need to address some of this outside the presence of the jury.
All right, we will do that then. Ladies and gentlemen, I'll have you go sit in the jury room. Don't discuss the case. We'll be with you shortly.
Okay. She drew the sketches. She has authenticated these sketches as being the sketches that she drew. And now, yeah, of course you don't want them coming in because they look nothing like the defendant. What is going on with this prosecution? They don't care about the truth. They want a conviction. That's what in the damn hell is going on here.
Who has permission to have cell phones?
This is a modern day kill a mockingbird, To Kill a Mockingbird. This would be my prop. And this is, I didn't just pull this out for this case. This has been underneath my lady justice over there, propping her up since I started this YouTube channel.
With the exception, of course, of counsel who may not have been here yesterday. So I want to make sure everybody.
Arg.
While the jury is leaving, I'm just going to say for the audience, there are a number of people in here who may not have been here yesterday. So I want to make sure everybody understands the court's rule about cell phones. With the exception of the media, who has permission to have cell phones, with the exception, of course, of counsel and their staff, and with the exception of law enforcement and attorneys.
Yeah, there must be people in there using their phones because she said yesterday, like, I'm going to kick you out. Mom, I'm going to kick you out.
Oh, thank you very much. All right, y'all may be seated. Go ahead, Mr. Bolden.
Your Honor, what Mr. Cruz is attempting to introduce through Ms. Lawson, she did, I'm not denying that those are sketches that she made at Athens-Clarke County Police Department back in January of 2001 in relation to this case. What I would say, Your Honor, is that those sketches are from witnesses who describe seeing an individual in Deer Park days before January the 19th. I mean, that like, if Mr. Cruz asserts otherwise, he's mistaken. So these are not relevant. And so not only are they not relevant, any potential, just, you know, the fact that there were people that came to the police department and that gave descriptions to Ms. Lawson on that day in connection with this case is relevant under 401. And I think that the state's argument would really stop there. But even if there was some sort of probative value of that evidence, that it would be substantially outweighed by the risk of confusing the jury, because at this point we don't know who gave those descriptions and things like that. So these are not
Did you see what he
admissible.
just did? He just did like a bend and snap without the snap. He just did a full on, what do you call that? When you bend your knees, like a deep knee bend. Hold on a second. Hold on. Chris with a K Bolden with the deep knee bend, trying to make his point. Look, come back to your screen if you can. Stop your rage crocheting for 1 sec.
Relevant under 401. And I think that the state's argument would really stop there. But even if there was some sort of probative value of that evidence, that it would be substantially outweighed by the risk of confusing the jury, because at this point we don't know who gave those descriptions and things like that. So these are not admissible in the state's view under both 401.
Confusing the jury. These are sketches, and you can see because Mr. Thank you, Mr. Cruz, for holding it up so we can see it. They are sketches of a black man. They are sketches of a black man. Why did you call her in then, sir?
And 403.
All right, Mr. Cruz, any response?
Yes, ma'am. Under OCGA section 24-4-401, the term relevant evidence means evidence having, and I emphasize the language any, or the word any, but any tendency to make the existence of a fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And as the Honorable Court is aware, the threshold for relevant evidence is extremely low. The relevance of these photographs are that, the relevance of these photographs is that law enforcement, when they were speaking to individuals in the neighborhood, the individuals that they requested sketches of, as the Honorable Court is aware from the other states' exhibits, are any African-American individuals that were seen either the day of the crime or the day before the crime. I believe, I'll say this, and Mr. Boda has something to counter that, but one was December.
Why are they only asking for African-American people in the neighborhood? And if that's what they were asking for, if that was the call from law enforcement, anybody who saw an African-American person in the neighborhood in the days leading up to this murder, please call us and give us a sketch, then 100% this is relevant. 100%.
18th, which I believe is not December, please forgive me. January, Mr. Boda has something to counter that, but one was December 18th, which I believe is not December, please forgive me. January 18th, which was the day before the murder, but law enforcement found it relevant, and Ms. Lawson completed a sketch. The other one was an individual they did see in this one on January 19th. So the evidence is relevant to the issue of, on one hand, we have a young lady saying, hey, I see a guy running. She tells law enforcement that no sketches requested of that individual. However, law enforcement did request sketches of African-American individuals that were seen the day before, as well as African-American individuals that were seen not even at the scene, but the day of the fire taking place. Those are the individuals that they chose. So that's in response to the relevance objection by the state. And I know sometimes I confuse my words. Did I explain that wrong to the Honorable Court? Did I confuse the Honorable Court in any way?
I'm not confused.
Yes, ma'am. In regards to confusing the jury, I made it clear in my opening that law enforcement dropped the ball a couple of times. And this is a part of that. We have law enforcement getting sketches from January 18th. We have law enforcement getting sketches from a person, I think he was at the corner of Cooper Road, which is this individual, and Fawn Drive. But yet we have a young lady who explained to law enforcement that, hey, I saw this guy running. And law enforcement did not ask Ms. Lawson or that individual to complete a sketch. So that would be my response to the 401 objection, as well as the 403 objection, Your Honor.
These sketches were not done before the incident. These sketches were from people seen in the neighborhood before the 19th of January. But he's saying one of them actually was seen on January 19th.
All right, thank you, Mr. Cruz. Yes, sir.
So I would also point out, Your Honor, that the state did file a motion. Soddy motion is what we've been referring to it as throughout all the pretrial hearings and as we've gotten into the case. And, you know, the law is very clear that Mr. Cruz has to proffer that in advance for exactly this moment. The only person he identified in that Soddy motion was Chris Melton. So, and the whole purpose of that is for the court to be able to undergo a preliminary 403 analysis. I cited the cases to the court. I just remind Your Honor, among those being the Crumpton case out of the 11th Circuit. And so there is a substantial risk. Any probative value is substantially outweighed. And I'm not saying that there isn't probative value, to be very clear, Your Honor, but any arguable probative value is substantially outweighed.
I don't think he's trying to say that these sketches were other third-party culprits. I think he's trying to say that these sketches look nothing like my client.
Outweighed by the risk of confusing the jury, and I just don't think it's admissible.
Thank you. Anything further, Mr. Cruz?
No, ma'am, that's not my argument in regards to the 401 objection as well as the 403 objection.
Thank you. All right. With regard to this offer of these two sketches, at this moment in time, I don't find them to be relevant.
Yes, ma'am.
The evidence has been described as being related to a sighting of someone not on the date in question, and also the other one not in the vicinity of the incident in question. So I'm going to grant your motion. I will say this: should the evidence, as it goes forward, tend to establish relevancy, we
Look at Mr. Faust. Look at Mr. Faust sitting there. Okay. This could very well be a factually innocent Black man who has been sitting in jail since his arrest in 2024 on a 25-year-old murder case. You're watching the public gaslighting. That's a terrible term to use because this murder involves an arson of the public. Law enforcement asked for witnesses to come forward and tell the truth and talk about whether or not they saw any Black men in the area of the fire in the days leading up to the fire. Because oftentimes, you know, because you watch a lot of trials, the person who does the crime may case the joint out ahead of time, right? But now, all of a sudden, when the witness who drew these sketches is on the stand, who spoke to other witnesses who have not been called yet, and she's authenticated the sketches as things that she drew, judge is not going to let it in. I can't believe that there's not more public interest in this trial. You know me, if you've been watching my channel for a long time, you know that I'm rarely at a loss for words. I am at a loss for words. The only person in this courtroom who's entitled to a fair trial is that man. And when his lawyer, who I think is doing a great job, I don't know, I heard you guys say that Julie, what's her name, was killing him on court TV. Shock of the century. I think his lawyer's doing a great job because you can see what he's up against, okay? You can see the machine that he's up against here. He's trying to zealously represent his client, and he is being handcuffed at every turn, in my opinion. And you're watching it in real, well, not in real time because we're a little bit behind. This is in today time.
can revisit this issue. But for now, I'm going to grant your motion. I do also find in granting your motion, Mr. Bolden, that you have made a proper argument over 403. I think at this point, given the description, Mr. Cruz, that you have provided about where those two sketches came from, it is certainly falls under the description in 403 of confusion of the issues. And so I'm going to grant your motion at this time.
May I ask the Honorable Court, I know we have Court's Exhibit 1, which was the PowerPoint. I don't know if the Honorable Court issued a ruling on that, but which was the PowerPoint from the state. I asked the Honorable Court to admit as Court's Exhibit 1. Can we admit Defense 23 and 24 as Court's Exhibit 2 and Court's Exhibit 3 for the purposes of the record?
No.
Yes, ma'am.
No.
You may bring the jury out. Thank you.
I'm sorry.
Yes.
I just thought maybe the issue with Ms. Peavy Hall, we could address it now. Or do you
Go ahead. No, go ahead, since the jury's not here.
I'm not going to say the address again.
Sure.
On the record, and I don't think it went out on the broadcast, but I do want to let the court know that my understanding, after having spoken with our Director of Victim Services, is that that is the correct address for Ms. Peavy Hall, that she has not received a subpoena. Right. She began checking because she was notified by Dr. Lowe when Dr. Lowe received hers, but she is unaware of any subpoena that was mailed via, I guess, certified mail.
All right, thank you. Mr. Cruz, any comment? You want to speak to the staff that Mr. Yalamanchili talked about?
I do not. As I mentioned to the Honorable Court, I think you made your ruling on the subpoena issue, which I would abide by, of course. I'll just I'll perfect the record with a copy of the certified tracking and return receipt information.
All right, thank you, sir. You may certainly do that. I'm going to allow Miss Ashley Peavy to remain in the courtroom if she chooses. All right, will you bring the jury in, please? Thank you.
403 evidence is evidence permits the court to exclude relevant evidence if its probative value is outweighed by its prejudice. And that's what the judge just said. She just took a pill. She just took a pill? Hold on. We all need a pill. Give us some of what she's taken.
And from there, in regards to your process, understand that you have them look at photographs, and from there they pick the shapes and different portions, eyes, things of that nature that fit the individual that they see. Is that correct? Okay, and I've had opportunity to look at the Eric Rudolph sketch. I'm sure you have because you've completed it. Typically, when you complete sketches and they're on the 8 scale, as you mentioned, are they pretty much similar to the person's description, accurate to the description that you receive? Okay, excellent. Do you keep any notes in regards to those pertinent, or at that time, would you keep any notes in regards to the pertinent facial features that an individual described?
I fill out incident reports of each composite drawing that I do, and will sometimes, state whether or not I had any problems or anything was said about, when we were complete, and should they circulate or whatever. Did they feel good about it? And well, that's why how we determine the completed, thing, sketch.
Absolutely. So there's I'd like to show you a document. I ask for your patience for a second. I'd like to show you a document that I am going to mark as Defense Exhibit 25. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 25. Okay, if I approach you, Ms. Lawson?
Yeah,
She said go for it.
okay.
All right, in regards to Defense Exhibit 25, is that the document that you're speaking of when you say report, or is it a separate document?
That's the document.
This is the document. Okay, excellent. Your Honor, you recognize this document, correct?
Yes, sir.
Okay, and is it a fair and accurate depiction of the document as you remember creating?
Yes, sir.
Okay, and does it appear, outside of the Defendant's Exhibit sticker, does it appear to be altered in any way?
No.
Okay. Your Honor, I would move to admit Defense Exhibit 25 into evidence.
Any objection?
Generally, no. I think that based on the court's ruling just a few minutes ago, parts of it would have to be redacted. So
Right.
subject to that redaction, I don't have any objection.
All right, Mr. Cruz, you want to be heard on Mr. Bolden's comment, redaction.
Yes, I do. Of course, indulgence. Let me make sure I'm 100% clear.
Sure.
What does he want to have redacted? He doesn't specify. And yet, the defense attorney must be so specific, but the DA can just speak in general terms, or the ADA, whatever he wants. Generally object in a general way. But Mr. Cruz, you better be specific.
The state's objection, and I do believe, based on your prior ruling, I would not be able to admit that evidence. So I don't have any objection.
All right, so I just want to make sure we're clear that state doesn't have any objection over the admission, except for certain portions that need to be redacted based on my ruling, and you agree with that?
I don't agree, but I respect
Not
the
objecting to
position.
that.
Correct,
Okay.
yes, ma'am.
All right.
And I just want to be clear because what I think I heard, and correct me if I'm wrong, is that he's now not intending to tender the document.
No.
No, that's incorrect. I do intend to tender the document, Your Honor.
But you're not objecting to the comment, the argument that Mr. Bolton made about certain portions need to be redacted according to the ruling the court has made.
Correct.
All right, then I will admit it with that understanding, and it can't be certainly circulated to the jury until I take a look at that document. We all agree what needs to be redacted, but I will admit it. Go ahead.
So in regards to, and I may need to give you this, in regards to suspect number 1, the composite reconstruction notes, would you agree that you put that the male was black? Is that fair? He was 18 through 21 years of age.
If you could just answer with your voice, yes or no?
Yes.
Thank you very much.
Thank you. He has an orange shirt. Is that correct?
Yes.
Medium brown complexion. Is that right?
Yes.
Short 2-inch afro. Is that correct?
Yes.
I need to ask you a question about something. I'm personal.
Okay.
Yes.
And slight mustache. Is that correct?
That's right.
Okay. And I'd like to show you what's been marked as defense States Exhibit 99.
I'm not speculating about her pill. I just think she gave herself a headache. Gave me a headache.
I'll give you one of these today. With the description that we put in our report, which exhibit does that description apply to?
You know, I don't know.
Sir.
Either the suspect, one or two. But I should have wrote it legibly across the top maybe. So this was just long gone of a time period. Could have figured out who was who.
Yes, ma'am.
Oh, she can't figure out who was who? It doesn't say anywhere who was who with regard to her notes? Hold on.
That's fair.
Either the suspect, one or two. But I should have wrote it legibly across the top.
With the description that we put in our report, which exhibit does that description apply to?
You know, I don't know.
That's
She
fair.
doesn't know.
Either the suspect, one or two. But I should have wrote it legibly across the top maybe. So
How many suspects were there
Long gone of a time period.
that were never followed up on?
Yes, ma'am. In regards to Ms. Tiffany Riker, I'm going to show you what's been marked as defense exhibit 25, okay?
Okay.
In regards to Ms. Tiffany Riker, we don't have a description that she provided. Is that correct?
Let me see. If I wrote anything down.
Was Tiffany the woman in the tow truck? Remind me, because I was sick yesterday.
No, but the suspect too was listed.
Your Honor, what?
Objection was sustained as to portions of that document.
Tiffany was the went back into the driveway?
Ms. Lawson's been questioned about the parts to be
All right, let me see counsel to the bench with the exhibit, please.
Your Honor, this is going to be really, really, really damaging to my case if everything is
Thank you. Your question
mislabeled and
remains
mismarked, just like all of the other evidence that we saw with empty envelopes being admitted into evidence. And Your Honor, this is really, really, really going to hurt my case. And he's tapping and he's moving his fingers around and he's reminding me of the actor who played Creighton Waters in the Murdoch Hulu series. Got some more room to move here. I feel like Mr. Cruz is like hearing music in his head. He's kind of bopping around, although I do have it on 1.5 speed. He's trying to get into his Zen zone, and who could blame him, really?
I'll certainly let you, it's been admitted. Well, it has actually been admitted, but 25 has been admitted. Yes, Mr. Bolden, it's been admitted. I'll certainly let you now use the redacted, according to the court's ruling, Exhibit 25. You may proceed.
Oh, Hulu did Murdoch, yeah.
Ms. Lawson, did you forgive me?
With it was really good too.
In regards to Ms. Tiffany Riker,
Trisha Arquette plays Maggie. It's really good.
in regards to your description of Ms. Tiffany Riker, would you agree that we don't have a description of the composite sketch completed for Ms. Riker?
I don't see it, yeah.
Yes, ma'am. And in regards to the 1 through 10 scale, on the document Defense Exhibit 25, we don't have a notation of whether it was a 8, 9, or 10.
No. Sometimes I don't write it on the originals because nobody knows what it means.
That's fair.
I guess I should have written it on there. I'm just accustomed to fly by night, I guess.
If it's okay. Take that back.
Yeah.
I'd also like to show you what I am marking as Defense Exhibit 27. I'll let the record reflect that I am showing the state what has been marked as Defense Exhibit 27. Let the record reflect that I am showing the witness what has been marked as Defense Exhibit 27. May I ask you some questions about Defense Exhibit 27?
Mhm.
Do you recognize Defense Exhibit 27?
Yeah. That's what my hope was.
And what do you recognize Defense Exhibit 27 as?
Well, homicide, arson, and, what we drew
Is it,
posits, yeah.
yes, ma'am. Is it fair that is it fair to label it as a summary of the work that you were doing in regards to the date and who asked you to come in?
Yes.
Outside of the defendant's exhibit signature, has it been altered in any way?
No.
And that is a very accurate description of the document as you remember.
Yeah.
Thank you. I would move to admit Defense Exhibit 27 into evidence.
I do have an objection under 401 and 403 to the entirety of that document.
All right.
She's your witness, counselor.
I think it's probably necessary.
All right, ladies and gentlemen, if you go to the jury room, judge discuss the case. We'll be with you shortly. We are taking a lunch break relatively soon.
Wow. Your Honor,
I
once
believe-
again, Your Honor, it's really, really, really bad for my
Evidence
case.
it has is substantially outweighed. The probative value that Mr. Cruz might argue is once again substantially outweighed by the risk of confusing the jury because there's reference to these other suspects, which we all agree, or he doesn't agree, but which I have asked the court and the court sustained my objection relevant to that is also on that cover sheet as well. So again, first of all, under 401, it's not relevant. Second of all, under 403, whatever relevance it has is substantially outweighed by the risk of confusing the jury.
All right, thank you. Mr. Cruz.
Sure. So in regards to the state's 401 argument, relevance, the relevance of this document is twofold. One, the testimony has shown that these individuals saw three different people walking through the Deer Park neighborhood. Okay. Ms. Lawson stated during her testimony that the date that she spoke with these individuals was January 26, 2001. So that testimony has been elicited. It's also in this document as well, just stating on Friday, January 26, forensic artist Lawson traveled to the Athens-Clarke County Police Department, so on and so forth. So that's one. Secondly, Your Honor, I believe based on, and this is not in evidence, but just for the purposes of speaking to the Honorable Court, I believe her sketches are very accurate. I looked at the Eric Rudolph sketch. I believe the individuals in those sketches are the individuals that gave the information saw. So I'm just putting in place that she did it on February 26th, and to bolster the, and I know maybe the wrong word, but to bolster the accuracy of the sketches. That's all, Your Honor.
Okay, well, that's an improper use of, evidence. First of all, bolster is probably not the word you needed to use. I
Correct.
will agree with you on that.
Support that.
I know what you're saying, but
Yes, ma'am.
bolstering is not
And then
proper use of it. But I guess not. Can I see the exhibit? I'm
Yes,
not
ma'am.
really sure what we're talking about.
May I approach?
Yes, of course. Thank you.
Right. Unless it matched him, then they'd be all over it.
And if I could add, it's a memorialization of the date that she conducted those sketches.
Thank you. Mr. Cruz, can you respond to Mr. Bolden's argument that the reason that 403 is implicated is
Sure.
the reference to, I'm assuming you're saying the phrase composite sketches of three suspects. Is that what you're referring to, Mr. Bolden?
Yes, and I think I'm sorry, Your Honor.
And composite sketches of the suspects. I mean,
Three
is that what you're saying?
suspects.
Okay.
So
Okay.
the word suspects, plural, is mentioned twice in this document.
Okay. And you're saying because there were only two witnesses who have been identified as producing testimony to this witness to produce sketches that the three suspects violates 403.
Right.
All right. Okay. I just want to make sure I understood your argument. Can you respond to that, Mr. Cruz?
Sure. Which portion of 403 are we, do I need to address?
Well, I would say in general, certainly, but I mean, the state's argument to the court was that it was confusion of the issues.
Sure.
That was substantially outweighed by.
Sure. Goes without, as the Honorable Court is aware, the issue that the jury has to decide is whether or not Mr. Faust is guilty of the charges in the indictment.
I know that, but with regard to that specific argument on this document about the three suspects, can you tailor your argument to that?
Sure. It's general. We have stated that there were three different individuals, actually four. The state's evidence, they introduced Mr. Matt Owens yesterday. He said he saw a black male with a white shirt and jeans. They introduced evidence from Ms. Tiffany Schroeder. She gave a description of the individual that she saw as well. They also introduced evidence from Ms. Karen Williams. She gave a description of the individual that she saw. So we do actually have three. We have four, but outside of those three, we do have three individuals that have stated that they saw a black male walking in the neighborhood. And we can also add four with the witness that came in today and mentioned the individual that he saw walking down the street as well. So I don't think it would confuse the jury because they've already heard evidence of multiple individuals in the neighborhood. John.
All right, thank you. All right, so that gives me a better explanation of where you are coming from, Mr. Cruz. So this is sort of a two-part moment. The state's argument that this violates 403, I think, is accurate. I'm going to grant your motion because it's in relation to this witness. Regardless of what you've just mentioned, and I will talk about that because I don't mean to suggest that is, I don't mean to be flippant in that way, but I want to talk about your specific argument. With regard to this witness has been identified as the person who made the two sketches that are in evidence, And so the state's argument that this cover letter, and I don't find it to be relevant, but regarding 403, the state's argument that this cover letter violates 403 is appropriate because it refers to three different sketches. It, in this particular moment with this witness, does certainly create confusion of the issues.
Yes, ma'am.
I am not prohibiting you from discussing the testimony in the way that you have just described it. You have described the four witnesses that the state has presented, talking about a person they saw in the neighborhood as being four different suspects. The state may choose to refer to those witnesses' testimony differently. But I'm not prohibiting you from talking about those, the comments that the witnesses have made in court about the person that they saw in the way that you've just described.
Yes,
but with regard to this witness and this exhibit, I am going to sustain your objection.
Your Honor,
I'm going to grant your motion, sustain your objection for those reasons.
Your Honor, for the purpose of the appellate record, would the Honorable Court be willing to admit this as court's exhibit? I believe that would be 4.
I don't think that's appropriate, Mr. Cruz. I'm not going to do that. All right, I'm going to give this back to you. All right, anything else before we bring the jury back in?
Your Honor.
All right, Mr. Cruz, you ready for the jury?
Yes, ma'am.
All right, thank you. You may bring the jury back in.
Hopefully we can fast forward through a lot. Through lunch. I don't know how long the lunch was today.
Did you care to call?
No, ma'am.
All right, thank you. You are direct, Mr. Bolden. May this witness be excused. Mr. Cruz, any objection?
No, ma'am.
All right, thank you. You are excused from any further service. Mr. Bolden, did you care to call the next witness? Is this a witness that we can call and then take a lunch break?
We could, Your Honor.
All right, very good.
Well,
Wait,
yeah, we can.
all right, we're going to do that. And who is your next witness that you care to call?
KYLEE TRAUB?
Could you please get KYLEE TRAUB?
Let's see what Kylie's got to say.
Ma'am, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay. You can have a seat. Ma'am, if you could state your name and spell it for the record, please.
My name is KYLEE TRAUB, KYLEE TRAUB.
Ma'am, how are you employed?
I am employed as a latent print examiner at the Georgia Bureau of Investigation in the Division of Forensic Sciences, and this is commonly referred to as the State Crime Laboratory.
What are your responsibilities in the, at the crime lab?
My responsibilities include, but are not limited to, processing evidence for the presence of latent prints, photographing any latent prints that are developed on these items, conducting comparisons of latent fingerprints to known fingerprints, running searches on the FBI NGI database as well as the Georgia APHIS database, and writing all of my conclusions in a report that I can testify to in court.
Can you tell us a little bit about your education, training, and experience as it relates to that job responsibility?
I received my Bachelor of Science degree in chemistry from the University of Wisconsin-Green Bay. I then completed the 20-week National Latent Print Examiner Training Academy in Meridian, Mississippi, as well as the latent print processing and latent print examination training programs at the GBI.
And can you testify generally about how one might search for fingerprints on items of evidence?
So for items of evidence, they are typically processed based on what type of evidence they are. So a non-porous item such as glass, metal, or plastic would be processed one way, whereas porous items such as paper, cardboard, or things like that would be processed in another manner.
Okay. And why would that be the case? Why would there be a difference in the way that they're tested?
The difference is due to the non-porous items, your glass, metals, and plastics. These items are normally smooth and shiny surfaces, so a fingerprint could be easily wiped off. It's not going to be absorbed into that surface. So we are trying to preserve those as best as possible. And then a porous item, paper, cardboard, these items are going to more absorb the fingerprint residue. So we are going to apply different chemicals to be able to make those visible to the naked eye.
Have you had the opportunity to come to court to testify before about latent print processing at the GBI Crime Lab?
Yes, I have.
Approximately how many times?
Approximately, I believe 7 times.
And during those times that you previously testified, have you been qualified as an expert?
Yes, I have.
In what areas?
In the area of latent print processing and examination.
At this time, Your Honor, I would move to tender Ms. Traub as an expert in latent print processing.
Any objection, Mr. Cruz? No, ma'am. This witness is admitted as an expert in latent print processing. Go ahead.
Thank you, Your Honor. Ms. Traub, did you have the opportunity to test certain items of evidence for the presence of or lack of presence of latent prints in connection with the case involving a victim by the name of Tara Baker?
Yes, I did.
Okay. And if you are aware, were certain items tested back in 2001?
Yes, some of the items that I tested were previously tested.
And what would be your reason for then going back and retesting them?
We have some new chemicals that we did not have in the past that we have access to now to conduct more testing.
Are you aware of what the results were back in 2001?
I do not know exactly what processes were applied, but I do know what the results were, yes.
What were those?
Those were negative results.
I mean, there were no prints.
That means there were either no prints that were potentially suitable for comparison, or yes, no prints at all.
I do have it sped up because I want to be able to finish day 4 today so that we're not too far behind.
May?
This has been marked States 107. Actually, hold on to that for the time being, okay? So you mentioned testing some items of evidence as it relates to this case. Was one of those things a power transformer?
Yes.
And all right. So
open up the bag and see if it's in there because we
you recall what testing procedures you performed on that piece of evidence, ma'am?
If I'm able to refer to my notes, I do.
Absolutely.
For the power transformer, I would have conducted a visual examination where I look at the item of evidence as it was received to see if there are any visible latent prints. I then applied a chemical known as lumicyano. This is a fluorescent superglue, so any latent prints that are developed would also fluoresce so that I could look at them under a light source. And then I also applied what is known as powder in suspension. This was a white in color chemical, and this can render any fingerprints that might be in blood visible to the eye.
Okay, the
Moving along.
significance of this is that Tara Baker was strangled with a power cord from a printer, and back in the day they still have they used to have these big black boxes that were it was like a transformer on a cord. Maybe they still do in some places, and that's what he's talking about when he says transformer. It was kind of in the middle of the cord, right? I think they showed a picture of it earlier.
On to
That was one of the murder weapons, let's just say.
the next piece of evidence. That the knife set. The knife block, referred to as, I'm going to use the crime lab's number, item 13.
Yes.
Do you recall performing testing on that piece of evidence?
Yes, I do.
And what testing did you perform on it?
For the knife block, I also started with a visual examination. This was followed by lumicyano again, the fluorescent superglue. I then applied DFO and anhydrine. These are chemicals that are used for porous processing. Since the knife block was made of wood, it would absorb fingerprint residue. So I applied those chemicals to look for that type of evidence.
Okay. Next, I want to talk about item 14, and using the crime lab number. Is that some stove knobs?
That is correct.
Can you describe the testing you conducted on the stove knobs?
On the stove knobs, I conducted my visual examination followed by the lumicyano.
Okay. And then lastly, on states 15. I'm sorry, crime lab 15.
Yes.
States 94. Excuse me. What item of evidence was that?
This item of evidence was a knife.
What testing did you perform on the knife?
On this knife, I performed my visual examination followed by lumicyano and the white powder in suspension.
As it relates to all 4 of those pieces of evidence, can you testify as to the results of your search for fingerprints?
For all of those items, the results were negative for fingerprints.
And is States 107 a report that fairly and accurately summarizes the testing that you performed and the conclusions that you reached?
Yes.
And is it signed and dated by you? Or signed with a date on it, I guess?
It is signed with the date that the report was released, yes.
Tender States 107 at this time.
Any objection?
Yes, Your Honor.
Any response to the hearsay objection, Mr. Bolden?
No, Your Honor.
Okay, I will admit it over objection.
Ma'am, those are all the questions I have. Defense counsel may have some questions. Thank you.
Mr. Cruz?
I don't have any questions for you. Thank you for your service.
Thank you.
May this witness be excused, Mr. Bolden?
Yes.
Any objection by the defense?
No, ma'am.
You are free to go.
Thank you.
You may call your next witness.
Okay, I'm muted. Sorry. There were no prints. Just to recap her testimony, there were no fingerprints found on the power transformer, the knife block, the knife. What was the 4th item? The chat is frozen right now for some weird reason. I know I unmuted myself. The chat is frozen. There was a Farberware knife and Farberware knife block. We did see that, hear that yesterday. What was the fourth thing? Okay, room to move. Not even the roommates, right? Somebody cleaned it. Somebody cleaned it all. Somebody wiped it clean. Remember, Chris had dropped out of medical school at this point. What is she scratching her nose about now? The oven knobs. Okay, so there's no prints on the oven knobs either.
Could I step into the hallway for just a minute to make sure that witness is out there?
Yes.
And remember, she used to make cheesy grits every morning. Her fingerprints would have been on those oven knobs if she made them on the stove. And remember, one of the firefighters said they had to put the knobs back on the stove to turn the oven off. I'm not sure what they're waiting for, but we're going to FF right through it.
Where were you employed at that time, sir?
I thought she said, do you have one last witness and then we'll let them go to lunch, but I guess not.
Sir, if you could raise your right hand. Do you swear or affirm that your testimony in the matter pending before the court should be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can have a seat. You could state your name and spell it for our court reporter, please.
My name is John Newton, John Newton.
And Mr. Newton, going to refer you back to 2001. Where were you employed at that time, sir?
I work for the Athens-Clarke County Police Department.
How long did you work for the Athens-Clarke County Police Department?
12 years.
Okay. And during that time, were you a post-certified peace officer in the state of Georgia?
Yes, sir.
And what is that? What does post-certification mean?
Post is the standards council that creates the standards for police officers for what it means to be, I guess, an accredited police officer in good standing.
Basically, a sworn officer, is that fair to say?
Yes, sir.
And did you work anywhere else in law enforcement after Athens-Clarke County?
After? No, sir.
Okay. Back in 2001, did you help with other officers in the investigation into the sexual assault and murder of Tara Baker at 160 Fawn Drive?
Yes, sir.
And are you familiar with that, where that address is?
I'm familiar with the general area. I don't think I could drive you to right where it is, but right off of Lexington Road, near the church and that neighborhood back in there.
Is that in Clarke County?
Yes, sir.
Now, I know you had a lot of involvement in that case, but I want to focus on just a few very specific things. In the days immediately following Ms. Baker's death, did you have an opportunity to collect head hair samples from certain persons in Tara's orbit?
Yes, sir.
Okay, did that include known hair samples of her roommates, Ashley Peavy and Valerie Lang?
I believe so, but off the top of my head, I couldn't tell you. Like, I would have to look at my report.
Would that help refresh your recollection?
Yes, sir. That would be wonderful.
I'm going to go fill up my iced coffee. Don't worry, I'll be listening in the background and I will return to you. Never fear, I'm always here.
You may.
Thank you. Yes, sir.
I actually the same question. Did that include collecting known head hairs from her roommates, Ashley Peavy and Valerie Hall?
Yes, sir.
Did it also include collecting head hairs from Chris Melton?
Yes, sir.
You may.
Then I'm going to hand you what I marked. It states 108, 109, and 110. Do you recognize those items, sir?
I recognize what they are. I can't say off the top of my head,
Sure.
This is it, but yes, this is my handwriting on these, and these would be evidence bags.
And do you take your time to review those items in their entirety? On each of those items, do you see your name or initials on a piece of evidence tape?
Yes, sir. My initial is on, or my signature and or my initial and my handwriting is on each of these.
And what do they appear to be?
One is the known head hair of Ashley Peavy.
Is that 108? With the evidence stickers?
Yes, sir.
States 109, what is that?
Known head hair of Valerie Lane
And then 110?
is the known head hair of Chris Melton.
And again, just to be clear, when you collected each of those items, 108, 109, 110, what would you have then done with them?
Put them in the bag, sealed them, put my initials on them, and placed it in an evidence locker.
Okay. And from that point on, would you have any idea what may have happened to those pieces of evidence?
I would have an idea, but I wouldn't do anything with them.
Okay.
I mean, I put them in there for the purpose of, further examination, but I wouldn't be involved in that.
I would move to tender states 108 through 110 at this time.
Any objection?
Yes, ma'am. Lack of foundation, one, we don't, excuse me. First, lack of foundation, we don't know if anything is in the bag. I would ask that the witness is allowed to identify what's in the bag. Two, if the bag is what the state seeks to introduce with the writing of whose name it is, I would object to relevance, as the bag is irrelevant to any issue in this case. It's what's inside of the envelopes. So those are my two objections.
Thank you, Ms. Cruz. Ms. Bowman, you care to respond before I make a ruling?
No, Your Honor.
All right. The foundation has been laid for the purpose of admission of evidence. I'm going to admit them over objection.
I'll take those back from you. And then at some point later, in your participation, it's hard to say, in this investigation, did you have the opportunity to once again meet with Chris Melton in an attempt to obtain his pubic hair samples?
Yes, sir.
Sorry.
Okay.
I'm
And as you sit here
sorry,
today, 25 years later,
Okay, if you missed the testimony from day 2, the witness was asked to open up the evidence bags to see if there was any hairs in them. These are the hairs that were found on the victim's body. And they were empty. 3 envelopes were empty. I guess the judge doesn't want that mess on her hands anymore, because now she's just going to allow it in. I hope on cross he asks him to open those envelopes, because empty bags are often just let into evidence, and then the defense attorney had them marked. Let's hear that again.
Involved in that.
I would move to tender states 108 through 110 at this time.
Any objection?
Yes, ma'am. Lack of foundation, one, we don't, excuse me. First, lack of foundation, we don't know if anything is in the bag. I would ask that the witness is allowed to identify what's in the bag. Two, if the bag is what the state seeks to introduce with the writing of whose name it is, I would object to relevance, as the bag is irrelevant to any issue in this case. It's what's inside of the envelopes. So those are my two objections.
Thank you, Ms. Cruz. Ms. Bowman, you care to respond before I make a ruling?
No, Your Honor.
All right. The foundation has been laid for the purpose of admission of evidence. I'm going to admit them over objection.
No, Your Honor, because I know exactly how you're going to
I'll
rule,
take
and you're
this
going to
back
rule in
from
my favor, so I don't need to. I don't need to have any. I don't need to respond.
And then at some point later, in your participation, it's hard to say, in this investigation, did you have the opportunity to once again meet with Chris Melton in an attempt to obtain his pubic hair samples?
Yes, sir.
Okay. And as you sit here today, 25 years later, do you remember exactly when that might have been?
Now, without looking at my report, sir.
They asked him for pubes. I can't stop to show you day 2 testimony, but you can go back and watch the stream from day 2, and you will see it. Maybe he'll do it on cross. Hold on.
When you would have collected known pubic hairs from Chris Melton?
Yes, sir. It was on February 27th of 2001.
Where did that take place?
This is the GBI office in Gainesville.
Wait, did he say February 27th, 2001?
Where did that take place?
This is the GBI office in Gainesville.
When you would have collected known pubic hairs from Chris Melton?
Yes, sir. It was on February 27th of 2001.
Where did that take place?
This is the GBI office in Gainesville.
I had him come down to the GBI office, Chris Melton, and turn over his pubes. Wow.
State 111. One last thing. State 111. Actually, take a look at that.
Yes, sir.
And do you recognize that?
Again, I recognize my handwriting and everything's on it. I write. It's a evidence bag with my handwriting and my initials and the date of February 27th, 2001.
Does it have markings that would indicate what?
Oh, I'm sorry. It's the known pubic hair of Chris Melton.
I moved to tender states 111.
Any objection, Mr. Cruz?
Yes, ma'am. Like a foundation to the item that's in the bag, and Rule 401 is relevant to the state is intending to just introduce the bag.
Mr. Bolden, any response?
Your Honor, it is relevant. Mr. Cruz has made chain of custody an issue in this case, so we're attempting to introduce the bag. The state will then go on to introduce what the contents of the bag. And so this is necessary for the first step, so I think it is relevant.
I'm going to admit it over objection.
Of course you are.
And again, kind of like before, Mr. Newton, when you collected those, how would you have them packaged them in item State's Exhibit 111?
Right. We would take the evidence, put it in the bag, seal the bag, and put it in the evidence locker.
And understanding, as before, you might have some idea about what happens from that point forward. Did you have any further involvement with State's Exhibit 111?
I did not.
Sir, those are all the questions that I have at this time. Defense counsel may ask questions.
Mr. Cruz, cross-examination.
Good afternoon, Mr. Newton.
Good afternoon, Mr. Cruz.
I did not know you would be testifying this fast, so forgive me.
I did not know that either.
I have a couple.
He didn't know he was going to be testifying today? Or that fast? Wait a second. Or this morning. And I notice how Mr. Cruz always looks at the clock
Questions
before
for
he
you.
addresses the witness, but so that he knows whether to say good morning or good afternoon. I just love his Southern gentleman type manners. I just do.
Good afternoon, Mr. Newton.
Good afternoon, Mr. Cruz.
I did not know you would be testifying this fast, so forgive me.
I did not know that either.
I have a couple of questions for you. Is it okay?
Yes, sir.
Thank you. On January 21st, 2001, do you recall capturing pictures of Mr. Chris Melton's hands?
I apologize, Mr. Cruz, but I do not. I probably wrote a report, and if I could look at the report, I could tell you. But this long afterwards, I can't say that I have an independent recollection of what happened.
If you haven't seen the pictures of Chris Melton's hands, it might remind you of the pictures of John O'Keefe's arm.
Yes, sir. That is fair.
I think I know why he's not ready, because the judge did say we're going to take one more.
So
witness
what I would do, I'm going to provide you a copy of the report as well as the photographs to give you a
Yes, sir.
look over. Is that okay?
That's great, sir. Thank you.
Perfect.
I haven't seen, Your Honor.
Right? Didn't she say we're going to see do one more witness and then go to lunch? He thought he had time over lunch, but he didn't, because of course that's not what she did. They're doing a little powwow, like, how can we keep this out? Yama lama ding dong, chiming in. Yeah, Sunshine is like, do they intend on proving this guy did the crime? Because I haven't seen any evidence so far.
Yes, sir.
Yes. Kraft Haskell says Chris's handpicks are all over X now. You've brought attention to this, Melanie. I don't know if it was me, but good. I don't care. The word needs to get out. More people need to be watching this trial. Devil went down to Georgia. Yeah, or Colin Albert's hands, right.
I'm not sure the appropriate way to answer this. I recognize what the photographs of and what this says. Do you by chance have a report that I wrote with this?
I may. Court's indulgence.
Court's indulgence. This is like night court.
Are
right?
of recognize the photo log and what's listed here, and what the pictures are of.
What are those pictures of?
These are pictures of hands along with a ruler showing injuries to a hand.
And can you
and to fingers, back of the hand, those sort of things.
And do you recognize that property sheet?
This is my handwriting on this property sheet. It's a property sheet that I filled out on January 21st, 2001.
Okay, and it states photographs of Chris Melton's hands?
The photo log states that, and then the sheet that says it, and then the evidence sheet says are pictures of Chris Melton. But you're right, the photo log shows what each specific photo was of.
Sure, and that's the report I was looking for. I realized I gave it to you. So yes, that is the cover sheet, and the following photos would be what was included in the discovery.
Yes, sir.
But that's it. Do those photos appear to be a fair and accurate depiction of the photographs that you took of Mr. Melton's hands?
Yes, sir.
Okay. Do those photographs appear to be altered in any way?
They do not appear to be altered to me, no, sir.
Let the record reflect that I am marking Detective Newton's property and evidence record sheet of pictures of Chris Melton as defense exhibit.
Let's see him.
28.
That's what I have. I think that's right, Ms. Cruz.
Yes, ma'am. Thank you, Your Honor. And let the record reflect that I am marking photographs of Chris Melton's hands as defense exhibit 29. Detective Newton, I have a few more questions for you in regards to the property form. I want to ensure I lay the proper foundation for that form.
Yes, sir. Yes, sir.
He's like, I learned all about proper
Thank you.
foundation. I know how this judge is. I got to do it right.
Now, you testified that you recognize the document. Has that document, does it appear to have been altered in any way?
No, sir. It does not appear to have been altered.
And is it a fair and accurate, or is the document a fair and accurate copy of the document as you would remember it?
Yes, sir.
Thank you. Your Honor, I would move to admit defense exhibit 28 and 29 into evidence.
Any objection? They are admitted.
I would ask for permission to publish defense exhibit 29 to the jury.
Granted.
They're going to put him up on the big screen.
And Detective Newton, you would agree that those photographs were taken 2 days after Ms. Baker's death?
Okay. I would agree they're taken on that date. I apologize. I don't remember the exact date of the incident, but on the date that's listed there, I would agree. Yes, sir.
Okay.
January being that's probably 2 days, an answer yes, but I apologize. I didn't review very few things before coming here.
That's on me. So I'll say this.
But the date on that would be the date that all that would have taken place. Yes, sir.
That is January 21st, 2001.
Yes, sir.
Thank you. Do you recall obtaining phone records from Ms. Tara Baker?
I don't recall that specifically, but I would be surprised, if that's not something we did.
Would seeing for purposes of the record, it is a copy of Detective Newton's affidavit in reference to phone records court order for the phone number 706-316-9760.
Your Honor, I would again ask that Mr. Cruz show me something before he tries to hand it to a witness.
That's correct.
I apologize. I'm just moving too fast. I'm sorry.
I'm going to use the binky emoji now. The binky emoji is now officially assigned to Chris with a K Bolton, the ADA, trying this case. He sounds like a whiny baby. Your Honor, can you please show me what he's going to
Tries to hand it to a witness.
That's correct.
I apologize. I'm just moving too fast. I'm sorry.
Your Honor.
Your Honor, I would again ask that Mr. Cruz show me something before he tries to hand it to a witness.
That's correct.
Again, Judge.
Too fast. I'm sorry.
Yes, sir. Thank you.
I'm really liking 1.5 speed today, I got to be honest.
All right. Have you had an opportunity to look at the documents provided to you?
Yes, sir.
Okay. What would you describe those documents as?
Phone records for the phone number
Please.
706-316-9760. So they show phone calls, time of duration, whether it was answered or not, carriers involved in some instances, and it has dates and times of the calls.
Yes, sir. And would you have any reason to agree that those are Ms. Tara Baker phone records?
That's certainly what they appear to be.
May I approach you?
Yes, sir.
Oh, I don't know, Zoe. Zoe says, did the police sketch artist draw Eric Rudolph or Richard Jewell? Because this earliest sketches were of Richard, who was wrongly accused. Thought she said Eric Rudolph, but
Thank you,
go
sir.
back and listen. Maybe she did both. I don't know.
Let the record reflect that I provided you with a pen and a sheet of paper. Is that correct?
Yes, sir. Blank piece of paper with lines on it, blue pen.
And a pen. You're actually going to need these shoes.
Yes, sir.
We've already agreed that those records that you have are Miss Baker's records, correct?
Yes, sir.
Would you mind writing on that sheet of paper Miss Baker's phone number based on those records?
I would object. He is asking the witness to testify about an item that is not in evidence.
Any response, Mr. Cruz, to the objection?
No, ma'am. This witness has personal knowledge of those items, so I would just ask that I have no response other than this witness has personal knowledge of.
I mean, with regard to the evidentiary objection, Mr. Bolden, he is correct. I'm going to sustain the objection.
Yes, ma'am. Court's indulgence.
Yes, sir.
Let the record reflect that I am marking the items identified. I know I've been calling you Mr. Newton. It just feels so natural to call you Detective Newton. Can I call you Detective Newton?
Sure.
Okay. The items, let the record reflect that I am marking as Defense Exhibit 29.
You've done 29. I think you're on 30. I think that's right. Do you have that, Ms. Satterfield? Thank you. Yes, number 30.
Let the record reflect that the items that Detective John Newton has identified as Ms. Baker's phone records have been marked as Defense Exhibit 30, and that's in regards to number 706-316-9760.
Since I don't think they're going to show us the hand pictures,
Let the record reflect that I am showing the state what has been marked.
I'm going to show you the hand pictures in case you haven't seen them. So just for one quick moment, come to your screen right now. YouTube probably doesn't like these pictures, but I don't care. I'm going to show them to you. Here we go. These are the way Chris Melton's hands looked. What did they say? 2 days after the murders? There you go. There you go. 2 days after. I don't know. Does it look like he might have beaten the bejesus out of somebody? I don't know. Just a guess. Innocent until proven guilty, which is the way it's supposed to be for all defendants, including
as
Mr.
number,
Faust.
Tara Baker phone records. Defense Exhibit 30.
That was the boyfriend, Chris Melton's hands 2 days after the murders. Who was out on the double dates with the?
And these phone records appear to be altered in any way?
No, sir, they do not.
And is this a fair and accurate depiction of the phone records as you remember seeing them 20 plus years ago?
Oops. Oh, sorry. I did something bad. I did something bad, as Taylor Swift would say. I did something bad. Hold on.
Phone records appear to be altered in any way?
No, sir, they do not.
And is this a fair and accurate depiction of the phone records as you remember seeing them 20 plus years ago?
It's a fair and accurate representation of what we would receive as phone numbers. Again, I don't know that I have any independent recollection, but to the best of my knowledge and ability, those would be the phone records.
Yes, sir. Thank you. Your Honor, I would move to admit into evidence Defense Exhibit 30.
Any objection?
I don't think that's a proper foundation for the admission of business records. So I do object to Mr. Cruz attempting to tender those records for this case.
Yes.
All right, Mr. Cruz, any objection before I make a ruling? Any response before I make a ruling about the objection?
Sure. So Detective Newton obtained these records via a court order. So I do believe there's to respond to their objection. He received these records via a court order, Your Honor.
I don't think that overcomes the objection that the state has produced, which is that it's not a proper way to introduce business records. So I'm going to sustain the objection.
Is this a record maintained
Yes, ma'am.
in the ordinary course of business? Is this in your file? Did you request these records? Did you subpoena these records? Did you examine these records when they came in? Are these records kept in the ordinary course of business? I mean, maybe he's got to get a Verizon person to come in, but there's a way to get a business record in. And really the judge is, yes, I'm a proceduralist at heart. You know I am. But all right. Maybe they don't need to come into evidence. Maybe you can just let him describe them. Maybe you need
Court's indulgence. May we take a 5-minute break, Your Honor?
Well, I think this would, well, yes, we can. The answer is yes, but it may be more than 5 minutes. So can I see counsel at the bench about timing issues?
Yeah, isn't that the point? The defense is barred from asking those questions. It's really the complete land of the loss. I know. That is why sometimes we put Chaka up there in the corner. But there's a lot of things being used as a shield and a sword here. And
Do any independent research and things of that nature, all of you. I'm going to send you to the jury room. We're going to bring the lunch for you. Please don't discuss the case, of course. Do any independent research and things of that nature, as we have discussed. I do know there are several of you, or maybe one of you, that needs to run an errand, and certainly that's fine. We're doing lunch in because I'm not going to have a long lunch break. We're going to be back on the record at 1:30. But if you need, I know there's somebody that needed to do an errand here in town, and that's absolutely fine. Same instructions apply, right? You can't talk about the case, do any independent research, or go anywhere you may have heard about. But
So she's making a big deal of them buying the jury lunch, which, some jurisdictions they do every day, buy the jury lunch, and some they let them go out to lunch, and some they have to bring the lunch.
break. Yes, ma'am.
I don't know how much they get paid for jury duty in Georgia, but I'm going to bet it's not enough. So now we can skip through the entire lunch break. And now Mr. Cruz can go review how to get business records into evidence.
Everyone, you may be seated. Thank you. Mr. Cruz, you have the floor. We're back on the record.
Sure, and I think before we broke, the state had an objection to the introduction of phone records. I responded and asked for a short recess to look over the law regarding those records. The question I have, I don't think Mr. Bowden was specific with his grounds for objection. If I remember correctly, he said that it was inadequate or inappropriate foundation for business records.
Are you talking about Exhibit 30?
Yes, ma'am.
I've already sustained the objection. If you would like to put some case law on the record, you may, but I've sustained the objection.
Yes, ma'am. Understood.
Too late.
What was the specific objection, just so I could put...
I actually don't remember. I don't write that down. We'd have to go back and...
It's too late. I actually don't remember. You'd have to go back and read the record. Let me just go to the chat for a moment, because this woman is really on my last nerve tonight. I already don't feel well. Just Joey, thanks for your 10. Says, if Tara was strangled, how did soot get in her lungs? The ME said it was in her trach, but she was found on her back. If her mouth was open, wouldn't soot naturally fall into it? Legit question. I'm not a medical examiner, so I can't answer your question. But the openings indicated that because there was soot in her lungs, she was still alive when the fire started. That is what the argument is here. She was still alive when the perp started the fire because she breathed it into her lungs. I think there was smoke in her lungs too. I don't exactly recall the testimony, Joey, but maybe you weren't here for openings or for the ME. You were here for the ME. And that's a great question. Thanks for your 10. Jen says, I haven't had to rip out and redo this many crochet rows since Brennan lied about the sweatshirt. Thank you, Jen, for your 5. I appreciate you. Joan says, prosecutor has not displayed one piece of evidence against the defendant. It's day 3. Well, it's actually day 4 because we missed yesterday. And so we did a little 3 and all of 4. Has the prosecutor even mentioned his name? No, I don't think he has. He has not mentioned his name once, except an opening, maybe. The opening was all in defense of Chris Melton, by the way. Melissa says, thank you for your Australian 30. Hi, Mel, get well, ASAP. I am sus on housemate Ashley. In my opinion, she was up to no good with Chris deliberately not home the night before. Topped it off when she said, my blanket they used to start the fire. Guilty knowledge leakage. I don't think she had anything to do with it. But I do think her husband may still be friends with Chris. 2 Halls and 2 Chris's. Is that what it was? 2 Halls and 2 Chris's? Thanks, Melissa. I'm not going to accuse anybody of being involved in it. Venus Blue says, Chris is going to say he punched a wall and that's why his hands look like that. I'm ashamed of my hometown. Justice for Tara, but not this way. I love you. I love you too. Thank you so much. And thank you, Venus. And Deborah Walters, thank you for your super sticker. I appreciate you so much. All right, let's get back to the shenanigans in this kangaroo type court in Athens-Clarke County, Georgia, because, we just can't get enough.
Records. If you don't remember or not prepared to present some case law, and I'll let you put case law on the record if you want to, but we need to move forward.
I'll ask this. Can I be heard in regards to his objection? What I'm asking is, I don't know what the specific legal ground of the objection. I remember he said something that the court agreed to and granted, but in order for me to perfect the record, I would just need to know the specific legal ground.
Well, I will just say this, counsel. I'm going to ask you to move on with this witness. I already gave both parties the opportunity to respond, and so I'm going to ask you to move on.
Yes, ma'am.
Are you seeing a fair trial for the defendant here? I mean, are you? Just tell me. Am I being
On March 12th, 2001, do you recall receiving a message from a female inmate at the Clarke County Jail? No.
No, sir, I do not.
The jury is present. That was wrong. I'm correcting my Chiron. Wait, and he got a visit from an inmate. Hold on a second. What now? What now?
On March 12th, 2001, do you recall receiving a message from a female inmate at the Clarke County Jail? No.
No, sir, I do not.
Show him his report. Oh, good. He got a call from an inmate at Clarke County Jail. Good.
Mr.
Other
Cruz, if you'll
suspects.
Go ahead and show Mr. Bolden what you're going to be working with. Thank you.
Your Honor, he didn't show it to me again, Your Honor.
Thank you, sir. And of that document that I provided you, the specific portion to read is paragraph 1, sentence 1.
I object, Your Honor. I don't know that there was a question. I don't know that the witness has said that there was something that maybe I'm mistaken, but that was.
I think that's right, actually. I think you need to sort of start over and lay whatever foundation you need to with regard to this document.
Yes, ma'am.
All right, go ahead.
On March 12th, do you recall receiving a message from a female inmate at a Clarke County jail?
There you go.
Yes, sir. Okay. And what did she, she messaged you because she wanted to speak with you about the Tara Baker murder. Is that correct?
Yes, sir.
Okay. And you met with her upon receiving the message from her. Is that correct?
Yes, sir.
You went to the jail and spoke with her, correct?
Yes, sir.
And she provided you information about who she believed committed Ms. Baker's murder. Is that correct? And it'll be paragraph 3 if you're looking at the report, sentence 1, 7, and 9.
I do have an objection on.
Yeah, 25 years ago, did a lady call me? He should have reviewed his file before he came into court to testify, don't you think? Don't you think he should have been prepped to look at his file and shown his file so that his recollection would have already been refreshed? Unless for some reason the district attorney did not want to refresh his recollection as to any of this stuff because he knew that he was going to be able to strong arm it to keep it all out. Okay, so Kokomo, Indiana, I love you with all of my heart, but this witness should have been prepped. Okay? And he should have reviewed his file before he came in to testify because we're here on a 25-year-old murder case. So he's one of the police officers on the case who did investigation. He should have been prepared for this testimony. Thank you for coming to my TED Talk.
That the state previously filed, and
can you bring that microphone towards you, Mr.
Same as before, Your Honor.
Okay, Mr. Bolden, will you bring that microphone towards you and just repeat your second?
Same objection as before. This state's previously filed a motion. I don't think this is relevant under 401. I think it's 403. So I do object to this line of question.
What previously filed motion are you referring to?
The Saudi motion, Your Honor.
Okay. All right. Based on our prior discussion of those kinds of objections, I'm going to send the jury out again. So if you'll go back into the jury room, please discuss the case. Thank you.
I mean, you know, she said yesterday he was having a tantrum about not getting a fair trial. I mean, we're seeing it. We're seeing it.
But do you want to make any more of an objection? Let Mr. Cruz respond. All right, Mr. Cruz.
Okay.
Thank you. Y'all may be seated. Mr. Cruz, do you want to make any more of an objection? Let Mr. Cruz respond. All right, Mr. Cruz.
Okay. To make sure I understand the legal basis for the objection, Mr. Bolden has stated Rule 401, which is relevant. Rule 403. I would ask the specific grounds under 403 that wasn't stated in the Saudi motion. But if I could get the specific grounds for 403, I could address all three, Your Honor.
All right, Mr. Bolden, specific grounds that you were referring to.
403, Your Honor. I think that what I expect the line of questioning that Mr. Cruz intends to ask of the witness would go to potential alternate suspects, alternate perpetrators. The state did file its motion back in October, specifically related to these types of issues. We, at our hearing on January the 21st of this year, Mr. Cruz indicated that the only alternate perpetrator that he intended to identify was Mr. Melton. I think that's been very clear throughout this trial to this point. And so what I suspect he's attempting to do here is to run through every tip or piece of information that the police got relative to anybody over the course of this 25-year investigation, not all of them through this witness. But one, my first point is that the motion that the state filed back in November and that we heard arguments on the 21st, the court granted my motion, granted the state's motion, and except with respect to Mr. Melton.
Something funny, Mr.
So,
Melton?
To the extent that Mr. Cruz may now be trying to assert that they're alternate perpetrators, That's the whole point of the motion. There has to be evidence proffered to the court before he can ask that type of information in front of the jury, so that the court can make a determination about whether or not any probative value is substantially outweighed. And I will be specific here: confusion of the issues and waste of time. So that is the state's objection.
Thank you.
Waste of time.
If I may, I don't quite understand. It was a lot of information, forgive me. I understand he mentioned something about Saudi. Can I get clarity on that, Your Honor? If you understood what Mr. Bowden was mentioning in regards to.
Well, he was just, again, mentioning the hearings that we had about the 412 motion and the rulings.
The rape shield statute?
I'm sorry, not rape shield, Your Honor. The one that I'm specifically referring to, and it was captioned.
That was also on the 21st.
Right, and it was also filed by the state on the same day, which is state's motion in limine to require the defendant to proffer evidence linking other persons to the crime charged.
Is something funny, Mr. Bolden? Is something funny, Mr. Bolden? Look at his hands up, like, hands up. Don't let him do that, Your Honor, because it's going to be really, 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 really bad for my case. Don't let him do it. Don't let him do it, Your Honor.
That's the one I'm referring to.
Okay. Go ahead, Mr. Cruz.
So I address each objection piecemeal.
All right.
So in regards to the Rule 401 objection, which is relevance, the relevance of this line of questioning is just simply to show that a individual that's in custody calling law enforcement and saying, hey, I have information on this case, it isn't something unique to this case. Throughout the history of this case, multiple detectives have spoken with individuals in custody, and they'll call and say, hey, I know who committed this crime, and the information would turn out not to be credible. The specific line of questioning that I was going down with Detective Newton was simply to get to the point that this individual offered information to get leniency, which we believe to the jury would be relevant in determining Mr. Cedric Jeffries' testimony. In regards to Rule 403, and I believe he said waste of time, as well as, if you don't mind, Your Honor, I have waste of time. It was one more that he mentioned.
Confusion of the issue.
Confusion of the issue.
I'm
listening. I'm looking for the motion while you're talking.
Absolutely. That is fine, Your Honor. Do whatever you need to do. In regards to the waste of time, Your Honor, this evidence directly rebuts the state's evidence. They want to present to the jury Mr. Cedric Jeffries as a unique individual that's in custody, and they would like it to appear to the jury that he's the first in custody individual to come forward with tips on this case. This evidence would rebut that image that the state would portray to the jury if Mr. Jeffries is simply allowed to testify. So it isn't a waste of time, Your Honor. And as far as confusion of the issues, I'm not sure of an issue that could be confused by the Honorable Detective Newton simply stating, yes, someone in custody reached out to me 20-something years ago with information on the case. So that would be my proffer in regards to 403, or my response in regards to 403. In regards to the Saudi motion, just for purposes of the record, I believe the appropriate term for that is third-party perpetrator or alternative suspect theory under Georgia law. That is not the purpose of this evidence. This individual, if I would have been allowed to go down, or if I'm allowed to go down that question with Honorable Detective Newton, the information turned out not to be credible. So it wouldn't implicate the alternative party theory or third-party perpetrator theory.
Okay, so let me just ask you this question, and Mr. Bolden, I'll let you respond, and I'll let Mr. Cruz respond if you wanted to say something. But given what you've just stated, then why is this testimony relevant?
Absolutely, Your Honor. Thank you for the opportunity to respond to that. So the reason this testimony is relevant is because the state intends to bring in an individual by the name of Mr. Cedric Jeffries, who is an individual that is currently serving a 105-month federal prison sentence. Right. The state intends to depict to the jury, which is their right because it's their case that they have the opportunity to present, that Mr. Jeffries is a uniquely situated inmate. So when Mr. Jeffries comes in, he'll testify, hey, I'm in custody, so forth and so on. Mr. Faust admitted this to me, and I'm hoping to get a benefit from the state. The reason this is relevant is because we're showing the jury also that Mr. Jeffries is not uniquely situated. Throughout the history of this case, individuals that are incarcerated have called seeking leniency. Excuse me, let me make that clear for the record. Have called law enforcement offering information in order to receive leniency. So that's the relevance of the question, Your Honor.
Mr. Cruz, who is the person that this witness went and talked to at the jail in Clarke County?
So, Your Honor, I did not intend to get into any names. I don't believe the name of the person is relevant.
So it's not Cedric Jeffries?
No, it is not Cedric Jeffries. This is a separate inmate. And I'll say this, Your Honor, I know sometimes I mince up my words, so I may have explained that the wrong way. Okay. So in this instance, what I'm saying is that there's a separate individual from years ago when Detective Newton, the Honorable Detective Newton, was working this case. That individual reached out to Detective Newton and said they had information on this case. Okay, that information turned out not to be credible. And that evidence that we're seeking to admit before the jury is to rebut any type of visual or image or piece of evidence that the state may attempt to introduce Mr. Jeffries as an individual that is uniquely situated. And what I mean by that, Your Honor, is Mr. Jeffries is in custody. He's the only person that's ever come forward as someone in custody saying they have information about this case. And his information is, of course, as the jury would learn, is that Mr. Faust confessed to him. Does that make sense? And if I explained it wrong, Your Honor, please forgive me.
Well, I mean, I understand what you're saying,
Yes,
the words that you're saying.
Yes, ma'am.
But I still do not understand how this particular testimony is relevant and how it relates to Mr. Jeffries, other than the statement that you just made, and let me know if this is what you meant, other than your statement that the state would produce testimony that said the only person in custody that ever reached out was Mr. Jeffries. Is that what you're saying?
I probably used too many words. Okay. Credibility, Mr. Jeffries' credibility. That's why this evidence.
How does this testimony that you're seeking to elicit impact Mr. Jeffries' credibility at all?
I think that's an excellent question, Your Honor.
So what we intend to show is that multiple individuals that were in custody reached out to law enforcement offering information. Throughout the history of this case, all of that information has turned out to be unreliable. And what we're creating for the jury in regards to Mr. Jeffries' credibility is it's consistent with the information that Mr. Jeffries is providing as well.
Okay, thank you.
Yes, ma'am.
Mr. Bolden, anything else, sir?
Unless the court has any specific questions about the way that I made the objection. I denied.
Okay, I'm making a finding that this information is not relevant.
Yes, ma'am.
And that under 403, it would absolutely lead to confusion of the issues and misleading the jury. I'm not going to allow it. I'm going to move on.
Yes, ma'am.
Could you bring the jury in, please?
Maybe bring him back on your case in chief, depending on how the evidence comes in, because the jailhouse snitch, Cedric Jeffries, has not testified yet, maybe later. But he's making a very meticulous record. He is making a very meticulous record of all of the things that are not being allowed in.
All right, y'all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Thank you, Your Honor. Detective Newton, on May 6th.
And Detective Newton was on the stand the whole entire time that all of this arguing was going on.
2001, you spoke with Mr. Chris Melton over the phone. Is that correct?
I don't remember doing.
All right, I gotta rewind a little bit. What was the date he spoke to Chris Melton on the phone? We're gonna go back to real speed now, or at least 1.25, because it's still kind of slow.
All right, y'all may be seated. Thank you. Mr. Cruz?
Yes, ma'am. Thank you, Your Honor. Detective Newton, on May 6, 2001, you spoke with Mr. Chris Melton over the phone. Is that correct?
I don't remember doing that, but I'm sure I spoke with him over the phone several times.
Yes, sir. Would seeing your report refresh your recollection in regards to May 6, 2001?
Yes, sir. Thank you.
Thank you. In the copy, let the record reflect that I'm showing the Honorable Detective Newton a copy of his May 6, 2001 report to refresh his recollection.
The jury is back now, yes. I would not suggest anybody to report the judge, so please don't even put that in there. We don't do that here. We don't do that here. We don't dox. We don't accuse. Hold on. We just deal with the papers and the testimony.
One?
Yes, sir.
Okay. Is your memory refreshed in regards to May 6, 2001?
Yes, sir.
Is it okay if I grab that document?
Yes, sir.
All right, thank you. You don't have to.
Just have it.
Did you show it to him? He's doing a great job, Sharia.
Now, this is May 6, 2001, correct?
Yes, sir.
And when you spoke to, well, you understood that Chris Melton, at the time of this investigation, that Chris Melton was Miss Baker's boyfriend.
Yes, sir.
And I believe he described it as he was her borderline fiance. Is that fair to say?
Oh.
Yes, sir.
Okay. But when you spoke to him on May 6, 2001,
Wait, borderline fiance. So he did not consider himself to be her ex-boyfriend. Okay. Right?
and asked him about the Thursday before his death, he didn't have any memory of it. Is that correct?
Wait,
Say is that his boyfriend. Understood that Chris Melton, correct?
Yes, sir.
And when you spoke to, well, you understood that Chris Melton, at the time of this investigation, that Chris Melton was Miss Baker's boyfriend.
Yes, sir.
And I believe he described it as he was her borderline fiance. Is that fair to say?
Yes, sir.
Okay. But when you spoke to him on May 6, 2001, and asked him about the Thursday before his death, he didn't have any memory of it. Is that correct?
If I recall, he didn't have a clear memory of it. I think that would be an accurate way to put it, right? There was a lot of confusion in his mind.
Yes, sir. Thank you for that.
Because you might be really confused if something, if you went berserko and remembers having the booty call. This is back his statements in 2001 to this police officer, Chris Melton, the borderline fiance.
There was a discussion about going over Chris Melton's finances. Is that correct?
Yes, sir.
Okay. And were you aware that Chris Melton told law enforcement that he had received a check from a place called Nash Plumbing?
He worked at Nash Plumbing, as I recall from that report.
Excellent.
Yes, sir.
And the bank records would have shown whether or not he worked at Nash Plumbing, correct?
That sounds very logical. Yes, sir.
Okay. But Mr. Melton was not comfortable with you going over his finances, was he?
That is correct.
Okay. So based on your time in this investigation, you were never able to confirm whether or not Mr. Melton actually worked for Nash Plumbing.
It's not in that report. I don't recall us doing that, sir.
Thank you.
Oh, really? He's doing an excellent job. preparing for an appeal. Thank you, Chris. I agree. And also Cherie said the same thing, that he's really doing a good job poking holes in. Nobody ever confirmed his employment with Nash Plumbing. I'm sorry. He didn't want to give you his financial.
Now, during your conversation with Chris, you asked him for the phone number to Nash Plumbing. Do you recall that?
Yes, sir.
And Chris told you he didn't have the number to Nash Plumbing. Is that correct?
That is correct.
Did you find that odd, considering that he said Nash Plumbing was his employer?
I apologize. I don't remember finding it odd or not finding it
Calls
odd.
for speculation, Your Honor.
Overruled. Something funny, Detective Newton? You wouldn't find it odd that he didn't know his own employer's phone number in 2001?
I don't remember finding it odd or not finding it odd at the time.
You just had an opinion.
But I asked the question. I would assume I would have expected to get an answer.
Yes, sir. Chris Melton also could not provide an exact address for Nash Plumbing, could he?
Oh.
That is correct.
The only information he could provide is that it is on 78 near Loganville and that it is a hole in the wall. Is that correct?
That is correct.
Do you ever recall going to Nash Plumbing?
I do not recall, sir.
Oh.
Thank you so much, Honorable Detective Newton. I do not have any other questions for you.
Thank you.
Any redirect, Mr. Bolden?
Your Honor.
May this witness be excused.
Part of his alibi that he was working for Nash Plumbing? Is it part of his alibi where he was at the time of the murder and the strangling and the stabbing and the setting the house on fire and the burglary and the essay and the grape and the sodomy? Is that part of his alibi, Chris Melton, that he was at Nash Plumbing working, but he doesn't know their phone number or their address? It was just a hole in the wall somewhere. I don't really remember. And this is within days following the murder. And he doesn't really remember the night, the details of the night before the murder are fuzzy. The old, I was at work. Don't call me. Okay, cool.
Be excused.
Ms. Cruz, any objection?
I still have him under subpoena, so I would just ask that, and for the witnesses, please forgive me for not bringing this up earlier. Mr. Yalamachili brought it to my attention. For the witnesses that are under subpoena, just to be respectful of their time, if I could give them 48 hours notice instead of 24 hours notice. Is that okay with the Honorable Court?
I don't have any problem with that. I certainly think that's fair.
Okay, as long as I'm aware, I'll give them 48 hours notice. Thank you.
You're still under subpoena, sir, but you are free to go.
Thank you.
You may call your next witness.
State call Shannon Brown.
Thank you, Joe Mar, for gifting 5 memberships. You're amazing. Laura says, and here I was thinking Bev was unique. Thanks for your super chat. Maggie says, am I the only one that hears Rocky's theme music in my head when we watch Attorney Cruz stretching while waiting to talk? No, I think I was hearing it too. Burp Snart says, I pray that if I'm wrongfully convicted, my defense attorney would fight as hard for me as this defense attorney is fighting for his client. This is what you call zealous representation. Jersey Queen, thank you. Says that the jury's going to get tired of all this in and out. Thank you.
Will you raise your right hand, ma'am? Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay.
All right. Would you please just state and spell your name for the record?
It's Shannon Brown, SHANNON BROWN,
And ma'am, where are you currently employed?
at the Athens-Clarke County Sheriff's Office.
All right. And what, well, let me ask you this. Does the Athens-Clarke County Sheriff's Office keep known photos of individuals from certain times?
We do.
Sir.
I would object to this line of questioning.
Okay.
In regards, I would object under Rule 403. The evidence that the state is attempting to introduce, its probative value is substantially outweighed by its prejudicial impact or undue prejudice. And I would also object under Rule 404B, OCGA 24-4-404B, as it gets into improper character evidence.
All right, thank you. And anything specific with regard to 403, other than probative value outweighs?
Probative value is outweighed.
That's just, okay. All right, thank you. Mr. Yamamoto, any response?
Excuse me, substantially outweighed.
I understood, thank you.
I think it would probably be helpful for the court to see the exhibit.
Okay.
Are you going to have like the defendant's face on a wanted poster from
You know what?
2001?
We're going to do it again this way. Ladies and gentlemen, I'm going to ask you to go into the jury room. Please don't discuss the case. I think it's best we do it that way, counsel.
He works at non-existent plumbing, address unknown. 867-5309.
Can't wait. Could you repeat the question that there was an objection to? Y'all may be seated. Thank you. All right, Mr. Yamamoto, one of the reasons why I sent the jury out is I don't really know what you all was going to start talking about.
Well,
Secondly, could you repeat the question that there was an objection to and just give me more context?
The question, Your Honor, was whether or not the Clarke County Sheriff's Office keeps known pictures of individuals from certain dates and times.
Okay. All right. Thank you. And so you were going to show me the exhibit. You thought that was best for, I need to get a context of what you're asking.
I'm sorry.
Yes, Mr. Yamalama Ding Dong.
Yes, 112.
I'm marking State's Exhibit 1.
It's a term of endearment, Mr. Yamalama Ding Dong. My brother. It's not a disparaging nickname.
12, Your Honor.
And then after I take a look at it, if you can respond to Mr. Cruz's objection to 403. Thank you. 412. I'm sorry, 403 and 44B.
And Judge, I just handed the court the exhibit, but for purposes of the record, that would be Mr. Faust's booking photo from early February of 2021, about 2 weeks after the incident.
There it is. Oop, there it is. Oop, there it is. They want to put in a mugshot. He said it wrong. He said 2021. He meant 2001. They want to show a mugshot of Edrick Faust from a few weeks or a few days after the murder of Tara Baker. Do you think that is more prejudicial or more probative? Is it more prejudicial to the defendant than it is helping the jury determine some facts that are relevant to this case? His booking photo, same mugshot, right? Same thing, right? Because Little Cupcake put in the chat before, he was arrested with an incident involving a knife against a man or something. He pulled a knife on a man, I think, in February 2001, and he pled guilty, and I think he did 6 years. Close in time to Tara Baker's murder. Does that mean that he murdered Tara Baker? No. Is the jury going to think that? Yeah. And here's what they're trying to do. Okay? He said 2021. We're going to take it back.
244B.
And Judge, I just handed the court the exhibit, but for purposes of the record, that would be Mr.
Purposes of the record and the worldwide audience that is watching this right now, I want the world to know, even if you don't let the jury know, I want everyone in the world, the viewing public, to know Mr. Faust was indeed arrested, and that's his mugshot soon after the murder.
Faust's booking photo from early February of 2021, about 2 weeks after the incident. I believe that it is the same or a similar photo to the one that Mr. Cruz showed in openings during his demonstrative aid that he presented to the jury, saying that this was the evidence that he would expect that would come in, showing Mr. Faust's physical appearance, basically as close as we have it to the date of the crime. It is certainly relevant in aiding the in making determinations about the accuracy of the sketches done by Miss Lawson, Miss Marla Lawson, the GBI.
And you just objected to, and the judge allowed some of those sketches to not even come in. See how they're trying to use it as a shield and a sword? Do you see? Is it just me? We didn't want those other sketches in, but now that we're here 25 years later, and it just so happens that Edrick Faust was arrested 2 weeks after the incident. See how we called it an incident? Not the incident, the murder, the brutal, very personal strangulation, murder, arson, sexual, horrific acts, and strangulation of Tara Baker.
Sketch artist that did work at the time. I've instructed Miss Brown, and I think she understands that we're not going to refer to it as a mugshot, a booking photo, make reference to arrest, or anything regarding charge.
Do you think that 8 men and 4 women on this jury are not going to know that that's a mugshot, sir? I mean, we know that you think the jury's pretty stupid because you're so worried about confusing them. But do you think they're going to be confused about what a mugshot looks like? He meant 2001. He was wrong. And nobody corrected him on the date.
charges. I'll also note for the court that a stipulation to the admissibility of the photo as being a known image of Mr. Faust from that date and time that it was taken was offered to the defense prior to us beginning evidence in the case. It was discussed with Mr. Cruz again when I offered to stipulate to that yesterday. Did not receive a response. I offered again to stipulate to that this morning and informed Mr. Cruz that this would be our last opportunity to reach an agreement on a stipulation to the photograph. And he indicated to me that he would give me a response in approximately 5 minutes, and I did not hear again from him about that. So we have Ms. Brown, who's the custodian or a custodian of records at the Clarke County Sheriff's Office, to authenticate the photo. It is certainly relevant. And I believe with the limitations on the way that is referred to, I mean, honestly, Judge, even if you referred to it as a booking photo, I still think that the probative value would be not substantially outweighed by any unfair or undue prejudice of the evidence.
Does he really have the giant balls to make that argument right now in front of the world? I can't with this. Oh yeah, the jury's not gonna, wonder like, oh, he was arrested for an incident involving a knife 2 weeks later. Well, of course he probably killed her. Wow. He really has big ones, man. He's got them. Thank you, Jody, for your 5.
You would be, way that is referred to. I mean, honestly, Judge, even if you referred to it as a booking photo, I still think that the probative value would be not substantially outweighed by any unfair or undue prejudice of the evidence. But
the defendant is sitting on his chair next to Mr. Cruz, his attorney Cruz. Look at both of them. They're incredulous. They're like, are you kidding? With their hands to their face, both got the same hand on their face. Like, are you really getting up there in front of the world and making this argument that even if you called it a booking photo, it would not be prejudicial? He wants to show the booking photo to show that the sketches that he wants in evidence maybe sort of kind of look like the booking photo that was taken 2 weeks after the murders. That's what he wants to use it for, I think. And this is a woman from the sheriff's office who's going to allegedly authenticate this mugshot. Do we have any Athens-Clarke County residents here? Can you please tell me what the general feeling is about this district attorney before today? Yes, we need the button. Here it is. I'm offended. I'm offended for every resident of Athens-Clarke County. I'm offended for the family of Tara Baker. Because just like another trial we watched recently, it seems to me that this entire persecution is in defense of someone else. And I don't know why.
But certainly with the limitation of not referring to it as a booking photo or arrest photo or anything along those lines, its probative value is not substantially outweighed by danger of unfair prejudice, confusion of the issues, or any of the other reasons that admission would be barred by 403. It is most certainly relevant. I mean, I think that that's established by both parties by the fact that Mr. Cruz used either that image or a very similar one during his opening statement.
So I do have some questions, and we may have to take a recess for me to do some research. So first of all, even if you don't refer to it, if it is admitted as a booking photo, I mean, there's no question that's what it is. I mean, you can look at it and determine that. So how is...
But you're going to need to go do research on this issue?
That not violative of, at the very least, 404B, at the most attempting to put Mr. Faust's character into issue.
Yes.
So,
well, Judge, would be violative of 404B if we're seeking to introduce evidence of a previous crime or other act, but we're not actually introducing any evidence of the act that was committed that resulted in Mr. Faust getting arrested on February, I believe, 8th of 2021. We're simply showing that as a known image of Mr. Faust from that time period. If the
You're so full of shit. And this is when I say shield and sword, this is what I'm talking about. This guy jumps out of his chair, Yamalab Ding Dong does, jumps out of his chair when our king, Ahmad Cruz, gets up and tries to talk about the fact with the roommate that Tara Baker did not have any racial bias, that she may not have told you every single thing that was going on in her life. And this guy jumps up that that's a violation of the Georgia grape laws, right? Because I think this is where he's going to go. And he has the cojones to make this argument in good faith? Come on, man. Come on. He's talking out of both sides of his mouth here.
court is concerned with the background of the image, we have a version in which the background was able to be removed. And so, I mean, this is a version.
What's wrong with the Playboy photo? What's wrong with the young Playboy photo that the defense offered of him in 2001? We took the background away. We used a little AI. We We made him look a little bit more like the. We made it look a little bit more like the sketches. We used a little AI. We took the background away. Are you kidding? I cannot believe. I am embarrassed for the citizens of Athens-Clarke County, Georgia. I am embarrassed for you, and I apologize on behalf of I don't even know on behalf of who. I am embarrassed.
Version that I could hand to Ms. Brown with the understanding that there wouldn't be an objection to the fact that this image has been altered from the record that was kept by the Clarke County Sheriff's Office. We're certainly happy to do that, but I do believe that a known image, even if it is one that is generated as part of an arrest for a different incident than the one that Mr. Faust or any.
This hurts my soul. This hurts every bone in my body as a lawyer, as a mother of sons. This hurts every single bone in my body. And this is why it is hard for empaths to be trial lawyers like this, to have to sit there and listen to this. And you could tell that he's beside himself. This is what gives lawyers a bad name.
Any criminal defendant is on trial for is admissible if it is one that.
Oh, there it is. You can kind of see the picture when he puts it back down on the desk. Hold on. See if I can get a better shot of that for you.
But I do believe that a known image, even if it is.
Look at that. It's even got a profile shot. Hold on. Look at that. We took the background away, Your Honor, so nobody's going to know that that's a mugshot. Are you kidding me? Are you kidding me right now?
Is one that is generated as part of an arrest for a different incident than the one that Mr. Faust or any criminal defendant is on trial for is admissible, especially under these circumstances where we're talking about 25 years later and everyone's appearance has changed substantially. It is especially important to establish Mr. Faust's appearance at the time. If this were a situation where a year had gone by or 18 months or something along those lines, then you may be in a different position unless there's some kind of special circumstance showing that the defendant's appearance has changed substantially since the time of the crime.
This is at 1.5 speed and now he sounds normal.
But in this case, Judge, just the passage of time has led to a situation where Mr. Faust, Ms. Peavy Hall, Dr. Lowe, basically everybody that's come to testify in this case looks very different than they did at the time of the incident. So that's why it's relevant and necessary.
Well, and
they're not on trial for murder, you dumb. Everybody looks different than they did in 2001. The roommates look different. Did he really just say that?
substantially since the time of the.
Hold on a minute. My sore throat is going to get worse again if I keep screaming. Hold on. But sometimes you have to scream.
18 months or something to establish Mr. Faust's appearance at the time. If this were a situation where, you know, a year had gone by or 18 months or something along those lines, then you may be in a different position unless there's some kind of special circumstance showing that the defendant's appearance has changed substantially since the time of the crime. But in this case, Judge, just the passage of time has led to a situation where Mr. Faust, Ms. Peavy Hall, Dr. Lowe, basically everybody that's come to testify in this case looks very different than they did at the time of the incident. So that's
trial for murder. He's got 12 felonies. Are you kidding me? They all look different, so of course he looks different too.
why it's relevant and necessary.
Well, and I understand your relevance argument, and I think you've made an appropriate relevance argument, and I'll certainly let you respond, Mr. Cruz, but don't worry. But my concern is beyond that. My concern is
It is beyond
this line of questioning with this witness and this particular photo. So this is what I'm going to do. I'm going to let you make a response, certainly, Mr. Cruz, but I'm going to go do some research. So we'll be in recess until I get back. Hopefully it'll be 15 minutes, but I'm going to give you back your exhibit. If anybody has any case law they want to present the court, they certainly can, but I will be back in hopefully 15 minutes. We'll be in recess. Thank you.
You might want to, if anybody takes blood pressure medication, you might want to go take some.
Replica of the federal rules of evidence.
Look at, we're not that far behind. Let's see, how far behind are we? I don't know, not even an hour. Okay. And we're going to keep it on higher speed so that we can get through the day.
At the time that this case occurred, that's H federal state.
I give him a lot of credit. He has
the Georgia time that this case came out.
Has, he's taken a chill pill. He's taken a step back. He's getting calmer as the days go on, because I think he's just surrendered to the fact that he's not going to win a lot of these arguments.
First of all, let me give the state back this exhibit, and it's your motion, Mr. Cruz. Anything further you want to tell the court?
Yes, ma'am.
Go ahead.
As the Honorable Court is aware, within its wisdom, Georgia adopted the federal rules of evidence in 2013. And those rules of evidence were, just to be safe, I'll say excluding very few, but were pretty much a replica of the federal rules of evidence. And as the Georgia legislature has explained, that when it comes to interpreting the Georgia rules of evidence, we look to the decisions of the 11th Circuit Court of Appeals. In that state, v. Almaza, and that's A as in apple.
You can just spell it. She can hear you.
Yes, ma'am. That's A-L-M-A-N-Z-A. And that's 304, Georgia, 553. Also state v. Brown, 333, Georgia Appeal, 643. Under our current evidence code, Your Honor, of course, indulgence to pull up the statute. Under our current evidence code, Your Honor, our rule, OCGA 24-404, is similar to the federal statute, language-wise. They're identical statutes. We found a case from the 11th Circuit, which is United States v. Hines, and that's H-I-N-E-S in Sailor. And this is a 1992 case, and I'll wrap it around together with our current evidence code, which states, mugshots carry a clear implication of criminal activity that breaches the rule against admitting evidence of the defendant's bad character or previous brushes with the law. At the time that this case came out, Your Honor, the federal evidence code stated, which is identical to our
to our evidence code. And the reason I'm making this comparison is because that case is from 92, just to avoid any argument that it's inapplicable to the issue we're dealing with here. But the evidence code in 1992 stated, federal evidence code, character evidence generally, and it's the exact same thing that we currently have, evidence of a person's character or a trait of character is not admissible for the purpose of proving action and conformity therewith on a particular occasion, except, and it goes through the same exceptions we have. So those statutes are materially identical to our current statute. So you're going to, based on the law, based on the federal rules and the ruling of the 11th Circuit Court of Appeals, as well as our statute, I will present to the court the exact same argument that was part of the Honorable Court's ruling in United States v. Hans, and specifically, the mugshot that Mr. Yalamachili would like to introduce, it does carry a clear implication of criminal activity that breaches the rule against admitting evidence of the defendant's bad character or previous brushes with the law. When Mr. Yalamachili spoke to me, just to address our conversations, earlier today, I explained to him it was a tentative yes, but not to that photo. I didn't see this mugshot photo side and front until the witness was called to the, was on the bench testifying. What we are willing to stipulate to, and this may resolve the issue, is the photo of just Mr. Faust looking forward. That photo alone, we have no issue with. But as far as the mugshot photos together, that our position is that it does violate OCGA 24-4-404. D is bad character evidence.
All right, thank you, Ms. Cruz. I do have a question for you since you've sort of proffered an offer, so to speak, for stipulation. Do you, was your objection extended or meant to encompass this witness that the state had testifying about the photograph, the one photograph you're offering to have admitted into evidence? Is that part of your objection, or is it the mugshot itself?
Can you ask me that question again?
Yes, that wasn't terribly articulate. So the state has a witness.
Yes, ma'am.
Who they have asked, do you keep certain photos, something to that effect, in your department or your office? I don't remember the exact language. And it sort of stopped there. I'm assuming they were going to ask this witness, do you recognize this photo, or something to that effect. So I guess my question for you is, given the fact that you are offering to not object to the introduction of the photograph you've described.
Correct.
Does your objection extend to this witness commenting on it, or?
Just to make sure that I explain it clearly. From what I understand, her testimony would be, from what Mr. Yalamachili explained to me, is just simply to introduce the photo. From what I understand from our conversations, there's been no discussion regarding her making any mention, any descriptions, or talking about the picture. I understand her testimony is for the sole purpose of introducing that mugshot photo.
You don't have a problem with that?
No, I do have, it's the exact same photo, because we intended to introduce it, that was shown during opening. And what it displayed was just Mr. Faust looking forward. That I have no issue with. But the looking forward and the side profile photo, Your Honor, that is what we're objecting to, those photos together.
I understand what you're saying. Thank you. Mr. Yalamachili, were you aware of the defense's offer, so to speak, before I walked in?
As far as an offer to stipulate?
Oh, yeah, about that picture.
Well, that's not exactly what was said, Your Honor. At the beginning of the trial, as court knows, the state and defense had been discussing some stipulations for some period of time. Mr. Bolden started those conversations with Mr. Cruz probably 3 weeks before we started jury selection. I sent the written proposed stipulations, tried to follow up a couple of times. I talked to Mr. Cruz, who initially had told us that Mr. Faust did not want to stipulate to anything, and so there would be no stipulations. And then this morning he said, that's a yes from me, but I need to check with him and I'll get you an answer in 5 minutes. And then I never heard anything before we.
Okay. He's saying we'll stipulate to the photo. We don't want this witness from the sheriff's department being asked, do you keep photos in the sheriff's department of people who have been arrested? And then she's like, yeah. And then they're like, okay, what about this photo? It's highly prejudicial. They've already shown, the defense has already shown that particular photo where he's looking forward in their opening. They don't need this witness. This witness is nothing but prejudicial. You see what I'm saying? Also, I'm going to speed this up and also know that when I am live, you can slow the speed down on your own end. I just want to be able to make sure that we are able to finish today's testimony.
Started the evidence in the case. I would state to the court that the offered written stipulation before the start of the trial was that the parties stipulated the foundation for the admissibility of the defendant's booking photo from February 2001, and that is a fair and accurate depiction of the defendant on the date it was taken. The state shall refrain from making any reference to the image as a booking photograph or otherwise indicating that the photograph is related to illegal acts committed by the defendant. If Mr. Cruz is willing to stipulate to the foundation, I don't need to put it in through a witness from the Clarke County Sheriff's Office, and I won't. It would need to be a stipulation that it is both an accurate image of Mr. Faust and it is an image from February 8th of 2001 at 4:33 p.m. I mean, that would be the stipulation. And I'm fine we've got multiple large copies of it, Your Honor. We're fine doing the front facing only. There's one, I don't even know that Mr. Cruz did this with the image that they used in opening. Obviously, you've seen 112, they're cinder blocks. We have one with the background washed out to be white.
You showed me that. I mean, I think that's certainly better than cinder blocks.
Okay.
All right. So let me just say this. I'm going to give you all a couple of minutes to talk about how to go forward with the picture. And here's the reason. Case law is pretty clear that a booking photo in and of itself is not necessarily inadmissible, just based on the fact it's a booking photo. It is dependent on the circumstances upon which it is being asked to be introduced. This particular case, I'm really not even making a comment on whether the photo is admissible or not. That's not really your issue. Your issue is that you're trying to get that photo in through the sheriff's department. And that moment in and of itself creates the implication that is inadmissible, which is that Mr. Faust at some point in the past had been arrested for something. That's the moment that I think the case law is pretty clear is inadmissible.
And can you unring that bell?
The photo itself, even a booking photo in the manner that you have suggested, I'm not making a ruling that it is not inadmissible based on Mr. Cruz's objection. I'm sustaining your objection, Mr. Cruz, but I'm sustaining it because the manner in which the state was trying to introduce it is inadmissible through the sheriff's department. That implication, I think it's pretty clear, the case law is pretty clear, that implication is violative of 403. And so I'm going to give you all some time to talk about what you can stipulate to. I think the suggestion that both parties have made about that one photo with the background.
Wow, she gives so much detail when, she's, I just don't even know what to say anymore. There comes a point where commentary just becomes impossible.
States Exhibit 113.
All right, so she gave them some time, and I guess now we're back. And
Sure, we're on the same page.
I do.
Okay. It's sort of
February 8th, ever displayed. Just whenever, Miss.
All right. Go ahead, Mr. Yellenchilly.
Thank you, Judge. We have an agreement, and would you like me to leave the other one labeled 112? Obviously, it wouldn't go with the evidence to the jury, or label the new picture 112.
I think the new picture needs to be 113.
Okay. And I would just state for the record, 112 was never displayed to the jury in any way.
does it have like numbers underneath them too?
All right, and if you all will.
113 is a picture of Mr. Faust, and the parties stipulate that it is in fact an accurate picture of Mr. Faust on February 8th of 2001. As far as how the court wants us to handle that when the jury comes back in, would you like me to move to tender 113 and just state that the parties stipulate or agree that it is an accurate picture of Mr. Faust from February 8th of 2001?
Okay, let me hear from Mr. Cruz first, and then I'll tell you.
Yeah, and when it's so close in time to this witness from the sheriff's department coming in, they're going to know exactly what it is. Such bullshit.
What sort of I'm thinking about. Mr. Cruz, you want to be heard on that? And do you agree with that stipulation? I just want to make sure we're on the same page.
I do.
Okay.
I don't.
No. What I understand, just to make sure that we're clear, he's just going to announce the stipulation to the jury. The witness won't be on the witness stand. Is that right?
Well, yes and no. I don't know what your plan is for this witness, but in terms of this photograph, I would answer yes, that it is inadmissible to introduce the photograph you stipulated to through this witness. Yes.
And I don't need the witness on the witness stand, then, Judge. And
Yes,
after
yes.
this, I'm sorry.
Go ahead.
I was just going to say, after we announce the stipulation, I just asked to publish it to the jury, and that's it.
Okay. All right. Thank you. Let me ask you anything else, Mr. Cruz? Is that okay? Mr. Yamacholi, do you need this witness?
I don't. I'd ask that she be excused.
All right. Mr. Cruz, any objection?
No, ma'am.
All right. You are free to go. All right. Anything else before I bring the jury back in?
No, Your Honor.
Mr. Cruz, you ready?
Yes, ma'am.
All right. You can bring the jury in. Thank you.
Now the jury's all confused. Where'd the witness go? That jury's not stupid either. This guy's dirty, says Sweet Southern Honey. It's the same photo that the defense showed in their opening, so it's the same photo, and that's why they're stipulating to it. I don't like it.
Mr. Yamacholi.
Thank you, Your Honor. The state has marked States Exhibit 113. There is a stipulation between the parties that States Exhibit 113 is an accurate picture of Mr. Faust from February 8th of 2001. So I'd move to tender it into evidence.
Mr. Cruz, any response?
No objection.
It is admitted.
And I'd seek to publish it to the jury at this time.
Yes.
It's like a half win. All right, so there's I don't know who the guy is in the oil painting, but here's the picture.
All right. You may call your next witness.
State call
Well, they didn't show it.
Rao,
Could you get Annie Kistler-Rao, please?
swear affirm testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, I do.
All right. If you could, please state and spell your name for the record.
My name is Ann Kistler Rao, ANNEKISLER-RAO.
Come over to this microphone. Ma'am, where are you currently employed?
I'm employed with the Georgia Bureau of Investigation, Division of Forensic Sciences, also known as the State Crime Lab.
How long have you been with the State Crime Lab?
I've been there for 20 years.
And what is your current title and role at the State Crime Lab?
I'm employed as the technical leader of the Trace Evidence Section.
And as far as your educational background, starting with your undergraduate degree, do you mind telling me about what you received your undergraduate degree in?
Yes, I received a degree in biology from the University of Pennsylvania.
Did you receive any other postgraduate degrees?
Yes, I have a master's degree in forensic science from John Jay College.
And once you got to the Georgia Bureau of Investigation, was there any internal training that you went through as part of your GBI employment?
Yes, I've gone through extensive training programs in each of the areas that I am qualified to perform examinations in. So this includes hairs, fibers, glass, paints and polymers, fractured materials.
Okay. And as it relates to hairs, when the GBI receives a hair from law enforcement, wherever that may come from, are there any steps taken to prepare that hair for analysis?
Yes, typically we will mount hairs on microscope slides. So we'll take a microscope slide, put the hair on it with some mounting media, and then put a cover slip on top to hold that hair in place and use it for further examination.
All right. And let me ask you this. Once your examination is done with a piece of hair, is the typical practice to remove that from the mount and place it back in an envelope to go back to the law enforcement agency?
No, typically we will then package those slides in a slide holder and then we'll put it in a package and preserve it that way.
Okay. So back in February of 2024, so about 2 years ago now, were you working at the GBI at that point?
Yes, I was.
All right. And did you're not you personally, but did the
Is he trying to explain the missing hairs?
Georgia Bureau of Investigation's Crime Lab receive communication from Agent Elizabeth Bigham?
Yes.
Okay. And what was that related to?
This was related to a box of slides. It was determined that we needed to look at the box of slides to inventory what was present within that box.
All right. And did somebody at the Crime Lab look at those slides to conduct that inventory?
Yes.
All right. Who was that person?
One of our lab techs within the trace evidence section, Valencia Johnson.
What was discovered upon the inventory?
Upon inventory, it was discovered that some of these slides were broken.
Okay. And so let me ask you a question about ways that things were packaged back in 2001 or the early 2000s as compared to the way things are packaged now. Okay. How were slides packaged back in the early 2000s?
They might be packaged.
Well, she wasn't there. She's only been there for 20 years. So I don't know how she can answer that question, but go on.
In various ways, but one of the ways would be to just wrap it in paper towels, or it might be otherwise packaged. Since then, we have acquired plastic slide boxes that are a little more sturdy that can prevent further damage.
And so you mentioned preventing further damage. Have there been situations where the slide in the old way of packaging things, not without the slide boxes you're talking about, gets damaged?
Yes, that's possible.
Okay. In this particular case, after the inventory was done, was there any damage to the slides?
Yes, some of the slides within the box did have some damage.
Okay. And so when a slide is damaged, what are your options at that point regarding remedying the damage?
It depends on if further examination is going to be done with that slide. So if it was damaged enough so the cover slip was cracked and we couldn't really see anything, then we might have to remount those hairs on a new slide. But if we were just preserving the slide to prevent further damage, like in this case, we just use tape on a lot of the slides to just tape it together to make sure nothing further happened to the slide.
Okay. And were you involved in that process?
Yes.
Okay. Were you the only person involved in that process?
No, 2 other hair examiners were also involved.
In the slides that were related to this case, was there any damage noted that compromised the hairs that had been mounted to the slides?
No, there was no note of damage that compromised any hairs.
All right. I'm going to hand you about 9 different plastic boxes here, so bear with me as we label these and show them to opposing counsel first.
Mr. Cruz carefully examining the slides and the boxes. I'm sure he'll have a motion. What do you think? What's the over under on whether he'll have a motion about this?
Yes.
All right. Ms. Kissel-Rao, I'm going to hand you State's Exhibits 114, 115, 116, and 117. The exhibit stickers are on the front.
He forgot to take his portable mic with him.
Will you look through those and then just let me know when you've had a chance to review all of that?
That's right. He did ask for sanctions, and he did get the $1,000 contempt fine. That was the DA, Yamalam Ding Dong, who asked for it.
And do you recognize State's Exhibit 114?
Yes, I do.
Okay. And how is it that you recognize State's Exhibit 114?
It has a label on the cover that I wrote with the unique case number and item number on it.
Okay. And so were the case number or item number, would that have been altered at the time that y'all repackage it or noted in your records in a different way?
No, so it would be the same case number that it originally had. So the slides were originally marked with a case number on them. So we just copied the case number onto the outer container so we would know what's inside that box.
And does that appear to be in the same condition as when y'all repackaged it or repaired it at the GBI?
Yes.
I moved to tender 114 at this time, Your Honor.
Any objection?
Yes, ma'am. I would ask that the state establish an appropriate chain of custody for those three slides, Your Honor. I'm sorry. Please give it.
I do have an objection, Your Honor.
Go ahead.
My objection is I would ask that the state establish an appropriate chain of custody for those items under 221 Georgia Appeal, 472 Southeast 2nd, 4621. And the case is Harper v. Dooley. And I'll just ask that the state meets its burden, showing the chain of custody before the honorable court admits it its evidence.
All right, thank you. Mr. Yellenchely, any response to the objection?
Your Honor, I believe what will be borne out is that these are the slides, as Ms. Kissler-Rao has testified to, that were part of that DOFS case number, and that these particular slides are the same hairs that Dr. Falzon submitted as part of the recovery in the autopsy.
All right, thank you. Yes, sir.
If he can establish that chain of custody, that's our objection.
All right, well, in terms of the objection about admissibility, the state has, anything else?
No, I was just
Yeah.
I'm sorry.
Okay. In terms of the objection about admissibility, the state has laid a foundation that is appropriate under the law, and so I'm going to get them over objection at this point. Certainly, if you all want to argue other things with regard to the admitted evidence, you can. But in terms of the foundation that has been laid by the state, simply for its admissibility at this stage, I'm going to overrule your objection. You may continue.
Yes, Your Honor. As it relates to State's Exhibit 114, are you able to determine where the lab received those hairs from, or the trace evidence section, I guess?
May I refer to my notes?
Lack of personal knowledge, Your Honor.
Mr. Yellenchely, any response to the objection?
I think that this witness, in reference to her notes about where the items were obtained from in the crime lab in conjunction with Dr. Falzon's testimony, lays the foundation for that.
Yes, sir.
I may have misunderstood his question. I thought he was asking that based on those items themselves, could she tell where they came from? The reason I lodged the hearsay objection is because I took it as, and you can correct me if I'm wrong, that she was simply going to read someone else's writing to determine where those items came from. But if she has it in her personal knowledge, the objection is irrelevant.
Okay.
She has to look at somebody else's words to determine. That's what we're lodging our objection.
Is your objection, Mr. Cruz, personal knowledge or hearsay or both?
So
All of it.
It would try to be both if she doesn't have personal knowledge.
All in there.
All right. I'm going to let you ask the question again, Mr. Yellenchely. If you want to object, Mr. Cruz, I'll hear it, but go ahead and ask the question again, sir.
What is State's number 114? What is that noted as in your notes about what the item is?
It. It was identified as collected from the victim's left hand and the victim's buttocks.
Okay. State's Exhibit 115.
Hairs collected from the victim's hand and the victim's buttocks, both in the same slide? Huh. Oh, okay. Typically, it has to be the person who wrote on the envelope who's authenticating this. But, not in this courtroom. It doesn't have to be the actual person who did the actual work. Sometimes there's exceptions. I don't know if there's one here because we're in kangaroo court land. I think that's what his objection was.
Notes about what the item is.
It was identified as collected from the victim's left hand and the victim's buttocks.
Okay. States Exhibit 115, do you recognize that item?
Yes.
Okay. And how do you recognize 115?
This also has a label on it with our unique case and item number and that I created.
And where is States Exhibit 115, where is that item noted as being recovered from?
It is identified as recovered from the torso.
Okay. And is that in substantially the same condition as it was when you repackaged it?
Yes.
Okay.
Those are all the
I moved to
envelopes
tender
that
150.
were missing, that were empty. The left hand hair, the buttocks hair, and the torso hair collected from the victim. Those envelopes were all missing. I mean, the hairs were not in the envelopes. Now they're on the slides. My mic is low. I don't know if I can do that just right now. I thought I was equal with the court level, no? And now it is, they're found. They're miraculously found. It's the magical mystery slides, hairs. All right, thanks.
15, Judge.
Any objection, Mr. Cruz?
Outside our chain of custody, no, ma'am.
All right, I'm going to admit it.
In States Exhibit 116, do you recognize what that is?
Yes, I do.
Okay. How do you recognize that?
This also has our unique case number and item number on the outside of the box.
And where is that item identified as being recovered from?
This is identified as from the victim's left hand.
And does that appear to be in substantially the same condition it was when you all repackaged it?
Yes.
Move to tender 116 at this time, Your Honor.
Any objection, Mr. Cruz?
Other than our chain of custody objection, no, ma'am.
Okay, I'm going to admit it.
States Exhibit 117, do you recognize that item?
Yes.
How do you recognize that item?
This item also has our unique crime case number and item number on the outside of the package.
And where is 117 identified as having been collected from?
This is identified as from the torso and from a towel.
And is that in substantially the same condition it was when you all repackaged it?
Yes.
Torso and towel also on the same slide.
Judge, I moved to tender 117 at this time.
Any objection, Mr. Cruz?
Yes, ma'am. To save the court time, I'll just say to
The problem with the court volume is that because people keep moving away from the mics, I have to keep adjusting it in the booster. And so if my volume is a little bit lower than the court's, just show me a little grace today. I feel like absolute garbage and I'm here today. So give me a break, okay? A little bit of a break.
to all of the ones we've mentioned chain of custody to. I'll just mention that now, but furthermore, no.
All right, thank you. It is admitted. Go ahead, sir.
I'll retrieve those now.
Usually it's the other way around. I feel really sorry for the sound person who's in the courtroom.
And Ms. Kissel-Rao, I'm going to hand you state's exhibits 118 through 123. As it relates to state's exhibit 118, do you recognize that item?
Yes, I do.
How do you recognize that item?
This item has our unique crime lab case number and item numbers on the label on the outside of the box.
Where is that item identified as having been collected from?
This item is identified as containing the known pubic hair of James Barker and the known pubic hair of Chris Melton.
And
oh, I'm sorry. Who's James Barker? Didn't they say that Tara was born with the last name Barker? That's her biological father's name. And then her stepfather's name was Baker, which was weird, right? Baker, Barker. She changed her name to Baker, even though her birth name was Barker. Her stepdad raised her, so she changed her name to Tara Baker. Who is James Barker and why is his pubic hair relevant here? What? Hold on a minute.
Item identified as having been collected from.
This item is identified as containing the known pubic hair of James Barker and the known pubic hair of Chris Melton.
And does that appear to be in substantially the same condition as it was when you repackaged it?
Yes.
Judge, I move to tender 118 at this time.
Any objection? It is admitted.
Going forward to State's Exhibit 119, do you recognize that item?
Yes, I do.
And what do you or how do you recognize that item?
This item also has the unique crime lab case number and item number on a label on the outside.
And where is that item identified as having been collected from?
This item is identified as being known head hair of Chris Melton and known head hair of Christopher Hall.
All right. And does
The Chris's have entered the chat.
that appear to be in substantially the same condition it was when you repackaged it?
Yes.
Judge, I'd move to tender 119.
Any objection, Mr. Cruz? It is admitted.
State's Exhibit 120, do you recognize that item?
Yes, I do.
How do you recognize that item?
This item also has our unique crime lab case number and item number on a label on the outside.
What is it and where is it identified as having been collected from?
This is identified as the known head hair of Ashley PV.
Does that appear to be in substantially the same condition as it was when y'all repackaged it?
Yes.
I move to tender 120 at this time.
Any objection, Mr. Cruz? It is admitted.
Thank you, Maggie. And
As it relates to State's Exhibit 121, do you recognize that item?
Yes, I do.
How do you recognize it?
This item also has our unique crime lab case number and item numbers on a label on the outside.
What is it and where is it identified as having been collected from?
This is identified as being known head hair and known pubic hair of Valerie Lang.
And does that appear to be in substantially the same condition as when it was repackaged or repaired by the GBI?
Yes.
Judge, I move to tender 121.
Mr. Cruz, any objection? It is admitted.
State's Exhibit 122, ma'am. Do you recognize that item?
Yes, I do.
How do you recognize it?
This item also has our unique crime lab case number and item numbers on a label on the outside.
And what is it and where is it identified as having been collected from?
This is identified as being known head hair of Valerie Lang and known head hair of Ashley PV.
And is it in substantially the same condition as it was when it was repackaged by the GBI?
Yes.
I know
Judge, I
you're
moved
the
to-
smartest chat on the internet, and there's a lot of forensic experts in the chat. Do you typically put hairs from two different people on the same slide? Is that common to do in 2024? Just, I'm just asking. I know what my gut tells me, but you could tell me. Maybe it is something that you do commonly. I don't know. I'm not a forensics expert.
Tender 122.
Any objection, Mr. Cruz? It is admitted.
State's Exhibit 123. Do you recognize that item?
Yes, I do.
How do you recognize that item?
This item also has our unique crime lab case number and item number on the outside of the box.
And what is it and where is it identified as having been collected from?
This item is identified as being known head hair of Valerie Lang.
And does it appear to be in substantially the same condition as it was when it was repackaged by the GBI?
Yes, it does.
Judge, I move to tender 123 at this time.
Any objection, Mr. Cruz?
I told you, see, Ajax is here, says those are slide cases. You can typically fit 10 slides in each box. They better be individually labeled, though.
Okay. It is admitted.
Ms. Kissler-Rao, thank you very much, ma'am. That's all the questions I have for you right now.
Mr. Cruz, cross-examination.
Do we have a box of gloves?
Well.
Medium, extra large. So, okay.
In court's indulgence, Your Honor.
We can scooch a little bit.
My Cruz,
Here are some of them.
Oh, you put gloves on.
My name is Amai Cruz. I have the privilege and honor of representing Mr. Edrick Faust. Is it okay if I ask you a couple of questions?
Sure.
Okay. I want to make sure I pronounce your name properly. May I have your last name, please?
Kissler-Rao.
Ms. Kissler-Rao?
Yes.
Perfect. Do you have the slides with you?
I have some of the slides still up here.
Is it okay if I approach them?
Yes.
Approach and grab them?
Ms. Kisler-Rao, you'd agree that the state asked you questions about these hairs here.
Yes.
Is that correct? Now, the hairs that the state asked you about weren't the only hairs collected. Is that correct?
I'm not aware.
Are you aware of a hair being retrieved from a power transformer in this case?
I'm not aware of that.
And are you the individual that packaged these hairs?
It was me along with 2 other hair examiners.
Which ones did you package?
I can tell you which labels are the ones I made.
Please.
I would need to see them.
Yes, ma'am. Let me slide these back in. The court's indulgence to figure out which hair is which. I'm just looking for a particular slide, if that's okay. And thank you so much for your patience. And these are the conditions. Well, let me rephrase that question. This isn't the condition that you put these slides or package these slides up as, are they?
So we took those slides, put them in the slide boxes, and then packaged them.
In this condition with the slides broken?
I'd have to see it a little closer, but
The slide's broken. I didn't put them in there. This was only a year ago. Remember, she just looked at these in 2024. Apparently there was a hair with the transformer of the power cord that she was strangled with. There was a hair found there, but she doesn't have that hair. Does it make, do you think the jury is thinking, what are they hiding from us? Because I think that's what I'm thinking. You found a hair on the cord that she was strangled with, and that's not in your presentation?
it's possible, yes.
Okay.
So no, it's fine. So the slide is a little bit broken, but it's still intact. So I am not sure if it.
Are there any policies in regards to safekeeping the evidence in a criminal case?
What types of policies are you referring to?
Sure. Quality assurance
Do you use broken slides?
Retention policies, storage policies to ensure that items aren't damaged.
So again, when we are done with an examination, we will package the items away into a sealed, secured container.
And your testimony is that you are not aware of any other hairs missing from these containers.
I'm not aware of it.
Sure. You have your report with you?
I did not issue a report for this particular.
Well, Ms. Kisler-Rao, during direct, you said you were using your report to refer to the hairs.
No, I was using my notes to refer to the hairs.
So you didn't issue a report on any, and if I phrase it wrong, please correct me, but you didn't issue a report to the work you did prepping these hairs?
So I did not prep these hairs. It was just opened and inventoried. And then we might have taped some of these slides, repaired anything to preserve it for future efforts. So no actual analysis was done at the time.
I may have asked this question wrong.
I'm sorry. We've got a lot of these boxes open. A lot of people are handling them. I just want to make sure all the slides go back in the boxes that they were taken out of. So if we could do it in a way in which we're talking about one box or opening one box at a time, I think that is the best way to do it. I'm sorry. I know that's not a legal objection. It's just, I think it's something that might be important.
Well, and I guess we didn't talk about publishing it to the jury. They are in evidence, but we need to talk about, are you trying to publish all of the slides to the jury?
The relevant slides to the jury, Your Honor.
Okay. I'm gonna have you put that on the record, which slides you want to publish to the jury.
Yes, ma'am.
I think, Your Honor, the jury something needs to be passed to the court, maybe through the bailiff or from the jurors, but they're trying to address the court about something here.
Sirens.
Thank you. Thank you for that. All right. Yes, sir.
Can we display these on the Elmo, please? I understand there's some latitude about how to do it, but this is not a good way to do this.
I think that would be best.
Break out the binky.
Mr. Cruz, I'm going to ask you to retrieve that
Yes, ma'am.
piece of evidence.
I can do that.
Break out the binky. The Elmo is the overhead projector.
Sorry, we may need to send the jury out so that we can see what fell, what we can recover, and what we can't recover.
Sure.
will use the elbow.
Well, Mr. Yalamanchili would like to make sure that we have recovered everything. So I think probably that's the best way to handle this moment. Ladies and gentlemen, happy going to the jury room. It's a good time for a restroom break. And please don't talk about the case. I'll bring you out as soon as we can put things back together. Yalamanchili, Mr. Cruz.
What fell? I don't know. I guess I must have missed it when I got up to.
Can we ask Ms. Kissel-Rao to step
Yes,
down?
yes, sir.
Thank you.
Are the knives all over the floor broken now? Hold on a second. What just happened? Hold on. Did I miss it when I went out of the room?
And your testimony is that you were.
What happened?
Thank you.
Let me just tell me what happened because I don't feel like rewinding. It's like they're picking slides up off the floor. Wiping them off. This is like a kangaroo court. It's weirder than a jury duty show. It's like the sweatshirt with the holes in the back. All right, so we have a little bit of room to scooch here, hey? Hey, oh, looks like a lot, actually.
One moment, Mr.
That isn't listed. There's no issue with the case. Multiple times.
On the record. I'll work it out. Don't worry. I'll just call it after work. All right, let's go back on the record. We ready to proceed, counsel?
Yes, Judge. State's ready.
We have a motion, Judge. We may need a hearing on this.
Okay. Go ahead.
In regards to these items, we do need to have a chain of custody here. I know I've raised that objection multiple times, but I'm looking at the glass slides, and I can stand to be corrected. But according to the slide, it is labeled as 2001-100-2454, which is item number 12. Okay, this is our case number. So no issue with the case number. But when you go to the chain of custody report, and this is listed as Q hair recovered from debris with power module. First, Your Honor, that isn't listed anywhere in the chain of custody report. But when you go to item number 12 on the chain of custody report, item number 12 is identified as sealed package, identified as containing power transformer. These are two different items, Your Honor.
Let me just interrupt you for one moment, Mr. Cruz, and ask you this question about it.
Look at Yamalama Ding Dong's face. Do you see him? Wait, hold on. He's right here. Watch his face. Shaking his head.
Item number 12 is identified as sealed package, identified as containing power transformer. These are two different items, Your Honor.
Let me just interrupt you for one moment, Mr. Cruz, and ask you this question about a chain of custody motion.
Yes, ma'am.
What is it ultimately you're asking the court to do with regard to your issue, whatever it is, with the, as you articulate, lack of a proper chain of custody? What are you asking?
Exclude the evidence.
We raised the issue. The state elicited testimony regarding these items and the proper packaging of these
I know,
items.
but what are you asking me?
The very first thing I'm asking, Your Honor, is to determine whether chain of custody is proper. If chain of custody is not proper, Your Honor, we're going to move for a mistrial. But I think we should flesh out the threshold issue. And, Your Honor, I respect your cross with utmost respect. Even if the honorable court decides to deny the motion, we may still move for a mistrial. A significant number of these hairs.
Move to exclude the evidence. Well, okay. If you want to move for a mistrial, you could do that too. You did it like 3 times yesterday, but.
If I'm understanding the labeling properly, are mislabeled. Now, I can stand to be corrected. The state could show me something that may be completely different. But I would ask to have opportunity to flesh this out on the record, if I may.
Mr. Yalamanchili, you care to respond to the motion, even though we haven't gone into full detail about a lack of chain of custody and issues related to that in terms of a
I can try, Judge. Here, I'll step to the microphone.
Okay.
We don't need no stinking chain
I
of
guess
custody.
one, there's been no identification of what exhibit it is that Mr. Cruz is talking about. I believe to the extent that a chain of custody challenge is made, and I'd have to look at the cases, Your Honor, but I do believe reading something about needing to make an affirmative showing of tampering, at least some type of evidentiary showing of that. But again, I don't, that's just off the top of my head when you're thinking about litigating chain of custody issues. As far as the chain of custody in this case, with both Lieutenant Liedall as well as Dr. Falzon, I believe, as well as Mr. Newton, who testified about the collection of known hairs as well, Your Honor. I think that the state has met its obligation thus far in chain of custody, and with the caveat that Mr. Peterson is expected to testify for the state as well. The extent of his testimony will be determined by the court's ruling in the Daubert motion, but at a minimum, he would testify for purposes of establishing another link of that chain of custody. I also believe, at least, that there is case law indicating that when you have an investigative agency or an agency like the GBI, essentially the entire agency is considered for chain of custody purposes. But again, Your Honor, I'm not citing these as holdings. I do believe that that general principle is correct, though, but certainly could look into the issue further if the court instructs us to do so.
All right, thank you. So,
Trust me,
Mr.
bro.
Cruz,
Trust me, Bo. Just trust me, Bo. They said chain of custody. We're just going to trust me. There's no log. There's no anything. There's no nothing. Right. You put empty packages in front of the ME. Right. And then there was another witness who had to look in there to see if the hair was it the ME that looked to see. I can't even keep track at this point with all those shenanigans that are happening here.
are you asking the court to not allow certain evidence in based on a chain of custody argument? Is that what you're asking?
So, Your Honor, that's what I was asking originally when we made the initial motion, just that the state lay a foundation for the chain of custody. Now I'm asking to flesh out, if the Honorable Court will allow, to flesh out the record in regards to chain of custody with the Honorable Court. And probably the way the hearing goes, Your Honor, unless I am mistaken, I can't be. I don't want to stand in my place and say I'm certain I can't be, but the burden is on the state to establish a chain of custody. If I am not mistaken, if there are errors with the chain of custody based on how far we've gotten in this testimony, not just her, but things we've discussed in this trial, including the envelopes, I would be moving for a mistrial at that time. But I'd like to flesh out the issue a little bit further on.
All of the hairs found on her body are Caucasian hairs. Am I wrong about that?
The record first, if that is okay.
Let's go back
Okay,
to my
so
notes.
the answer to your question is no.
Yes, ma'am.
And I don't really know what your motion is with regard to chain of custody, but I will just say this, that chain of custody, if you choose to challenge the chain of custody, certainly you have the right to do that if you decide that that's appropriate for your case. What you are referring to is the weight of the evidence rather than the admissibility of the evidence. And it is not, I'm just going to deny your motion on chain of custody. You can challenge it however you choose, but this is not a moment where the court has where the court is in a position to exclude evidence based on your argument that chain of custody has been established or hasn't been established. And that is an argument you certainly can make however you choose to do it. You can always make that challenge, but what you're asking the court is not something the court needs to make a ruling on in the manner that you have asked it to. So I'm going to deny the motion as best I understand it about chain of custody, and we're going to continue cross-examination. The court's question for all counsel is, where are we with the evidence that was on the floor or not on the floor, or did we sort that out?
Yes, Judge.
Okay.
One of the slides broke. However, it's my understanding that the mounting did not come apart.
Okay.
The evidence was not lost. Ms. Kistler-Rao, I think, was able to put things back together, and it was placed back in the plastic slide box.
Outstanding. Okay, so we're going to bring the jury back in. You may continue your cross-examination, and I think it is best at this point, Mr. Cruz, if you want to publish to the jury, to use the, well, I call it an overhead projector, but that is not what it is. We're going to use that. And then if the jury needs to handle any of the slides during deliberations, I think we need to talk about how to make that happen. Maybe bring them out, do it in more of a supervised fashion, things of that nature. All right, would you bring the jury in, please? Thank you.
I mean, Mike says, I didn't think I would ever say this, but so far I think this is a bigger injustice than Karen Reed.
And Mr. Cruz, cross-examination.
All of the hairs found on the body were Caucasian in origin. The hair found, the rectal hair, the butt hair was positive, or, you know, was Chris's hair. That's what my notes say. And I think 2 other hairs, the hair that was found in her hand, were Caucasian male hairs. And the hair on her torso, also Caucasian hairs. Some of them may be missing. We don't really know. So far, there have been no African-American hairs found on the scene or on the body of Tara Baker. I've seen nothing that points to the defendant yet. Nothing, except a mugshot from a different case. And that doesn't point to this at all. And she had just taken a shower.
Ms.
That's right.
Kessler-Rao,
Maybe her bad.
you would agree that the GBI has a policy for the preservation of evidence. Is that correct?
Yes, that's correct.
And the purposes of such a policy is to prevent evidence from being lost, damaged, mixed up, things of that nature. Is that correct?
Yes, as long as it's in our custody, we want to keep it secure. And then when we return it to the agency, we send it in a secured package.
Okay, thank you. I'd like to show you, I believe a slide that you mentioned with the state that you repackaged. Can you identify that slide? Is that one of the slides that you repackaged, or would that have been one of the other 2 individuals?
I don't know who repackaged it. We all worked together at the same time. So I don't know which particular individual put that in the package.
Sure. But this, I'm assuming it was an agreement that it was okay to put this in the packaging in this condition?
Yes, it's intact and was able to be put in a slide box.
Sure. What year did this take place where you started going through the boxes with the 2 other individuals?
That was in 2024.
So it's recently. Okay. Do you know that these hairs were collected in 2001?
Yes.
Okay. Do you know whether the hairs that are contained in these items are the actual hairs that were collected?
So I have no direct knowledge of the mounting of the hairs. The only knowledge I have is of the slides we received. Everything, we repaired what we could and put it back in a package.
You said it repaired what you could. What about the things that you could not repair?
Again, we repaired them to the point where we felt that they were secure in their package.
Were these
Yes.
slides relabeled in 2024?
No, I don't believe so.
And I could have heard you wrong. I thought you mentioned during direct examination that you relabeled or you labeled some of these slides.
I was referring to the slide boxes. So the label on the outside of the box that told you what was inside that box. Those are the labels that we created.
That would be that item there.
That's correct. Yes.
Can you tell the jury the preservation policy of the GBI when it comes to evidence collected on an open on an open case?
Again, like our preservation is that we will place evidence in sealed packages. We seal them with evidence tape. That's secure to secure them.
So to make sure I understand the entirety of the GBI policy and the preservation of evidence, you put it in sealed packages and secure it with evidence tape?
That's correct.
Is this considered a sealed package?
Those slides were placed in a larger slide box, and that slide box was sealed with evidence tape.
And were you the individual that sealed that box?
I don't believe I was the one who did the final sealing of the box.
I'd like to show you a couple of these slides. You let me know if this was part of the repackaging that you all were doing. Was it this difficult to get the slides inside of the box?
Sometimes it can be, yes.
Does that raise concerns about the slides being potentially damaged or breaking?
No, as long as they're in the box, it should provide at least better security for them than the former method of wrapping them in paper towels.
What I'm asking about particularly is putting the slides inside of the box. There are no concerns about these slides breaking?
I have yet to have an issue with slides breaking when I put them in the box.
We just saw broken slides, paper towels, solo cups, leaf blowers.
Do you want to give it to the witness? But if you're having trouble putting it back in, choose one.
I'd like you to put these slides in the box for the jury. Is it okay if I approach you?
Sure.
Would you like some gloves?
No, that's okay.
No? Okay. Well, I guess protocol doesn't really matter. You're handling evidence, but whatever. That's excellent that she said no, because that just shows that, they don't really care about silly things like rules and.
So one of the slides was just misplaced and it's no longer, I have to take 2 of them out because it's no longer in order. Okay. All right, now it's back in the box.
This slide here is one of the slides that that was found in that box. Not that one there, I'm sorry. This one isn't labeled. Your Honor, I'd like to show the witness what I'm marking as Defense Exhibit 31. Let the record reflect that I'm showing the witness what has been marked as Defense Exhibit 31. And take your time to look at Defense Exhibit 31. If you would like, you could take the slides out just to review the slides. I'd like to also show you State's Exhibit. Well, before I show you State's Exhibit 114, do you recognize Defense Exhibit 31?
Yes, this item also has labels with our unique case number and item numbers of the slides that it contains.
And I want to make sure I pronounce it correctly. Can I call this a container?
Yes.
The container that the slides are in, you recognize that container, right?
Yes.
And the slides that are within that container.
Yes.
And are those slides in the container, have the slides in the container been altered in any way to your knowledge?
Not to my knowledge.
Okay. And is that a fair and accurate package of slides as you remember those slides?
As far as I know, yes.
And I would move to admit Defense Exhibit 31 into evidence.
Any objection, Mr. Yalamanchili?
No objection, Your Honor.
Is admitted.
May I approach the witness, Your Honor?
You may.
You gave us a qualifier. You said not to my knowledge. Can you explain that? When I asked you, had these slides been altered in any way?
They don't appear to have been altered by me.
Retrieve a particular slide. I ask you this. The state didn't ask you to introduce Defense Exhibit 31, did they?
No.
In Defense Exhibit 31, there's a hair in this item that is labeled hair from the power transformer. Is that correct?
Oh.
Yes, that is what the box indicates. And yes.
Oh, now we're getting somewhere.
And just, you didn't do any testing? I want to be clear on that.
Not on these particular items.
That is fair.
But the hair that's from the power transformer is a fair and accurate depiction of what you remember packaging up in this device.
Yeah, that's what it was identified as with its label, yes.
And just so we don't confuse the issue with the jury, the hair from the drain assembly is different from the hair that would be on the power transformer that was found, correct?
Yeah. Well, I might misunderstand the question a little bit. I'd object if it's calling for some kind of comparison between the hairs, as Ms. Kistler-Rao has testified that she didn't do any analysis. If Mr. Cruz is just saying that the two slides are different slides, then I don't have an objection. I'm just not clear entirely what the question was eliciting.
All right, Mr. Cruz, any response?
Was for comparison as far as her looking at the slides, both slides.
I'm going to object then, Your Honor. If he's asked, he already asked, and the witness said she had not conducted any analysis.
All right, any response to the objection?
No, ma'am, I stand by my response, Your Honor.
Okay, I'm going to sustain the objection.
Yes, ma'am. Well, in this sense, slide-wise, because both of these will be into evidence, I could get it out. And actually, can you help me with this, Mr.
I think a lot of the time the DA is objecting just to throw him off of his flow.
Okay.
All right, do you get that feeling too?
Oh, yes. Oh, gosh.
Crazy Graham says the fix is in. Zimmy's slides in biology 7th grade look better than these. She doesn't wear gloves. She doesn't, even though the slides are broken, she doesn't wear gloves. She could cut her finger and contaminate. It doesn't matter. It doesn't matter. They're not they're all Caucasian hairs, my guys, my friends. These are all Caucasian hairs, every single one of them. Every single one of them. The only evidence they have against this defendant, if I recall correctly from openings, which are not evidence because we haven't heard anybody actually say any evidence yet, is maybe from an oral swab inside of the mouth of Tara Baker was found perhaps the DNA of Edrick Faust. But then we found out that the vaginal swabs and the oral swabs were mislabeled. So we're not even really sure. The only sperm they found, I think they found some sperm, but then they said maybe they wouldn't find sperm for some reason. But maybe if they did, it was Chris's. And all the hairs that were found, some were Chris's. All of them were Caucasian. And we got nothing. That's a great screenshot. And the only reason that they got his DNA was because they got it through CODIS in 2024 when they enacted the Coleman-Baker Act in Georgia, which allotted $5 million to close cold cases. And Tara Baker is who the act was named after. And here we are. And here we are. And it's true allele DNA, which if you know anything about DNA, and I'm not a DNA expert, there's some issues with it, right? I know I have DNA experts in the chat. And Chris is roaming free with busted up hands. I can't wait for the day that he comes in to testify.
I'd like to show you the slide that has been labeled as
I don't think we
hair number 12 from cord of power transformer.
Oh, there's the hair from the power cord.
Do you see the hair there, Ms. Rao? Kistler-Rao?
Yes. Yes, I do.
I'd like to also show you my last question for you. This hair is a part of Defense Exhibit 31. Is that correct?
Yes.
Thank you. And I have no other questions for this witness, but I may need this witness's help putting these slides back in, Your Honor, so please forgive me.
All right. Mr. Yalmachili, any redirect of this witness?
I do.
All right, go ahead, sir.
Yeah.
8 men, 4 women on the jury.
Just take it up. I can wait until you're done giving
If you want to get that assistance now, you certainly can, and we can wait. That's fine.
Cherie said the fix was in when they did not arrest Chris. Well, thanks for coming here today, Maggie from Scotland.
Yeah.
We're so happy that you're here. Thank you so much for your super chat. Jody says, I need to know what you would do in King Cruz situation. Well, I'm not a criminal defense attorney, never claimed to be, never have been. I'm a civil litigator. I'm a plaintiff's lawyer. I'm retired now, but for over 30 years, I was a plaintiff's lawyer. I sued the Catholic Church on behalf of many of the victims, and survivors of clergy essay. So I can't tell you what I would do in his situation because I've never been a criminal defense attorney. But I certainly might come in with my tail between my legs, just like he is doing, but still try and fiercely advocate for my client.
Go ahead, sir.
Thank you, Your Honor. I'm going to show Mr. Cruz what I've marked as State's Exhibits 124 and 125.
And continue to make a really good appellate record. Because if this man is convicted, this will be a travesty of justice based on the zero evidence that they have here. And thank you so much for your super chat, Jody. What is this now? Redirect? Okay, got to change that. Oops. You see what I have in this hand?
And Ms. Kissler, out
in this hand.
124 and 125. Starting with States 124, do you recognize that item?
Yes.
How do you recognize it?
This item has our crime lab case number and the item number that the slides came from on the package.
What's located in 124 and where does it indicate that it was recovered from?
This is identified as the known head hair and known pubic hair of Ashley Peavy.
And does that appear to be in substantially the same condition as when it was repackaged by the GBI?
Yes, it does.
And Judge, I move to tender 124.
Any objection? It is admitted.
And then as to State's Exhibit 125, what is 125?
125 is identified as the known head hair and known pubic hair of Tara Baker.
And how do you recognize that?
It also has our unique crime lab case number and the item number that the slides came from.
Does that appear to be in substantially the same condition as when it was repackaged by the GBI?
Yes, it does.
And I'd move to tender 125 at this time, Judge.
Any objection, Mr. Cruz? It is admitted.
Thank you, Gigi, for gifting another 5 memberships. You're amazing. I'm so glad to see you too. I'm not really feeling better, but I'm powering through it. It's one of those things that's going to take a while. I feel like.
And then Mr. Cruz asked you a question about what year it was when these items were repackaged. I think he testified to this earlier. What month and year was it when they were repackaged?
It was February of 2024.
Okay. I don't think I have any other questions for you right now, Ms. Kissler-Rao.
Any recross, Mr. Cruz?
No, ma'am, no response.
May this witness be excused, Mr. Yalamanchili?
We'd ask that she is, Judge.
Any objection from the defense? You are free to go. You may call your next witness.
State calls David Griffith.
Could you get David Griffith, please?
Is that a character from like Family Guy or something? I don't know. I think I'm losing it. Hold on.
Hold record.
My name's David Griffith, D-A-V-I-D, G-R-I-F-F-E-T-H.
And sir, what do you currently do for work?
I'm a technology consultant. I primarily manage public safety information technology stacks.
Okay. Before you did that, did you ever work for the Athens-Clarke County Police Department?
I did.
How long did you work for ACCPD?
I worked for ACCPD for just under 15 years. From November of 2004 until October of 2019.
Okay. Well, what was your title when you were with ACCPD?
I was a criminal analyst.
All right. Let's back up a little bit. And what did you study when you were in college?
Finance at the University of Georgia.
All right. Did you take a little break before you received your degree?
I did. I was in school at UGA from 89 to 93. During that time, I started a software company. And my senior year of college, I left school to pursue that software company, sold the assets of that company in 2003, and went back and finished my last couple of classes to obtain the finance degree.
Yeah. Well, I just found this out now, but I think we were at UGA at the same time. I would have been a freshman and
yeah,
when you went back. But
Dude, let's do a big swing and D contest. Who cares that you went to school at the same time? Thank you, just Heidi. I've been screaming this since the beginning. Please note, the Baker Act was established because of the advocacy of Tara's family, and more importantly, her case. More This case was the first case the Special Cold Case Unit investigated, brought to trial. Yes. And I've been saying this, that they have to prove its worth.
Agree.
Yeah. Well, I just found this out now, but I think we were at UGA at the same time. I was a freshman and when you went back. But that software company.
I just threw up a little in my mouth.
After you sold the assets of it, went back and got your degree, what were you doing after that?
I didn't really know what I was going to do. I just by chance ended up attending the Citizens Police Academy.
Tell us about your 5-year plan, your 10-year plan, and your life goals, sir, and your mission, and your mantra. Tell us about your mantra, your daily mantra. We have an affirmation for a badass. Here's the one from today. It says, "I am effing powerful." Do you have one of those, sir? Come on, man. He's just trying to run out the clock on the day, and I'm going to speed it up. Motion granted.
I guess let me back up a little bit. I was in a church group. I made some offhanded comments about police officers to a buddy of mine that was a police officer in Athens-Clarke County.
What? You made some offhanded comments in a church group? What? I'm sorry. Are we trying to get ahead of the impeachment material? What? Hold on a second. Hold on. Hold on. What? Nothing like getting it right out there in front of it, eh? But hey, good old boy. We went to college at the same time. We went to UGA at the same time. Go Bulldogs.
But went back and got your degree. What were you?
I just by chance ended up attending the Citizens Police Academy. I guess let me back up a little bit.
He was in there's a Citizens Police Academy. Is that like what you do to put people under citizens arrest? This is normal speed. I want you to know this is normal speed. We need a laugh today, and this is going to be it. I have a feeling. I went to the Citizens Police Academy because I wanted to be able to do a citizen's arrest.
In a church group, I made some offhanded comments about police officers to a buddy of mine that was a police officer in Athens-Clarke County. And he challenged my assumptions about law enforcement in the community and said I should attend the Citizens Police Academy. So I did. The Citizens Police Academy at the time, and I guess it probably still is, was a kind of a public outreach effort to bridge the gap between the community and law enforcement. And it was
because I'm a good
citizen. I think it was a 12-week course. One night a week you would go, and some aspect of the department was presented to you, and you would get to see the inside operations of the agency. During that Citizens Police Academy, the command staff asked me to apply for a position at the agency that they had open. It was the crime analyst position. And I thought, well, I'll apply, and they offered me a job, and I thought, well, maybe I'll do this for a couple of years, and a couple of years turned into 15 years.
Initially, when they brought you on, was your technology background an attraction to them?
It was. The chief at the time, Jack Lumpkin, was looking to modernize the police department's technology stacks. And
wait,
so
was it Jack Plumpkin? Jack Plumpkin? I'm not making fun of the accent. It's a character. Jack Plumpkin was in charge of what now? I'm a Northern girl. I don't know anything about cutting up. I'm from above the Mason-Dixon line, born and raised. Okay, I don't know nothing about cutting up. Nothing. Sorry. This is on a regular speed. I want to hear that again. Jack Plumpkin. What now?
It was the chief at the time, Jack Lumpkin, was looking to modernize the police department's technology stacks, and so I could offer some expertise in that area.
The crime analyst field in general in law enforcement, kind of what stage of its development was it in when you started with ACCPD?
Zero.
It was a very new position that a lot of agencies did not have at the time. Athens was kind of on the cutting edge. The best way to describe it was a specialized unit that was trying to figure out its way in law enforcement and what role it would play at the time.
In your work as a crime analyst, were you ever involved in any trainings?
I was.
I'm calling him
over the course of 15 years.
I'm calling him for purposes of this Chiron, a citizen crime analyst. Okay, David Griffith, Athens-Clarke County Police Department citizen crime analyst. Is this real life? What evidence did he collect? Athens is on the cutting edge. We're walking while black at 8 a.m. Looking awake is a crime. So much so that many people called the police department about it. Especially if you have an orange shirt on.
I had hundreds of hours of training as it relates to this trial. I was trained in all facets of intelligence analysts through the years, but specifically cold case homicide training. At the time I was hired in 2004, this case had languished a little bit, and they sent me to cold case training at GBI headquarters. It was a cold case training put on by DHS and FLETC. That was a 40-hour course.
Is it like Scooby-Doo? You have a van like Scooby-Doo? It was only a 3-year cold case at that point.
And they also sent me to the FBI Academy in Quantico, Virginia to do cold case training there. That was another 48-hour homicide training course.
You got to go to Quantico?
And in addition to that, I think I went to Brunswick, Georgia, and did 40 hours of training with an NCIS.
NCIS?
And so those are the trainings that you attended. Did you ever
He said all of the buzzwords that everyone who's ever been interested in true crime and Silence of the Lambs and television and Law and Order and NCIS, he went to NCIS and Quantico. And CSI. 48 hours. I can't. Zoe says, yeah, I don't trust any department that recruits crime analysts from their Citizens Police Academy. This dude is Welcher 2.0 with Shannon with one N sprinkled on top. Girl, comment of the day. You win. Excuse me while I bend over and pick up that name you just dropped. NCIS, Quantico, CSI. What about CSI Miami? What about that?
trainings for any other crime analysts?
I did. Sometime shortly after the GBI training, FLETC approached me and asked if I would be an adjunct instructor for FLETC. FLETC is the Federal Law Enforcement Training Center down in, they've got multiple campuses, but the main campus is in Brunswick, Georgia. They train federal law enforcement across the nation. And so from 2007 to 2011, I was an adjunct instructor for FLETC and helped develop curriculum to train analysts across the nation.
Everyone.
At any time during your career with the Athens-Clarke County Police Department, were you assigned as a crime analyst to work on the murder of Tara Baker?
I was.
Okay. And if you recall, it's been a while, when do you think you first had contact with the case file?
Sometime in late 2005. I've got a very vivid memory of meeting the Baker family at the arch on the 5th anniversary of Tara's death. So I know that in January of 2006, I was actively working on it.
Okay. Well, was there a detective at the Athens-Clarke County Police Department that when you first got the case file, you were working on it with in conjunction?
There were two, Sean Potter and Courtney Gale.
Okay. And can you describe for the jury how crime analysts work in conjunction with detectives? What's your role in that relationship?
So we were a support unit and
you need
that brought a specialized skill set to help analyze the case file. Our role was to help, at that time the case file was very large. It's multiple volumes of
It's a cross between clown music and the Benny Hill theme song. Like I don't know which one is better for our citizen crime analyst.
statements, supplementals, evidence.
Oh, so he was paid by the Baker Act. Well, wait, no, because the Baker Act didn't come into play until 2023, right? And he says that he was on the 5-year anniversary. He was on this case, so he was all the way back on the case and back in like 2006. So I don't think he was paid by the Baker Act.
It would have been thousands of pages at that point. So my role was to review the case file, make an assessment of where we were, what avenues we might explore going forward, and to give a broad overview synopsis of the case.
And so what kind of organizational condition was the case file in when you picked it up for the first time, or I guess we're assigned to it for the first time? I'm not sure you could pick the whole thing up.
No, you couldn't pick it up. It was literally multiple volumes locked away in the Criminal Investigations Division at the police department. So the case file at that time was what I would call analog. It was literally paper reports assembled in 3-ring binders. It was in good order. Lots of care had been taken to keep it in good order through the years. At that point, lots of investigators had worked on the case. My role was probably something like attorneys would get ready for a trial in court. I wanted to assemble a timeline of events so that we were sure we understood. Let me back up a little bit. When you've got a homicide investigation going on, this case had dozens of active investigators in the days immediately following the crime. There were investigators from the Athens-Clarke County Police Department, the University of Georgia Police Department, the Georgia Bureau of Investigation. They were all working collectively to gather information and put together this case.
This trial is brought to you by the letters B and S. Thank you, Solo Dave. He found the Holy Grail.
Well, so what happens is those agents and case investigators go out and conduct interviews, collect evidence, and they write reports about what they've discovered or found or collected, and they're assembled in this case file. So my role was to go through that case file and to assemble a common book of facts, chronology. The software that we used to help assemble that knowledge was called Case Map. It's probably still used today. So that software labeled things like a cast of characters. That would be the subjects that were part of the investigation, the witnesses, the persons of interest, the victims, the facts of the case, so the dates and times, the events that happened, the evidence that was involved in the case, so the trace evidence collected at the scene, all the evidence that you're going to talk about during the course of this trial.
So at any point, did an opportunity come up to discuss this case with other law enforcement professionals?
On many occasions.
Right. That was an imprecise question. I'll try again. Did any of those occasions involve the Federal Bureau of Investigation?
Yes.
Okay. And so can you tell me what that event was?
So at some point in 2006, one of the avenues that we pursued was we submitted the Tara Baker case to the FBI's Violent Criminal Apprehension Program. What that entails is we prepared a synopsis of what we knew about the crime
television.
and what had occurred and what we
know
knew
what
about.
VICAP is because we watch television. Ashley 83 says, who knew we'd get such an afternoon treat? A little afternoon delight for us on a hump day. This is why we're here, because of this citizen crime analyst. David Griffith, Peter Griffith, Family Guy, name dropping. I don't even know.
Victim and the offender, and we transmitted that information to the specialized unit at the FBI. The FBI, after receiving that report, asked the agency to come present the case file for peer review in Quantico, Virginia. That was sometime in 2006.
Did you take advantage of that opportunity?
We did. Myself, Sergeant Courtney Gale, who was with the Athens-Clarke County Police Department, Jesse Maddox, who was a GBI agent. I believe he's probably the SAC in Athens at this time. Monica Bumgarner, who was also a GBI agent. She now works for the ATF. We traveled to Virginia to present the case.
A few things upset me more. There's a lot of things that upset me. A lot of things upset me, but one of my pet peeves, just one of them, is the improper usage of the word myself. Does anybody else have that? Does it just grate on? I know we have a lot of grammar snobs here and a lot of spelling snobs here, but the improper usage of the word myself in a sentence is one thing that will always just make me choke. Did you hear it? Am I the only one who heard it? Myself, so and so and so and so did that. No. Listen again and tell me if it bothers you as much as it bothers me.
That was sometime in 2006.
Did you take advantage of that opportunity?
We did. Myself, Sergeant Courtney Gale, who was with the Athens-Clarke County Police Department, Jesse Maddox, who was a GBI agent. I believe he's probably the SAC in Athens at this time. Monica Bumgarner, who was also a GBI agent. She now works for the ATF. We traveled to Virginia to present the case.
Can you describe, what does that mean or look like to present the case at the FBI Cold Case Symposium?
I can. We were one of, I believe it was 8 agencies that presented cases. So basically, the investigators and analysts from these agencies come together and present their cold case in a roundtable type form. So we all sat around and discussed our cases, made a formal presentation, and then collectively we talked about what each agency could do to further its investigation in the case.
Okay. In preparation for that, what's the depth of, information and knowledge about the case that you're presenting that's necessary to be able to present at a symposium like that?
The expectation is that you'll be able to present every aspect of the case that's important to the investigation. So you would need to know the case from beginning to end, all the facts, all the chronology, all the people involved.
And obviously, I think you said that was, you believe, sometime in 2006. It's been, depending when in 2006, 19 or 20 years since then. Has your memory faded a little bit since then?
Oh, yeah. I probably have forgotten more than I recall about this case after 20 plus years of working on it.
It's a pretty large file.
Thanks for that.
Well, let me ask you this. Do you recall the name Chris Melton?
I do recall the name Chris Melton.
Okay. So did ACCPD investigate Mr. Melton after this crime occurred?
We did.
And did you have an opportunity to review that investigation?
Yes.
Okay. At any point, did Mr. Melton become, in your estimation as a crime analyst and being part of the continued investigation for a number of years, no longer a viable suspect in ACCPD's mind?
You know, Chris Melton, of course, was a person of interest from the very.
Based on your best citizen crime analysis, sir. I'm sorry. Is this the best witness that you could get to say that Chris Melton shouldn't be a suspect as a citizen crime analyst? Come on. Here we go. Do we put it on real speed just for the glory? This is on normal speed. Or is there any reason why you, citizen crime analyst, no longer considered Chris Melton to be a suspect? Okay. He's forgotten more about it than he remembers, but okay, let's go.
Analyst and being part of the, okay. At any point, did Mr. Melton become, in your estimation as a crime analyst and being part of the continued investigation for a number of years, no longer a viable suspect in ACCPD's mind?
You know, Chris Melton, of course, was a person of interest from the very beginning. You know, if you looked at homicides in aggregate across the nation, more often than not.
I don't care about it. His pubes were found on her back door. Okay, right?
The offender in a homicide's known to the victim, and often it's somebody that's close to the victim, a significant other, boyfriend, spouse. So Chris Melton was a person of interest for the agency, very much so. The agency went to great lengths, I guess colloquially in the inner workings of the agency, that, you know, the investigators would say, we're trying to either put this person in or put them out of the case as a suspect. I don't know that anybody would say Chris Melton was absolved as a person of interest.
Ever? Oh, thank you.
But he was not.
Thank you. So he's still considered a suspect or a person of interest? Thank you very much.
Let me back up. So we went, the case investigators very diligently tried to put together a timeline of Chris Melton's actions the day before and the day that Tara's body was found. And
he lied.
That effort alleviated a lot of suspicion in the minds of the investigators that worked on the case. Collectively, the thought was Chris Melton is not at the top of the person of interest list.
Why is that? Did you see his hands?
The timeline that the case investigators assembled related to his activities had him, and I'm working from memory here, had him at home the night before Tara's body was found. His parents
say at home, where do you mean?
Well,
yes.
You know what's so funny about that is that in 2024, he changed his story and said he wasn't home. He was really having a booty call with her, but he left at midnight. So there's that. Did they make a timeline? What? I'm sorry, what? Mr. David Griffith?
Lack of personal knowledge and hearsay.
Lack of personal knowledge is the objection.
There's the objection. Mr. Alamachilli, any response?
Judge, I think Mr. Griffith has information, personal information about the timeline that was assembled by the agency. Obviously, the state will be calling witnesses to establish Mr. Melton's whereabouts at the time that this murder occurred. But I do believe that this witness has personal knowledge of the agency's timeline.
I'm going to overrule the objection. You may continue.
Of course you are.
So, Mr. Griffith, you were talking about the steps that the agency took in order to establish a timeline.
Right.
Can you talk a little more about what witnesses or were witnesses interviewed in order to establish that timeline?
Sure. The agency interviewed Chris Melton, Chris Melton's parents, a coworker of Chris Melton's, I believe his name was Josh.
A coworker at the plumbing place that he didn't remember the name of, or he knew the name, but he didn't know the phone number or the address of. So his parents backed up his alibi. His coworker of the place he doesn't know the name of, he doesn't know the number or the address of, backed up his alibi. And then in 2023, he says that he lied. Oh, this is great. It's actually good for the defense. Let him go. Let him go.
And interviewed bank employees related to a banking transaction that occurred the day that Tara's body was found.
And so, and you said interviewed, was the timeline that the agency put together established that there were individuals who said Mr. Melton was with them during the time that Ms. Baker was murdered?
Based on the collective statements of all of those people, it would have been virtually impossible without some magic technology to move you from here to 60 miles to the west for Chris Melton to have killed Tara Baker.
Or people lied. Or his parents lied for him. Or he went to the bank to get money to pay the person who did it. I don't know. Those are just a couple of guesses of mine, but I'm no citizen crime analyst.
I don't have any other questions, Judge.
Cross-examination, Mr. Cruz.
Oh, can we do it tomorrow? He's like,
He let the jury know what year Chris Melton's timeline was finally confirmed.
I would say it was 2000 and, well, I can't say what year it was definitive, not without looking at the supplementals, but it would have been early on in the investigation.
Yeah, sure. And this was based on an interview with Chris Melton. Is that correct?
Right.
Okay. And you just tell me if you agree or disagree. Mr. Melton said he started his morning at his parents' home at 7:15 a.m. You agree, disagree, don't know.
Do we have a, can I use the copy of the timeline I brought with me?
May I see it?
Good.
Is that
Can
okay?
you
May I
enter
see
it as
it?
evidence?
Yep.
Is it part of a PowerPoint presentation like they did in opening?
Sure.
Andy says he went to the bank because he needed to buy bandages. Was it nearby? Was the drugstore nearby? Yeah. Were his hands all bandaged up when he went into the bank? He brought a timeline with him, and he wasn't given to the vent. Witnesses are instructed to never bring anything to depositions or to court because then it becomes fodder for cross-examination, and you must.
Let's start this way, and I'll get back to Chris Melton.
Okay.
And thank you for allowing me to see this. Can I use this for a second? If you need
Sure.
it, I'll bring it to you. And the information in here is all information within your personal knowledge. Is that correct?
That's correct. I just understand that that document was prepared by me more than 20 years ago. So
Well,
that's fair.
closer in time to the events, right, sir? Wouldn't you agree that it would be more reliable than your testimony today, 25 years later or 20 years later? Thank you, Scott. Please hit the like to push the video out, and thank you to the amazing moderators who.
I want to talk about the mitochondrial DNA analysis. Okay. What I understand is on page 5 of 36 of your report, the cold case, FBI cold case form, it states a request has been made to have mitochondrial DNA analysis done on one Caucasian pubic hair, which has not matched any elimination hair submitted. Is that correct?
that's correct.
Okay. Do you know, well, you know that mitochondrial DNA test was completed. Is that correct?
I do.
Okay. And that pubic hair came back to match Mr. Chris Melton. Is that, well, excuse me. I said that wrong. That mitochondrial DNA test came back that it could not exclude Chris Melton as a contributor of that hair.
I don't know that that's accurate.
It's not accurate.
I think my recollection is it matched a roommate. My recollection could be wrong though.
Sure.
There was a lot of hair involved in this.
Sure. Was seeing a copy of the mitochondrial DNA report refresh your recollection?
Surely, yeah.
Course indulgence.
The mitochondrial DNA could not exclude Chris Melton. And what do we know?
I'll ask this. Some testimony was presented that was not expected. I would like to address the testimony, but it may take me a minute to get the different files together. I would ask if we could take maybe a 5-minute recess for me to collect those
Yeah,
files.
just come back tomorrow.
5-minute recess.
Thank you, Your Honor.
I'll send you all to the jury room. This is a good bathroom break. Please don't discuss the case.
Well, let's see. Right now it is 5:03. So how much longer does she go? Let's see. We did really well today, you guys. We did really well. We covered Ashley's testimony from yesterday and today, and today's full day. I'm going to give us a big round of applause. Standing O for you guys.
I'd like you to look at, take your time, look over the entire document. But the particular page that I'm going to ask you about in regards to your response to my prior question is page 4, the first paragraph, and the last sentence in the first paragraph of page 4.
And Your Honor, just to be clear, I understand this is being offered to refresh Mr. Griffeth's recollection.
That's correct.
Yeah, okay.
Okay, I got the first paragraph. What was the other part of the last page?
So the fourth paragraph on the last page. I'm sorry. The fourth paragraph on the last page and the, saying that wrong. Page 4.
Third paragraph.
Page 4, first paragraph, last sentence.
And Judge, I do believe the witness can just review whatever he would like out of the report that he believes would refresh his recollection.
I mean, I think that is correct.
I don't disagree with that, John. I was trying to direct. Okay. Have you looked at it?
I have.
Okay. Is your recollection fresh?
It is. So the hair. Yep. So, all right. I'll let you ask a question.
Yes, sir. So in regards to the hair that was found on Ms. Baker's buttocks, Chris Melton could not be excluded as a source of that hair. Is that correct?
That's correct. And so could not Ashley Hall.
Ashley Hall.
So let me ask you this. We talked about his alibi. Okay. And you mentioned in regards to his alibi that he was with a coworker. Do you recall saying that?
I do.
Okay. Did you obtain any employment contracts to ensure that those two work together?
I did not.
Okay. Did you go to any place of employment that did you go to any place of employment that they may have worked on January 19th that confirmed that they were coworkers?
I did not. I did not personally interview Mr. Melton or the coworker.
What did your citizen crime analyst spidey senses tell you, sir?
Course indulgence, Sean.
He didn't even check to see that this guy was really a co-employee.
Were you aware that Mr. McCourty and Chris Melton stayed less than a mile away from each other?
I have a recollection that they lived in close proximity to each other.
Okay. Were you aware that those gentlemen went to high school together?
I don't know that I was aware that they went to high school together.
Of course.
Were you aware that Chris Melton were you aware that Josh McCourty drove Chris Melton to Athens?
Yes.
Okay. Were you aware that when Chris Melton gave his alibi to law enforcement, Josh McCourty left the police department?
I don't know that that would have been relevant to any of my analysis.
Was it Canton High?
Well, the statement that you made is that Chris Melton's alibi has been confirmed. Now I want to go through the steps that you all have taken as an agency to confirm his alibi. So as of right now, we've established that you did know that, or you may have known that Josh McCourty stayed less than a mile from Chris Melton, but you did not know that they went to high school together. We agreed on that fact, correct?
No, we don't agree on that fact. I may have known, it's been 20 years. I'm not going to remember all the details. I think I was doing good to pull up the first name Josh from memory, actually.
Yes, sir. But you told the jury on direct examination that you confirmed his coworker. Is that right?
That's my recollection, is that we interviewed his coworker, we interviewed his parents, we interviewed bank employees that were at the bank the morning he visited the bank, and that's how we came to put together the timeline of events surrounding
Mr.
Melton.
And I want to take it piece by piece, step by step, so the jury can understand what was done to verify this timeline. Is that fair?
Sure.
Okay, and please forgive I have to grab a couple of different things to go over that with you. So please.
Sure.
If you're not looking at my screen and you don't know that the members of my community are called cupcakes because I have this pink sign back there. I have 5 kids, and ever since I became a mother of 2, I've had a pink sign that says, you can't make everyone happy. You're not a cupcake. You make me happy. I make you happy. You are cupcakes. If you can't see that little Debbie icon in the corner up there, it says, I baked you some shut the fuck cupcakes. And they're chocolate. Parents are not alibis.
Melton.
And I want to take
our parents we interviewed directly.
Yes, sir. But you told the jury on direct examination that you confirmed his coworker. Is that right?
That's my recollection, is that we interviewed his coworker, we interviewed his parents, we interviewed bank employees that were at the bank the morning he visited the bank, and that's how we came to put together the timeline of events surrounding
Mr.
Melton.
And I want to take it piece by piece, step by step, so the jury can understand what was done to verify this timeline. Is that fair?
Sure.
Okay, and please forgive I have to grab a couple of different things to go over that with you. So please.
Sure.
Would you agree that during ACCPD's investigation, you all were unable to speak with any supervisor that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
I can't say. I don't recollect.
Okay. And that would be a fact that I know it's been 20 years. I'm just asking this to put it on the record. Would you agree that fact would be significant?
My recollection of Melton's timeline is essentially this.
Not the question.
Josh
don't let
showed
him
up
go.
at his house.
Don't let him go. It's a yes or no question. Judge, direct him to answer the question. Would it be significant? Would it be significant to know what his timeline was, or that nobody could confirm that he was at Nash Plumbing between 7 and 9 a.m.? Hello?
My recollection of
Here's the question.
That would be a fact that you were at 7 a.m. and 9. Would you agree that during ACCPD's investigation, you all were unable to speak with any supervisor that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
I can't say. I don't recollect.
Okay. And that would be a fact that you were, and I know it's been 20 years. I'm just asking this to put it on the record. Would you agree that fact would be significant?
My recollection of Melton's timeline is essentially this. Josh showed up at his house. They drove to the bank to withdraw some money. They went to a truck, to a company to have some work done on his truck, if I recollect. Those are all the details I can pull from memory off the top of my head.
Sure. So if you don't know, you could just say, I don't know. Okay.
Okay.
I think we've already agreed, but I asked just in case. You're unable to speak with any coworkers that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m.
I did not speak with any of Mr. Melton's coworkers, other than reading supplementals and putting together the timeline after the fact. I couldn't attest to what
You're a great citizen crime
what was
analyst.
said or not said, or who was interviewed.
Sure. But to your knowledge, you wouldn't disagree that as you sit here at this time, that you don't know if that was done?
I don't know.
Would you agree that you don't know at this time whether or not ACCPD spoke to any receptionists that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
I don't recollect.
Would you agree that as you sit here today, you don't know if ACCPD was able to speak with any eyewitnesses that confirmed Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001?
Can I have the report that I handed you back?
Absolutely.
Refresh my memory.
Now, I would ask you this. I've read the report. I know there's some language in the report. I would ask that, and just to let you know where I'm headed with these questions, I'm going to ask you very specific questions. And if you say that it's confirmed, I'm going to follow it with how. Is that fair?
Sure.
Thank you, Piney Woods, for your Venmo. Very much appreciated. You rock more. Thank you, Jane, for your Venmo. She says, DoorDash yourself some chicken soup and feel better. Thank you, Jane.
Okay.
All right. So I believe the last question I asked you is, as you sit here today, you're unaware as to whether any any eyewitnesses confirmed that Josh and Chris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001.
Here's what I can definitively say about Nash Plumbing.
That is not the question. Mr. Cruz is being too nice to this witness. Answer the question.
In 2006, when I was reviewing the case supplementals and interviews related to this investigation, my note says that Chris Melton and Josh McCurdy visited Nash Plumbing from approximately 7:45 to 9 a.m. on the morning of the 19th. That was based on an interview that Billy Ricketts did on January the 19th, 2001 and January the 21st, 2001. I think the best source of information related to that interview would have to come from Mr. Ricketts or from the people that were the subject of his interview.
Sure. Can you repeat those times to the jury?
Sure. 7:45 a.m. to 9 a.m.
All right. So you were unaware that Josh McCurdy told law enforcement that at 8 a.m. he was in Grayson at a house. Were you aware of that fact?
I can't say that I was or was not. I don't recollect.
Well, you spoke of Detective Ricketts' report. Would you like to see Detective Ricketts' report to refresh your recollection?
Sure.
Court's indulgence.
Wow. This is getting better and better. Can't wait for Billy Ricketts to come in and Josh too. Now I'm waiting for Josh and Chris Melton, all of
I'd like
them.
the record reflect that I am showing, and please forgive me, officer. Good afternoon. My name is Mike Cruz. I represent Mr. Edrick Faust. It has been a long day.
David Griffith.
Thank you, Mr. Griffith. Please forgive me. Let the record reflect that I am showing the state Detective Ricketts report from January 21st, 2001.
We have a little room to scooch.
Detective Ricketts report. Let the record reflect that I am showing the witness Detective Ricketts report from, I said the date wrong. I need to correct the record. From January 20th, 2001.
Okay. So my notes list Ricketts' report from January the 19th and January the 21st. Okay.
And I'll give you all three. I'll give you the 19th, 20th, and 21st.
Okay.
Oh, look at this. We are the lucky ones gifting 10 memberships. You are so lucky. All of you 10 new members are so lucky. Welcome. Welcome. Thank you for your generosity. We are the lucky ones. You're so generous. Scooch. Scooch.
Document. Mr. Griffith, I would like for you to read the second paragraph on that document, second paragraph, line number 4.
I think we are seeing the beginning of Mr. Cruz's what is going to be illustrious career, in my opinion. Although Julie Grant and I typically disagree on just about everything.
Okay.
You would agree that Josh McCourty stated at 8 a.m. he was in Grayson checking the house for leaks. Is that correct?
He said that they went to a house to check leaks.
At what time?
8 a.m.
But you just told this jury that from 7:45 to 9 a.m. they were at Nash Plumbing.
Well, the jury that was, this is my recollection of what happened. It's based on these notes here.
Understood.
Right.
Will we agree at this time that there's at least one error in the notes?
So, sir, this is a supplemental report written by a case agent. Hopefully, at the time that we prepared this, we went back and listened to the interviews directly. But I can't recollect what we did 20 years ago. But the case synopsis that we took with us to the FBI in 2006, we collectively made the analytical determination that from 7:45 to 8 a.m., Melton was at Nash Plumbing.
So the time has changed from 7:45 to 9 a.m. to 7:45 to 8 a.m.
From 7:45 to 9 a.m.
Okay. Excellent. May I approach?
Sure.
I would certainly hope you'd have some actual evidence against this man who's sitting in the defendant's chair, Edrick Faust. Say his name, Edrick Faust. Thank you, Gigi. How about empty envelopes? She says, this prosecutor's about as sharp as a bowling ball.
And just to make sure that we're clear on what we established that Josh said that he was in Grayson at 8 a.m. Would you agree with that?
Yes. Okay. That's what the supplemental report that I read says.
Okay. And the one that you mentioned that your notes were based off of, is that right?
No. My notes were based off reports from the 19th and the 21st.
Okay. So we'll go to the 19th. Showing the state Detective Ricketts report from January 19th, 2001.
Kelly says this trial is like Karen Reed in that the prosecution is spending more time trying to show Chris's innocence as opposed to proving Edrick's guilt. Agree. I agree. Thank you, Kelly.
Yes, sir.
Hey, it's me. Thanks for your 5. Says, forgive me, but I've had to come and go. What evidence did they have to prosecute this man?
Detective Ricketts' report from January 19th of 2001. I don't know that the witness has been asked an additional question that he has said he doesn't recall in order to refresh his recollection with this report, however.
Sure.
They say they have DNA from, 23 years later. That's true allele DNA. We have yet to hear about it yet. Thank you, Hates Me, for your 5. Irish Wolfhound Mama says, my son is a plumber. Never had hands like that. Talking about the picture of Chris Melton's hands. Thank you, Tracy. Kudos to me and my mods. The law and crime chat yesterday was awful. Appreciate y'all keeping it classy. Well, that's what we do here. That's what we do.
That's fair. Sure. Chris Melton stated that they went to Grayson, Georgia after 9:30 a.m. Is that correct?
don't know that I can say, I don't have a recollection of what Chris Melton said at this point 25 years later. I'm looking at the notes that are here in front of me to try to recollect, but I can't definitively say what Chris Melton said.
Would Detective Ricketts' January 19th, 2001 report refresh your recollection?
Possibly.
And I would like you to look at paragraph 2.
This is really scary.
Sentence 3, excuse me, the third sentence from the bottom to the bottom of the page.
Jack says,
reflect, I'm showing the witness, Detective Ricketts' January 19th, 2001 report.
all my homies hate true allele DNA analysis. Shooter UK says this trial is very scary, like Monty Python. Thanks for your super chat. Hey, it's me. Says, did Chris have clothes at Tara's house? He could have changed. Just a thought. Don't know. Set the place on fire. I mean, somebody set the place on fire.
So Chris stated they were in Grayson at 9:30 a.m. Is that correct?
That's correct.
Thank you, Nona3, for gifting 5 memberships. You're amazing. 5 new members. Yay, welcome.
Just to make it clear for the jury, so Josh McCourty's alibi for him and Chris is at 8 a.m. We're in Grayson. Chris Melton's alibi for himself is at 9:30 a.m. We're in Grayson. Is that correct?
That's what that supplemental report says. Yeah.
Okay. And this was the report you told me you relied upon. Is that correct?
So we referenced the interview that Ricketts had. We probably listened to the interviews.
Officer, we've already talked about this. We've already agreed on this. We talked about this earlier. So you didn't tell me that the January 19th, 2001 Ricketts report was the report that you
So we look at the total collective case file back when we prepared this in 2006, which would have been the interviews. You know, if there were video or audio interviews, we would have reviewed those. We would read those supplemental reports. Our collective assessment was we felt like Chris Melton was nowhere near Athens, Georgia during those hours.
But officer,
Whether it's in Grayson or at Nash Plumbing or it wasn't Fawn Drive in Athens, Georgia.
but you would agree with me, law enforcement officers don't go off feelings, they go off evidence. Is that right?
That's correct. Yeah, but it's not abnormal to take statements from
Did
different
he really
individuals.
say it was our feeling? What? Stop. What day are we? This is day 4 of this trial.
But officer,
Whether it's in Grayson, which would have been the interviews. You know, if there were video or audio interviews, we would have reviewed those. We would read those supplemental reports. Our collective assessment was we felt like Chris Melton was nowhere near Athens, Georgia during those hours.
but officer,
Whether it's in Grayson or at Nash Plumbing or
We felt like it.
it wasn't Fawn Drive in Athens, Georgia.
but you would agree with me, law enforcement officers don't go off feelings, they go off evidence. Is that right?
That's correct. Yeah, but it's not abnormal to take statements from different individuals and have time variations in their statements. You know, it's difficult for people to remember.
Within days of the incident? Within days? It's difficult for people to remember within days of a murder? No, I don't think it's difficult. Maybe 25 years later, but not within days.
What they did yesterday.
Is that right?
That's correct. Yeah, but it's not abnormal to take statements from different individuals and have time variations in their statements. You know, it's difficult for people to remember what they did yesterday.
Sure. What if they say they went to different places? Is that abnormal? Is that abnormal?
I don't think they say they went to different places. They collectively agree that they went to Grayson, right, to check a house for leaks.
Sure. So this is what I like.
Sure, so they got their story straight. They just messed up the times. I mean, I don't think there's anything wrong with that. I mean, they collectively agreed they were in Grayson at the time, so we just bought it. No, you know, Bo. I mean, are you kidding me? Are you kidding me? I want to know what the jury's reaction to this is. I wish there was someone in the courtroom.
Statements, you know, it's difficult for people to remember what they did yesterday.
Sure. What if they say they went to different places? Is that abnormal? Is that abnormal?
I don't think they say they went to different places. They collectively agree that they went to Grayson, right, to check a house for leaks.
Sure. So this is what I like to do. I like to show you the January 20th, 2001 report from Detective Ricketts, and I would like you to advise the jury of where Mr. McCourty said they went after leaving Nash Plumbing. Is that fair?
The day after the murder, January 20th, 2001.
Well, and Judge, I am going to object to that. Refreshing recollection isn't handing Mr. Griffith a report and asking him to relay to the jury what the report says. The question needs to be whether or not the report refreshes and brings to mind independently a recollection of that event. Sure.
Any response, Mr.
I agree.
I'm going to sustain the objection.
Josh McCourty stated after leaving Nash Plumbing that him and Chris went to Chick-fil-A. Would you agree with that statement?
That's what the report says.
Chick-fil-A? Was Chick-fil-A around in 2001?
So Josh McCourty said they went to Chick-fil-A. Chris Melton said they went to Truck Customs. Would you agree?
I think they did both, probably.
Well, we'll get into that. We're going to get into that. But Chris's next stop was Truck Customs. Is that correct?
Right.
Okay. And Chris says that they were at Truck Customs around 9:30 or sooner.
That's possible. I don't remember, what exactly his statement was.
Sure. Was he in the report? Refresh your recollection.
All I'll be able to tell you is what that report says. So if that report says,
well, if you don't move the ball on me.
But what you need to recognize is that's a summary of an interview that was conducted with this individual, and it's a summary that's paraphrased. So that wouldn't have been the best evidence for us at the time looking at this case file. We would have listened to the interview. Hopefully, I don't recollect if Ricketts recorded it or not, but that was the expectation at the time, is that you would record your interviews. We would have listened to the recorded interview.
So I want to make sure that you and I are on the same page. So it's not Ricketts' reports that you relied upon, it was the recorded interviews that you relied upon.
So we looked at the totality of the case file when I started looking at this case, which included audio recordings, video recordings, supplemental reports that case agents and investigators wrote. The totality of the case file as it was when we picked it up in 2005.
Sure.
Details weren't
So
important.
I asked you a couple of questions. If you don't remember, we'll play the audio recording for you. Is that fair?
Okay.
And Judge, I mean, I'm
Judge.
going to object. I think the witness has testified that all this will do is give him an opportunity to say what is in the report or what is in the recording, not develop an independent recollection of his own. I think that was his testimony the last time that a report or anything else was offered to him. So I'm going to object to that. Ricketts going to, I anticipate.
Ask yourself why the DA is fighting so hard to keep out the truth. Why is the DA fighting so hard to keep out the truth?
So I'm going to object at this point to using cross-examination as a method to just read in portions of a police report.
May I respond? Of course. The state opened the door to this line of cross-examination. This witness, nowhere in the discovery file, mentioned a statement that we confirmed Chris Melton's, let me rephrase that. The anticipated testimony for this witness based on the state's discovery file had nothing to do with confirmation of Chris Melton's alibi or non-confirmation of Chris Melton's alibi. When the state elicited an answer from him stating that we confirmed Chris Melton's alibi, it would be impossible for Chris Melton to be in Athens at the time, and he relied on these reports in making that decision. The state opened the door to this line of cross-examination. That's one, but I think that misses the issue of the state's objection. In regards to the state's objection, Mr. Griffin stated that he relied on these reports as well as the recorded audio in coming to his decision, Your Honor.
So let me ask you this question, Mr. Cruz. What is it that you're trying to do right now?
Confront the statement that he made that Chris Melton's alibi was confirmed. It was not, Your Honor. We have evidence to show that.
I'm going to sustain the objection and ask you to move on.
Yes, ma'am.
Of course.
Officer, I have no more questions for you.
Okay.
Any redirect, Mr. Yalamanchili, of this witness?
I just want to clarify, because there were a couple questions that Mr. Cruz asked you that I think the tail end of your answer may have been cut off. Just want to clarify a couple of things. Mr. Cruz asked you if Josh McCurdy said.
Objection, Your Honor. You just stated that we could not go down that line of questioning, so I would ask
Right.
the same restrictions placed upon the state.
Okay, well, that's not exactly what I said, but what is your specific objection?
He's talking about the alibi.
Okay. Mr. Yalamanchili, how is that relevant?
I'm simply asking the witness to clarify the answers he gave to two questions that Mr. Cruz directly asked him.
All right. Anything further, Mr. Cruz, based on that?
I would just simply ask the same restriction that's placed on us, that we can't get into that with this witness. I would ask that the same restriction is placed on the state. As I mentioned, Your Honor, they opened the door to this line of questioning. I was confronting the answer. If I can't ask about it, and I stopped as soon as he made his objection on the court stated that I couldn't ask those questions. I would ask the state not to make, let me rephrase that. I would ask that the state is the same restriction are placed on the state that's placed on the defense at this moment.
And if I-
that line of questioning.
If I could respond briefly.
You may, sir.
This is a question that Mr. Cruz did ask and received a response to with no objection. So I don't understand that argument. And I believe it is something that's proper and redirect to ask about specific responses to questions asked on cross-examination and the answers that were admitted in front of the jury.
All right. Yes, sir.
He's just trying to skirt around the honorable court's ruling. Your Honor has made it clear that that line of questioning is not appropriate for this witness. If he didn't object to it, he can't open the door, allow the questions, object. The honorable court says, no, those questions are not allowed. And then get up and follow up on the questions that I understand the honorable court is saying are improper for this witness. So I would ask that the state not be allowed to ask those type of questions.
All right, thank you. All right, so with regard to the actual objection, I think, Mr. Cruz, you're misstating what the court did. I have said this before. The use of the word restriction is not appropriate. The court made a ruling based upon the law and the analysis of the objection and what it entailed. It is not actually called a restriction. The state made an objection, the court ruled on it, and I sustained that objection. With regard to this particular moment, the state is asking to redirect based upon two questions that the defense asked that were permissible. I'm going to allow it. You may proceed.
So I want to start first with a question that was asked to you. I think Mr. Cruz asked you a question of Mr. McCurdy said he was in Grayson at 8 a.m., I believe was the question. Your answer said they were. What do you mean by they?
So Josh McCurdy said that that's what the supplemental report said, they. So I think the best way to let's back up and talk about what I know.
Sure.
Collectively, at the time, we were reviewing all of the
said.
interviews that had taken place previously in this case, where we looked at Josh's statement, Chris's statement, the parent's statement. Collectively, they all put Mr. Melton to the west, way out of Athens, Georgia. There may not have been perfect agreement in the minute-by-minute recollections of where people were. But at the end of the day, there were multiple people that put Chris Melton over at his home, near his parents' home.
Well, and I'm sorry, and I just want to stop you because I think I might have asked my question poorly.
Okay.
But
Hang on one second, Mr. Yellow. I think Mr. Cruz has an objection before you continue. Go ahead, sir.
The state has opened the door again, and I would ask for the opportunity to cross-examine this witness on the statement that the witness just made before the jury.
You will certainly get the opportunity to cross-examine. I don't know. I'm not going to respond to the opening the door at the moment. I don't know that that's necessarily an objection. But if you need to recross this witness, you certainly may do so. Go ahead, Mr. Yellow.
And I'm sorry, I'll ask it more precisely. They is a plural pronoun, correct?
I take that to mean, based on my collective knowledge of the case, that Josh and Chris.
Okay, that was my only question. And I'm sorry, I should have asked it in a more precise manner that way. Mr. Cruz asked you about some mitochondrial DNA results, and he said this result indicated that Chris Melton could not be excluded in the report. And your answer referenced one other person in addition to Chris Melton. Who were the people who could not be excluded as contributors of that hair?
One of Tara Baker's roommates and Chris Melton.
Okay.
How
I believe
is
it was
that?
Ashley Hall.
That's it, Judge. Just two questions.
How can both Ashley Hall and Chris Melton not be excluded from mitochondrial DNA? That's bizarre. Where are my DNA experts in the chat?
Recross, Mr. Cruz.
Absolutely, Your Honor. And I just want to follow up on a specific question that the state asked you. He asked you what did, he stated that on cross-examination, I said he, you said they, and they means Chris and Josh. Is that correct?
That's how I took it.
Okay, that's fair.
Enforcing intellectual competence because they are related. Did we know that Ashley and Chris Melton are related? I mean, does it confirm that they're related now? Was she asked that on direct? I am so confused.
The timing of being in Grayson at 8 a.m. Is that fair?
Yes.
Okay, so I'm asking you a different question from what I asked you before. Chris Melton stated that he was at Nash Plumbing at 7:45. Is that right?
I believe that's correct. Yeah. So my notes say that, and this is a case summary that was presented to a bunch of investigators at the FBI, right? We believe, based on the totality of the interviews that we listened to, the case supplemental reports that we read, that Chris Melton was not in Athens, Georgia. He was over near Nash Plumbing.
But officer, you already said that you all didn't confirm, or you're not aware of you all confirming Chris being at Nash Plumbing.
That's not what I said. I said I couldn't confirm, but I'm looking at this case file multiple years down the road, looking back at interviews that were done in 2001. As I sit here today, 20 plus years later, I may not recollect accurately what we looked at 20 years ago. But my understanding of the case is we felt collectively at the time that Chris Melton was not, that it would not have been possible for him to have been in Athens, Georgia and killed Tara Baker.
Okay. And that was based on, I think we agreed, just you all's collective feeling. Is that correct?
No, not our collective feeling, our collective review of all the evidence that had been collected to date.
So let's talk about the evidence. You would agree that law enforcement spoke to Chris Melton's parents 4 months after Ms. Baker's death?
I couldn't tell you when they spoke to them. Here, 20 years later, I don't know what day they spoke to his parents.
Mr. Griffin, we can't have it both ways. We can't say we're sure that we confirm Chris Melton is away from Athens, Georgia, and then when we ask about the specific.
I don't think those are my words.
Hold on. I'd ask that Mr. Cruz ask questions to the witness, not make comments about the witness's response.
Yeah, I think that's correct.
Yes.
Ask a question, Mr.
Yes, ma'am. But you would agree that I believe it was, I won't even say the date, but in May of 2001, law enforcement went to interview Chris Melton's parents regarding his alibi for the first time.
I cannot tell you when they would interview them for the first time. Sitting here today in 2026.
That is fair. Did you look at any report that discussed when they went to interview?
I'm sure I did.
Okay. Would seeing that report refresh your recollection?
All I would be able to do is read back the report to you at this point. And I'm not trying to be belligerent or difficult. I can't tell you.
Just don't want to answer the question.
What we did 20 years ago to a certain date.
But officer, you just told the jury what you all did 20 years ago. We just want to understand the foundation of it. Is that fair?
Object again, Judge. Mr. Cruz is to ask the witness questions, not make comments about the witness's responses. So I would object to the form of the question.
That's correct. Mr. Cruz, ask the question if you want to.
I do want to, Your Honor.
And go ahead.
Please forgive me.
Do you think the jury is picking up that picking up on the fact that he's being completely obstinate? Is it just me?
And I'll say, please forgive me, Mr. Griffin. Let's take it step by step, okay? You relied on Detective Ricketts' January 19th and January 21st report. Is that fair to say?
Asked and answered.
I'll allow it. Go ahead.
Is that fair to say?
Yes. And the only reason I can say that is because I have it in my notes that's what we relied on.
Okay. Excellent. And we've agreed that from 7:30 to 7:45, Chris Melton stated that he was at Nash Plumbing.
My notes say that from 7:45 to 9 a.m., Chris and Josh McCurdy were at Nash Plumbing. And that this is a summary of a lot of interview that took place. So as I sit here today, all I can tell you is we didn't believe they were in Athens, Georgia. Now the best way would be talk to Chris Melton.
Well,
right? And Josh McCurdy.
Well, I just want to follow up on your statement. So let me ask you this.
So we should talk to them now. You are the citizen crime analyst in this case. You're the citizen crime analyst, so you're telling us that we should now ask. This man is on trial for his life right now, okay? And you're telling us we should just check with Chris Melton? My brain hurts too. My brain hurts. You have no idea. 7.5 hours we've been here. My brain is hurting like you have no idea. But I'm still have to rewind this a little tiny bit because I still can't believe this is real.
As I sit here today, all I can tell you is we didn't believe they were in Athens, Georgia. Now the best way would be talk to Chris Melton.
Well,
right, and Josh McCurdy.
Well, I just want to follow up on your statement. So let me ask you this: is it fair to say that we shouldn't? And this is the best way I frame it, so please forgive me. Based on our conversation here today, your report may not be the best place. Excuse me. Your report may not be what we need to trust in determining whether or where Chris Melton was on that day. Is that fair?
We started out talking about what my recollection and understanding of the case file was, and my analytical assessment in 2006, and still to this day, is that Chris Melton was not in Athens, Georgia, and that's based on all the testimony of the people that we've talked about.
And that's Josh McCurdy, correct? Chris Melton, and Chris Melton.
You could say yes or no, please, sir.
Yes, and bank employees at a bank. I want to say it was a Wachovia, but off the top of my head, I can't be certain.
You would agree with me that Chris Melton wasn't at the Wachovia until 9:08 a.m. Is that correct?
I don't know for certain.
But you spoke to 4 people. Is that right?
No, more than 4 people.
Okay, so it's no longer Josh McCurdy, mom and dad, Chris Melton, and bank employees. Who else did you speak with?
My recollection is we spoke to Chris Melton, Josh McCurdy, Chris's mom and dad, and 2 bank employees.
So for the purposes of this conversation, we'll take the bank employees out of it. You and I have agreed upon that you didn't know that Josh and Chris went to school together. Is that right? We've agreed on that.
No, we haven't agreed on that. I don't remember if I knew that or not. Right now, as I sit here, I don't recollect.
Did you note it in your report?
Not in the report that's in front of me, no.
Okay.
And I'm not sure why it's relevant. What does that have to do with anything that we're talking about?
Well, we could talk about it after court, but as of right now, the Honorable Court has said I only can ask questions. So can you answer that question for me, officer?
What's that?
The question is it in your report that Josh and Chris went to school together?
No, and I don't believe that I would have included it in my report if I'd known it.
So your report does not include all the details relevant to this case. Is that fair?
I think it includes the key details that were important to our investigation at the time that I prepared it.
But officer, you told the jury that Josh and Chris were employees. Would you agree that that gives a different significance from high school classmates? I'll say that.
Absolutely. The totality of the relationships between all the people involved are for the jury to weigh. Absolutely.
And were you aware that Chris Melton was his parents' only child?
I believe I was.
And is it fair to say, do you have children, officer?
I do. Yeah. And parents will do a lot for a child.
I don't even have to ask my next question then, officer.
You said it.
In regards
Parents will do
to
a
Nash
lot
Plumbing,
for
that's
a
really what I
child.
want to focus on. I want to
Parents will do a lot for a child, like lie for your alibi. Okay.
focus on the Nash Plumbing. I want to make sure that we're on the same page. We've gone from, I believe, and correct me because I think I'm going to say this wrong. We've gone from 7, how's this? Give me the times that you state Chris is at Nash Plumbing.
So on this timeline, we have from 7:45 a.m. to 9 a.m.
At Nash Plumbing.
Mm-hmm.
And we've established that Josh McCourty said at 8 a.m. they were in Grayson, Georgia.
Right.
Okay. And we've also established that Chris Melton said after 9:30 a.m. they were in Grayson, Georgia.
Right.
Okay. So you'd agree this is one contradiction in the alibi.
And like I said before, there are going to be contradictions when people are trying to recollect
Sure.
minute by minute.
Sure.
That is fair.
Right.
That is fair. Would you agree that after leaving Nash Plumbing, Chris Melton stated that they went to,
I think it was Truck Customs.
correct.
I think that he's
However,
even
Josh
trying-
McCourty stated they went to,
he's even testifying to say that Chris Melton is innocent. I don't get this. I don't. It's just so bizarre. He doth protest too much.
Chick-fil-A. Is that correct?
Right. Yes. Exactly.
That's what the supplemental report has in it. Yeah.
Sure. And this is a question I want to ask you, okay?
Mm-hmm.
You would agree that Josh McCourty was asked if he went to the bank with Chris Melton. Would you agree with that?
Yes. I feel certain that that was a question that was asked of him.
Okay. And Mr. McCourty said he didn't remember.
I don't recollect what Mr.
Remember.
I can't tell you what he said.
Would he in the recording refresh your recollection?
It,
The same objection as before, Your Honor. This witness has indicated repeatedly that all the reports or recording would do would prompt him to say what is in the report or recording because he didn't interview.
Josh doesn't remember
Stay.
going to the bank.
Yes, ma'am. Yes, ma'am.
I mean, why are we here? Why are we here?
Court's indulgence. Chris stated that they went to, well, excuse me. Do you recall Chris stating that they went to Forsyth and met with a contractor named Mike? Do you remember that?
I don't remember those details.
Do you remember anyone at ACCPD ever speaking to a contractor named Mike that could confirm that Chris was in Forsyth?
I can't say with certainty whether or not a contractor in Forsyth was spoken to.
Okay. And I ask you this, and I'll let this probably be my final question. When it comes to the questions I asked you, there's no certainty, but you would agree when the state asked you if Chris.
Object to that question. It's argumentative.
Sustained.
Argumentative.
Is it fair to say we aren't, outside of the 3 individuals you spoke to, excluding the bank, is it fair to say we don't have any other evidence of where Chris Melton was between 7 a.m. and 9 a.m. on January 19, 2001?
Mr. Cruz, what I can tell you with certainty is that as I sit here today in 2026, my assessment of Chris Melton's timeline in 2001 as an investigative analyst that's investigated hundreds of violent crimes is that Chris Melton has substantial testimony from other people that puts him away from Athens, Georgia at the time Tara Baker was killed. And our assessment in the analytical.
Answer the effing question. For those of you who know who Joseph Scott Morgan is, close your eyes and tell me this man's voice is not exactly Joseph Scott Morgan. Listen to the question and then listen to his ramble on Rose answer. Rambling man. Isn't it true that aside from
Evidence of where Chris Melton was between. Is it fair to say we aren't, outside of the 3 individuals you spoke to, excluding the bank,
outside of 3 individuals that you spoke to, excluding the bank,
is it fair to say we don't have any other evidence of where Chris Melton was?
is it fair to say that we don't have any other evidence of where Chris Melton was? That's a yes or no answer.
Was between 7 a.m. and 9 a.m. on
7
January
and 9
19,
a.m.
2001.
Mr. Cruz, what I can tell you with certainty is that as I sit here today in 2026, my assessment of Chris Melton's timeline in 2001 as an investigative analyst that's investigated hundreds of violent crimes is that Chris Melton has substantial testimony from other people that puts him away from Athens, Georgia at the time Tara Baker was killed. And our assessment in the analytical unit at the Athens-Clarke County Police Department was that Chris Melton could not have killed Tara Baker.
That's based on those? That's
based on the totality review of the case file at the time that we looked at it in 2005. And that's what we presented in Quantico, Virginia at the FBI Academy.
Sure. And even the FBI advised you all to investigate Chris Melton's hard drive. Is that correct?
I recollect that there was a suggestion to look at his hard drive in an email from Christine DePoyster. I don't think that I don't know that Chris Melton had a hard drive to look at.
Well, this is what I follow up with.
Who knows?
If ACCPD was so certain that Chris Melton was away from Athens, why would the FBI request or instruct you all to look at his hard drive?
It goes back to something I said before. We did not eliminate Chris Melton as a person of interest. He was not at the top of our list of persons of interest. So, you know, from an analytical standpoint, we had to look at, could we absolutely eliminate him? I would not absolutely eliminate my mother from the crime. If somebody came and said that my mom could possibly have been involved, but it made it, the totality of the statements that we reviewed made it seem very implausible that Chris Melton was in Athens, Georgia at the time Tara Baker was killed. Now, if you presented some significant evidence, you know, if Chris Melton was seen on video in the neighborhood with a timestamp of 8 a.m. on January the 19th in 2001, that might change my assessment. But
can I ask you this?
Sure.
So you need a receipt.
You'd agree that Mr. Faust wasn't seen,
as opposed to just taking someone's word for it. Your mom has entered the chat.
8 a.m. on January the 19th and the time Tara Baker was killed. Now, if you presented some significant evidence, you know, if Chris Melton was seen on video in the neighborhood with a timestamp of 8 a.m. on January the 19th in 2001, that might change my assessment. But
can I ask you this?
Sure.
Somebody saw a white guy running through a backyard, as far as I recall. Did they call that witness yet? Was he on video at the bank?
You'd agree that Mr. Faust wasn't seen on video at 8 a.m. in the neighborhood. Is that correct?
I didn't say he was, but I was talking about what might change my mind. Now, if we saw a video of Mr. Faust in the neighborhood, that would be a clue, right?
Great.
But you also didn't see any video of Deer Park. Is that right?
I don't think I saw any video from Deer Park.
And outside of the bank, so we're not talking about the bank. We're going to assume that the bank is at 9:08. Between 7 a.m. and 9 a.m., you all didn't collect any video where Chris Melton was located. Is that correct?
The only video that I recollect being collected, or I don't think it was collected, I think it was seen, was Chris Melton in a bank.
That's fair. And to conclude my questions for you, FBI stated search the hard drive. That wasn't done, was it?
I don't believe there was a hard drive to be searched.
So that's a no?
I cannot say with certainty that we didn't search a hard drive as I sit here today, but I do not have any recollection of searching a hard drive.
Okay. Well, I thank you so much for your time. I thank you so much for answering my questions, Your Honor. Those are my questions for this witness.
Any redirect, Mr. Yalamanchili?
No, Judge.
May this witness be excused? Mr. Yalamanchili, may the witness be excused?
Judge.
Any objection from Mr. Cruz?
Did you receive a subpoena from our office?
I did not.
Okay. No objection.
You're free to go, sir.
May I sit in the courtroom, Your Honor?
Yes, you can. Your testimony is over. All right, ladies and gentlemen, it's 5:30. We have gone a little bit past sort of my 5 o'clock stop, and so we are going to stop. Thank you for your patience. I'm going to release you today, ask you to return tomorrow at 9 o'clock. The attorneys in the court are going to take up some things outside your presence, so hopefully we'll be able to start right at 9 o'clock tomorrow. We are going to finish tomorrow. I believe it's at 2:30. Is that the time? Okay, 2:30 tomorrow. And so because of that, we are going to bring lunch to you all again tomorrow. We'll bring you the I'm not sure what it's going to be. It may be menus again. I'm not really sure, but we will certainly provide that for all of you. Please don't discuss the case. Do any research. Go on the internet and look up anything you may have heard. Enjoy your evening. We will see you tomorrow at 9 o'clock. The deputies are going to escort you all, of course, to the elevator.
Okay.
State is prepared to address.
All right.
For D30, that's all.
We may have said two things.
Way there too, Judge.
Okay.
One now and then.
All right, the jury's
Okay.
out.
Peterson was-
This is end of
Mr.
the day.
Peterson's the one in the morning.
Yes, sure.
Okay.
Hey, can I put something on the record just in the meantime?
Can you, I'm sorry, go ahead.
Can I put something on the record?
You may.
Yes.
Just putting this on the record in regards to Defendant's Exhibit 30, which were Tara Baker phone records. If undersigned counsel understands Mr. Bowden's objection correctly, it was that the records were hearsay and I needed to lay a foundation for the business records.
Wait, Mr. Cruz, I probably should have asked you what you need to put on the record. What is it that you're doing?
I was just going to put the grounds of admissibility for D30. That's all.
But I've already heard the objection and ruled on it.
No, I wasn't asking for a ruling, Your Honor. I was just asking to preserve the record.
Well, the record is preserved because it's being transcribed. I'm not sure I know what you're referring to.
Please forgive me.
Okay.
So I didn't quite understand Mr. Bowden's objection. So I didn't put my response to his objection once I understood it that it may be a hearsay objection on the record. What I intend to put on the record, if I may, is just simply that the phone records are non-hearsay because they are computer-generated records. So if his objection was that it needed a business record certification to come in as hearsay, our response would be that it is non-hearsay because these records were computer-generated. That's all, Your Honor.
All right, thank you. And Mr. Bolden, did you want to respond then to Mr. Cruz's?
Christy, if you're going to go to court tomorrow, yeah, definitely, absolutely. Take my email. It's in the show notes. And you could report to us on jury reactions. That would be great.
Response. All right, thank you. All right, what are we going to handle this afternoon since we're doing something at 8:30 as well?
Your Honor, we are prepared, state is prepared to address Mr. Cruz's Daubert motion filed back on October 2nd of last year. The court may remember that the state, I think we made a joint motion to continue this. The state's reason for doing so is that, pardon me, Your Honor, is that our witness, who is currently right outside the courtroom, would be traveling from California, and we were trying to see if we could only require her to travel here once. And so what the plan was, as I understood it, was to have her testify outside the presence of the jury for the Daubert purposes, and then, depending on the court's ruling, we would have her testify tomorrow morning.
Hold on just a minute. I'm trying to find your motion. You said the motion you're referring to, it was October 2nd? So you want to have the Daubert motion now?
Yes, Your Honor.
Okay, I just need to find it.
And I would object to having it now. I would like notice to prepare for it. I know we said that we have it when she gets ready to testify, but we never said a date certain. So I have time to prepare for it.
Yeah, how about he should have some notice when he's going to have to do a Daubert hearing and he's going to have to question the expert. Let him have a little preparation time. You don't just bring your witness in and say, by the way, Judge, we'd like to do it now at 5:30 on Thursday. Oh, today's Thursday, right? I think earlier I said it was hump day because yesterday I was asleep all day because I was sick. I missed a day.
All right, tell me the name of the person that you were asking to exclude the testimony of? Okay, I just have to find, oh, here it is.
Who?
All right. All right, Mr. Bolden, do you care to respond to this defendant's request?
Your Honor, Ms. Lackholm, like I said, is right outside the courtroom. The state's ready to go.
Did you tell him you were going to be ready to go?
This morning, still ready.
Okay.
I would need, I'm requesting more than saying they notice for hearing on this Daubert.
Okay, well, let me say a couple of things. So first, I think it's appropriate for counsel to always be prepared for motions they know that are coming up.
Try by
We have
ambush.
discussed this. I remember it now. I'm looking at the motion. There were several, I think, that we were going to have before the testimony. Now, I think it's appropriate for all counsel to always be prepared. Once trial starts, anything can go. So I will say that. This is what I'm going to do, though. I'm going to let the state present their side, and if you're not prepared to go forward, we will address it tomorrow at 8:30. All right, you may proceed, Mr. Bolden.
Marissa Lackholm?
Could you get Marissa Lackholm, please?
This is voir dire. This is a Daubert hearing. This is outrageous. Like this guy is not a one-man band already. Attorney Cruz, don't give him the heads up that you're bringing your witness in for the Daubert hearing that you requested in October, and then told the judge you only wanted to fly her in from California once when you have an unlimited budget because you're the freaking state of Georgia. Okay?
You can have, go ahead and have a seat if you like. Ma'am, can I get you to raise your right hand, please? Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. If you could state your name and spell it for our court reporter, please.
My name is Marissa Laquan, and it's spelled MARISSALICON.
Where are you employed, ma'am?
I'm employed at Pure Gold Forensics.
Where is Pure Gold Forensics located?
We're in Southern California.
What what is Pure Gold Forensics?
We're a private accredited DNA forensic laboratory. So as a private lab, we
provide services for prosecution, defense, as well as private parties.
How long have you been working at Pure Gold Forensics?
Since May of 2022, approximately 3.5 years.
Okay. And can you tell the court a little bit about the responsibilities you've had at Pure Gold since you started working there?
Yeah, so I started as a laboratory assistant, which consisted of maintaining the laboratory cleanliness, receiving and sending back evidence, maintaining chain of custody of that evidence, as well as any administrative duties, as well as I maintain the temperature logs in the laboratory and clean our instruments. Do you want me to go through my duties now?
Yeah, and then after working as a laboratory assistant, were you promoted to the title of forensic scientist?
Yes.
And when did that occur?
In February of 2024.
Okay. Tell the court a little bit about your responsibilities as a forensic scientist.
As a forensic scientist, I perform serology testing as well as DNA casework using global filer and Y-filer amplification kits. I analyze mixtures using StarMix probabilistic genotyping software, and I analyze the data and produce scientific reports based on that data.
You mentioned StarMix just a minute ago. Are you familiar with TrueAllele?
I'm familiar.
Okay, and I guess my question would be, are those kind of competing brands of
there's
genotyping software? Okay. Talk to the court, if you will, a little bit about your educational background.
I have a bachelor's of science degree in forensic chemistry with a concentration in criminalistics from California Baptist University.
Can you speak a little bit to any specialized training that you've had as it relates to your job as a forensic scientist at Pure Gold?
As far as like continuing training or
Yes,
just
exactly.
training in general?
Yes.
So as analysts, we're required to complete at least 8 hours of continuing education per year. That can include lectures, conferences, webinars that brings analysts up to date on current technologies and information, as well as we're required to complete monthly reading in the laboratory on scientific articles, anything having to do with DNA analysis.
Do you belong to any professional organizations?
Yes, I'm an affiliate member of California Association of Criminalists, as well as a professional affiliate of American Academy of Forensic Sciences.
In your role as a forensic scientist at Pure Gold Forensics, do you have the occasion to run testing on items of evidence that may be submitted in an attempt to ascertain their possible biological origin?
Yes, so at our lab, we offer testing for different biological fluids. We offer blood, semen, saliva, urine, as well as microscopic examination of vaginal epithelial cells and identification of spermatozoa.
Ma'am, have you previously testified as an expert?
Once before.
Okay, and where was that?
In Colorado.
And do you recall what you were tendered as an expert in?
DNA analysis.
Your Honor, at this time I would move to tender Ms.
Did she say once?
Well, I haven't finished talking yet.
Go ahead, sir.
I would move to tender Ms.
She's testified as an expert once. Did she just say that? Do you remember the hoops that Dr. Russell had to jump through? And Dr. LaPosada and everybody that was given a Daubert hearing in Massachusetts? If she allows this person to testify as an expert, I am going to lose my shit.
Testing on items of evidence that...
Semen, saliva, urine, Colorado.
And ma'am, have you previously testified as an expert?
Once before.
Okay, and where was that?
In Colorado.
And do you recall what you were tendered as an expert in?
DNA analysis.
Your Honor, at this time I would move to tender Ms. Well, I haven't finished talking yet.
Go ahead, sir.
I would move to tender Ms. Lycon as an expert in forensic chemistry and forensic biology.
Okay, forensic chemistry.
One is the loneliest number.
All right, Mr. Cruz, any objection? And
Yes.
Yeah, all of them.
We talked about your needing to go get your information, and so let me know, do you want to proceed or do you want to adjourn and come back at 8:30 and finish any cross-examination?
I think I'll proceed, Your Honor.
All right, go ahead, sir.
And just to make sure before I proceed, Your Honor, can you repeat what the state is tender as an expert in?
Yes, what I wrote down, Mr. Roll, to make sure that this is correct, is that he is asking to tender this person as an expert in forensic chemistry and forensic biology. Is that correct, Mr. Roll?
It is, Your Honor.
All right, go ahead, sir.
Didn't hear anything about methodology.
Can you tell the Honorable Court what forensic chemistry is?
Forensic chemistry would be, well, it's chemistry, so the study of elemental composition with a forensics application.
Can you explain that in layperson terms?
So it would be like chemical substance in reference to forensics, so having to do with evidence examination.
Okay, in what way?
So, for example, an example that comes to mind would be blood alcohol content. So testing that in regards to like a legal matter.
Okay. You would agree that you are not here today to testify about blood alcohol content, is that fair?
That's correct.
You would also agree that you have never been admitted in any court as an expert in forensic chemistry. Is that correct?
That's correct.
Okay. Nor have you ever been admitted as an expert in forensic biology. Is that correct?
I would say that a DNA expert is an expert in biology.
Sure, but you're not here today to discuss DNA. Is that correct?
That's correct.
What are you here today to testify about?
Serology testing.
I believe you said you've been in your field since, did you say you graduated in May of 2024?
I graduated and was hired at the lab in May of 2022.
2022, okay. And from May 2022 to February 2024, I'm gonna go point by point. Your duties included maintaining temperature and cleaning logs. Is that correct?
That's not correct.
That's not on your resume or your CV?
Well, yes, my title changed in between there. So I started doing serology cases in August of 2022.
She's not an expert. I don't care what court you're in. She's not an expert. And yes, I understand
What
that
type of
everyone's
serology-
got to start somewhere, but this is not the place to start. Okay, this is not the place to start in a brutal cold case murder from 25 years ago.
What testing are you here to testify about?
Vaginal epithelial cell testing as well as saliva testing.
You'd agree that epithelial cells are all throughout the linings of the body.
Yes, that's correct.
Okay, and the mouth, is that right?
Yes.
Your Honor, I would object. I think at this point, we're just trying to voir dire the witness as to whether or not she's an expert. Now, he's
correct. That is
certainly
correct.
sound like, anyway.
Okay, well, I'm going to advise all counsel that we are having a hearing under 702.
Correct.
All the factors under 702, A, B, and particularly B, 1, 2, 3, and 4 need to be addressed in order for the court to make a decision. So you may continue, but at the same time, Mr. Golden is correct. This is not necessarily about the entirety of her testimony, but I'm going to let you continue.
Yes, ma'am.
She's not an expert.
So can you tell me about your experience with identifying vaginal epithelial cells from oral epithelial cells?
As far as the method we use in our laboratory, or can you clarify?
Yes, ma'am. How many times have you been asked to differentiate oral epithelial cells from vaginal epithelial cells?
Between training and casework, possibly around 50 times.
And there's a test to separate epithelial or differentiate oral epithelial cells from vaginal epithelial cells?
A presumptive test, yes.
Okay. And what's the name of that presumptive test?
Lugol's iodine presumptive test for vaginal epithelial cells.
Okay. Now, would you agree that a presumptive test is a test that requires a confirmatory test to make a determination whether the substance is what you believe it to be?
I wouldn't say it requires. A presumptive test alone is just an indication that a substance may be present.
So the Lugol's iodine test is what you're here to testify about today, is that right? Not today, but testify about, is that correct?
Correct.
But from what you just stated, this testing is just to determine if something may or may not be present. Is that fair?
An indication if something's present.
Okay, it's an indication that something may be present, correct?
Yes.
What is the confirmatory test that is done following a Lugol's test?
There's no confirmatory test for vaginal epithelial cells that I'm aware of.
Okay. Excluding the I'm aware of portion, do you know why there isn't a confirmatory test?
Yes, because so some buccal oral secretions, well, I guess I would have to explain kind of the test further. Is that okay?
Whatever you're comfortable with.
And again, Your Honor, I think I still have this witness on direct. I understand that the procedures allow Mr. Cruz to voir dire her as to her expert qualifications so that we can establish that for the record. And then the state would intend to go about its direct examination about the testing that Ms. Lacan did. So can we just get past that first hurdle?
That's actually true. I sort of got far afield. You're actually right. We got to do this in two separate portions.
Sure.
Your objection was to the state tendering this witness as an expert
Correct.
in forensic chemistry and forensic biology.
Correct.
Your objection, I'll let you voir dire her for your objection.
Correct. And I don't mean to cut that over.
That's all right. Anything else you want to ask her with regard to that objection before we get into whether 702 is met?
Okay, let me make sure I understand. Maybe I understood differently. I was asking her questions regarding B2 and B3. I was getting into that area. Are you saying you'd like me to focus only on
There are two parts to this Dauber motion. We kind of got far afield on that. So my question to you now is, do you object to this person being tendered as an expert in forensic chemistry and forensic biology?
Yes, ma'am.
Okay, and the reasons for that?
I was getting into the examination with her regarding.
Okay, that's for the next portion of the
Sure. Yes, ma'am. Yes, ma'am. So if the honorable court would like to answer now, one, this witness has, correct me if I say anything wrong. I don't want you to think I'm trying to, I just forget sometimes. But this witness has never been tendered to testify as an expert in forensic chemistry and forensic biology for this particular test. From what I understand, she stated is that her expertise that she has been admitted in court on is DNA.
That's correct, but I would argue that that encompasses also serology testing.
You're not
Sure.
here to
Does that
argue.
encompass Lugol's iodine test?
Yes.
You've been admitted to testify, if I may, Your Honor.
Go ahead.
You've been admitted to testify as an expert in regards to Lugol's iodine test in the court?
No.
And the reason for that is because it is a presumptive test. Is that fair to say?
I haven't been called to testify ever on the specific test.
So this is the first time you've been asked to.
Yes.
Your Honor, once again, we are venturing so far astray of the purpose of the voir dire of the expert or the witness's expert qualifications.
I'll make.
Okay, I got to end this here because it's going to make me insane. Here, according to Law and Crime, they're doing a poll right now. They've got only 3,300 votes. What is your opinion so far in this trial? Reasonable doubt, not guilty, 38%. They have the right guy. Guilty, 24%, and too soon to make up my mind, 37%. I'm going to watch the rest of this Daubert hearing on my own because this is just going to really annoy me even more because they're still going on with this. It's still live and it's 6:04 here on the East Coast. And we're going to find out what happens tomorrow because I'm just tired and I need to go to bed now. I need to be in bed now. I'm done with this for the day. So if you want to watch it, go on over to Law and Crime and continue watching this non-expert, probably be admitted as an expert. And let me know how you feel about it in the comments below. Hey, it's me, said I wish I lived in Georgia just so I could show up to support the defense. I have not heard anything at all except roads leading to the boyfriend. Mr. Cruz has such a mountain he's facing. I know. Mr. Faust does too. Agreed. Thank you so much for your 10. Gigi's here. She says, I hope the jury's getting Scooby snacks. We can tell the judge and Smeckasaurus had their fill. Thank you, Gigi. Crime Junkie, thanks for your 5. Says, I'm so far behind, but this is a kangaroo courthouse. Me rolling. Just love you. I love you more. Fat Baby's mom says, if asked now, I think the jury would say not guilty. Well, not Law and Crime Chat, because 24% say over there, at least 20-something% say that he's guilty. Based on what? I have no idea because I haven't heard one thing yet. Kim says, I think we're watching the next John Grisham movie. Gigi. Roscoe. Train. Dukes of Hazzard. Boss Hog. I'm that old. Thank you, Gigi, for your 5. Gigi also says, Melanie, my granddaughter Leighton ran into my office. She heard Miss Melanie's voice. She said, Miss Melanie does not feel good. I blew you a kiss. Oh, kisses to you, Leighton. Thank you, Leighton. Oh, she wants to give me her blankie. Oh, that's what a sweet girl. What a sweet girl, Gigi. You are blessed. Not a House defendant says Mr. Cruz needs to stop saying that's fair. Oh, I see what you're saying. That's fair. When he's questioning, he's like, that's fair. Yeah, because nothing about this. Nothing about this is fair, in my opinion, and maybe in yours too. What a day. What a day. As always, please tell me about your favorite parts of the day in the comments below. And we're all in on the same joke, apparently. We are all in on the same joke. Here we are, and we're all in on it. And it's a travesty of justice, and here we are. And the fact that there's so many people in the Law and Crime Chat saying that this guy is guilty is wild to me. Thanks, Gigi, for buying me 5 matcha lattes. You're amazing. I appreciate you so much. And I gotta go back to bed. It's enough. It's enough already. We'll be back here tomorrow, but since we've decided that we can put this on 1.5 speed and it's only going until 2:30 tomorrow, I say we come here at like 10 at the earliest. Okay, I'll put it up later. But thank you to the moderators, tip your servers. I'll be here all week. Well, tomorrow is Friday, so at least for one more day. Stay cool, stay kind, stay classy. Please share the stream out. Please smash the like button. Please do all the things that YouTube likes so that this stream will get into the algorithm for people who know nothing about it. Because in my opinion, this is a case that people really, 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 really need to know about. Because for all of the reasons that we usually talk about. All right, guys. I love you with all my heart. Thank you for hanging in with me today. It's been 8 hours of joy. Peace. Probably around 10. No earlier than 10. Just set your alarms. I'll see you in the morning because we can fast forward. Good night.